Everyone, I declare open the public hearing of the Joint Select Committee on National Anti-Corruption Commission legislation for the inquiry into the provisions of the National Anti-Corruption Commission Bill 2022 and the National Anti-Corruption Commission Consequential and Transitional Provisions Bill 2022. These are public proceedings, although the committee may agree to a request to have evidence heard in camera or may determine that certain evidence should be heard in private session. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by a contempt of Parliament. It's also a contempt to give false or misleading evidence to a committee. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in private session. Such a request may, of course, also be made at any other time. For Commonwealth or state officers, I particularly draw the attention of officers to an order of the Senate of the 13th of May 2009, specifying the process by which a claim of public interest immunity should be raised. Copies are available from the Secretariat. The Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. A witness called to answer a question for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly and into the microphones to assist Hansard to record proceedings. Mobile phones should be switched off. In accordance with the committee's resolution of the 4th of October 2022, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will be published on the Parliament's website. Those present here today are advised that filming and recording are permitted during the hearing. I also remind members of the media who may be present or listening on the web of the need to fairly and accurately report the proceedings of the committee. In addition, a recording by members of the media must not occur from behind the committee or between the committee and the witnesses, and computer screens and documents belonging to senators or members must not be filmed, photographed or reported. Witnesses are reminded that they can object to being recorded at any time. The committee thanks the media in advance for maintaining a COVID-safe approach while in the hearing room. So I now welcome the representatives of the Attorney General's Department to give evidence today, and for the Hansard record, would you please state your name and capacity in which you appear before the committee?
Sarah Chidgey, Deputy Secretary, National Security and Criminal Justice Group, Attorney General's Department, and formerly Head of the National Anti-Corruption Commission Task Force.
Lucinda Atkinson, Assistant Secretary, Fraud Prevention and Anti-Corruption Branch, and also from the National Anti-Corruption Commission Task Force.
And Tara Inverarity, First Assistant Secretary, International and Security Cooperation Division, and also previously in the National Anti-Corruption Commission Task Force.
So can I, although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you, Chair. The Attorney General's Department welcomes the opportunity to appear before the committee as part of its inquiry into the National Anti-Corruption Commission bills. Those bills will establish the National Anti-Corruption Commission as an independent agency with a focus on detecting and investigating serious or systemic corruption affecting the Commonwealth public sector and undertaking a range of prevention, education and information sharing activities to harden the Commonwealth public sector against corruption. The design of the Commission has been informed by consultation with leading integrity experts and has drawn on lessons from state and territory anti-corruption commissions and the Australian Commission for Law Enforcement Integrity. The bills implement the government's publicly announced design principles for the Commission, and in accordance with those principles, the Commission will have broad powers to investigate Commonwealth ministers, parliamentarians and their staff, statutory office holders, employees and contractors of all government entities and contracted service providers. It will carry out its functions independent of government, with discretion to commence investigations on its own initiative or in response to referrals from anyone, including whistleblowers, members of the public and anonymous referrals. The Commission will have the power to investigate both criminal and non-criminal corrupt conduct, where it could be serious or systemic, including conduct that occurred before the establishment of the Commission. It will have the power to hold public hearings where it is in the public interest and exceptional circumstances justify doing so, and the Commission will be subject to effective oversight, including by a parliamentary joint committee and an inspector. Subject to the passage of the legislation, the Department and the Australian Commission for Law Enforcement Integrity are working to enable the Commission and Inspector to commence operations in mid to late 2023. One of the important steps to facilitate this will be the appointment of the Commissioner, Deputy Commissioners, CEO and Inspector, and the intention is that nominees would be selected through publicly advertised merits-based processes in accordance with the Merit and Transparency Guidelines. The bills provide that the appointments of those statutory office holders require approval by the Parliamentary Joint Committee to ensure appointees have parliamentary support. And in addition, the Department and ACLI are also working closely to support the establishment of the Commission and Inspector, ensure ACLI's functions and resources transition smoothly to the Commission, and to assist the Commonwealth public sector to prepare for the Commission's commencement ahead of the Commission commencing. Thank you again for the opportunity to appear. We're happy to answer any questions.
Thank you. I will now ask Dr Haynes to commence commission.
Thank you very much, Chair, and thank you to members of the Department for coming to speak with us today. My first question relates to the definition of corruption, Clause 8. Why was the decision made to leave out conduct by a non-government actor that sought to corrupt a government process, for example, a procurement process, from the definition of corruption?
That is covered by the definition. The definition in 8.1a covers the conduct of any person that adversely affects or could adversely affect the honest or impartial exercise of any public official's powers, functions or duties. And the definition also encompasses attempts and conspiracies as well. So if there is an attempt to corrupt a process that is covered by the definition doesn't cover criminal activity that, for example, that doesn't involve any corruption or an attempt to corrupt a public official.
So if that is the case, just yesterday we learned of allegations of widespread rorting of Medicare, for example. Under the definition, as I interpret it, and I'm seeking your clarification, in the bill currently, the Commissioner wouldn't be able to start an inquiry into that because the corruption of a specific public official is not involved. Would you agree that that's the case? And if it is, would that be an oversight with this definition?
No, it's not an oversight. So that was quite intentional, that we weren't covering external frauds against the Commonwealth. There are existing well-established arrangements for dealing with external criminal activity that doesn't involve was not intended to involve any corruption of a public official. I think, for example, in the last 3 years, the AFP has undertaken, I think it's almost 300 serious fraud investigations. The Commonwealth Director of Public Prosecutions has prosecuted, I think it's about 1,300 almost, referred by 30 agencies. So the intent with the definition is very much to focus on matters that are about corruption or attempted corruption, and not just criminal activity that could affect public administration but doesn't involve any corruption. And I think there would be a very significant risk were it to be expanded out to a range of other activity that could affect public administration but doesn't involve corruption, that the Commission could be significantly distracted from its core focus on corruption and the purpose for which it's created, which is very much about a corruption of public officials or attempts to corrupt public officials.
Could you explain to me then, given that you're confident that we've got sufficient capacity to investigate such a thing now, who then would be looking at any systemic elements of corruption in such a case?
So if there was corruption involved, so an element of attempt to corrupt an insider and affect a public official's duties in a matter, then that would be this commission when it's created. If there's no corruption or no attempt to corrupt any public official, so it's purely an external criminal activity, for example, a cyber hack on a government system where there's no involvement of any insider or attempt to involve an insider, access to information. There are a whole range of activities that could affect public administration, but that don't involve any corruption or attempted corruption. Those matters as they are now would be dealt with by the AFP and the range of other integrity agencies that exist in the Australian Government's multi-agency integrity framework.
Would you say there was a role for the National Anti-Corruption Commission in, for example, an own motion investigation into the systemic nature of such rorting, for example?
Any rorting that involves corruption, absolutely. That's the purpose of the commission. Fraud, as I've just mentioned, the AFP, I think they're also appearing, conduct a range of task forces into for example, frauds against government programs, and they'd be able to talk in more detail about that, but there are very well-established arrangements to look into, say, if there were serious and organised fraud against the Commonwealth committed by external parties.
I have some concerns that the definition of corruption doesn't include conduct where someone has attempted to corrupt a public official and been unsuccessful, if that conduct was considered unlikely to affect the outcome. What would be the effect of amending section 8.1 to read, or that could or is intended to adversely affect, instead of the current wording?
An inept effort.
Sorry, Dr. Haynes, would you mind repeating that?
Sure. There's concerns that the definition of corruption does not include conduct where someone has attempted to corrupt a public official and been unsuccessful, if that conduct was considered unlikely to affect the outcome. What would be the effect of amending section 8.1 to read, or that could or is intended to adversely affect, instead of the current wording?
It would be possible to add intended. We also think that that subsection 10 of section 8 because it covers attempts, so anyone who acts with that intention and undertakes an overt action, whether or not it may or may not ultimately have that effect on a public official, it would be caught by subsection 10. So we think that is covered.
Okay, thank you. I've got some questions now in relation to the definition of corrupt conduct by a non-public official in relation to government processes that are included under the New South Wales, the ACT and the Northern Territories integrity bodies, with similar clauses in Victoria and Queensland, but they're not included in the National Anti-Corruption Commission legislation. Firstly, if collusive tendering is not investigated by the NAC, which federal body would investigate that?
That is covered by the ACCC's jurisdiction over cartel conduct, and the ACCC can also work with law enforcement agencies, so can work with the AFP. Obviously, if there was a corruption element involved in any collusive tendering, that would then also enable the National Anti-Corruption Commission to investigate. And in all likelihood, I think it may well do so with ACCC, who has particular expertise in collusive tendering and cartel conduct. And that ACCC has had a track record of referrals of briefs of evidence to the CDPP on those matters.
If I just take our mind to fraud, so if fraud in relation to application for licences, permits or other authorities under legislation designed to protect health and safety or the environment or designed to facilitate the management and commercial exploitation of resources is not investigated by the NAC, which federal body would investigate that?
I think, as I mentioned, I think for serious fraud, for any offences on the Commonwealth statute books, the AFP has a significant role, and they've got a dedicated fraud command. And that, say, fraud command over the last 3 years, I think it was the exact number, was 261 investigations into serious and complex frauds. But then the total numbers of fraud against the Commonwealth that the Commonwealth Director of Public Prosecutions has prosecuted over that same period of 3 years was 1,400 fraud matters referred by the AFP and 30 other agencies. So depending on the nature of the offence, if it was a regulatory offence, often you might have a specific regulatory body within the Commonwealth who would deal with it and refer it to the Commonwealth Director of Public Prosecutions for prosecution. For the most serious and complex matters, the AFP would be involved, often working with other agencies.
Okay, so what about defrauding public revenue? It's the same? Is that AFP?
Yes, that's the same. And again, it probably just depends on seriousness and complexity, that there are a range of agencies who do have some investigatory functions.
Just want to make a clarification.
The difficulty with not giving the NAC jurisdiction is the AFP's only really interested in the instant case, the individual prosecution proving that individual fraud. It's not their job to look at an arc of cases or make recommendations back to, say, Medicare to address systemic vulnerabilities, is it?
No, that's incorrect, Senator. So they have a fraud command. We have a fraud prevention centre in the department as well, and we work together with the AFP, taking into account the intelligence and operational work that they do, which can be across a whole cohort of cases, and they often have task forces set up into more systemic issues of fraud, and we will work with them. So the Fraud Prevention Centre in the Attorney General's Department looks at policy design and systemic issues and about how to redesign programs to prevent fraud. And we very much work together with the AFP and the Australian Commission, the Australian Criminal Intelligence Commission, to deal with those issues. So they absolutely are addressed in a systemic way by the existing framework.
Can you point to reports that have come from the AFP that have led to, public reports that have come out and led to that kind of systemic reform? Because from my observation of the AFP, their primary focus is on individual crimes, not the systemic fraud tasks that seem naturally a body of the NAC, the purpose of the NAC.
So
Can you point to those systemic reforms that have come from the AFP reports?
So the Australian Criminal Intelligence Commission produces reporting, often it's classified, for government agencies to use, and we have access to it for the Fraud Prevention Centre. We do a lot of work across agencies. We run an annual fraud forum for government agencies to address those matters, and do produce public materials on program design to address systemic issues. The AFP, obviously the sort of public point for them is when matters that they're dealing with are brought to prosecution, but they work to address the issue systemically. It's not the AFP's roles to produce public reporting. That's the role of other agencies in the system, like the Attorney General's Department, and the Australian Criminal Intelligence Commission produces classified reports.
Thank you. That's where I was going to see who would provide those kind of systemic reports so that we can learn from this. Professor Anne Twomey raises the question of whether the conduct of a parliamentarian when acting as a minister fulfilling executive office is actually included in the definition of corruption. Are you concerned that this is not explicitly included?
So So they're covered in wearing both hats, if you like, ministers and parliamentarians. A public official performing any public role, whether it's in either capacity, is covered by the definition, and the definition of public official and corrupt conduct.
Do you think it could be included so it's absolutely explicit? There's no interpretation required?
We don't think there's any doubt, to be honest, but I mean, there's been no harm in saying something further, but we think it's very clear.
Could I address some questions around public hearings, please? At what point in the drafting was the exceptional circumstances test added to the test for public hearings?
We need to take that on notice.
Could you explain why it was necessary then, in addition to the in the public interest clause?
Yes, so the addition of exceptional circumstances to the threshold for holding a public hearing, I think, was directed at a threshold that met that balance between making corruption issues transparent in appropriate circumstances, but recognising the significant issues that public hearings might create with unfair damage to reputations, potential risk to criminal prosecutions in matters, and that the practice has been that they are, a much smaller subset of hearings that are held. So it was very much recognising that and making sure that there was an appropriate balance and that public hearings, given some of the issues that they give rise to, that the Commissioner had to determine there was an exceptional circumstance that warranted it in a particular case.
And could you then just explain to me if there is a legal basis for the Attorney General who's publicly said that the inclusion of exceptional circumstances is unlikely to lead to court challenges. I'm concerned, as many people are, that particular phrase will create delays in investigations by a court challenge.
We don't think it will add to the risk of court challenge. I think there's always the possibility of an individual seeking judicial review under the Constitution or Judiciary Act that remains irrespective, and so that possibility exists whether that threshold is there or not, and could exist for things like public interest, for example. So our view is that the addition of exceptional circumstances doesn't add materially to the chance of court challenge.
Okay, thank you.
Thanks. Mr Zapier?
Thank you, Madam Chair, and thank you for the evidence thus far. Mr Chidley, you said in your opening statement that this legislation draws on state and territory anti-corruption commissions and the Ackley legislation. Does it draw on any overseas experiences?
We haven't. We've looked more at Australian experience.
Okay. And can you explain to the committee who can refer matters to the Commission under the NAC legislation, and who makes the decision about what will be investigated under this legislation?
So anyone can refer a matter to the Commission. There are mandatory referral requirements for heads of Commonwealth entities, but anyone has the ability to refer a matter to the Commission for consideration, and then it is the Commissioner's decision about whether to undertake an investigation having regard to the thresholds in the legislation.
Okay. In the definition of corruption, it also goes on to say corruption of any kind. Can you explain to me and to the committee what is meant by corruption of any kind? Can you give some examples?
So I think instances of corruption we can think of, the ones that we're aware of, we think are very much covered by the previous limbs of that definition. We included that, I think, because it was in the Law Enforcement Integrity Commission Act, and if there were sort of any unforeseen elements, but it's very much still its scope is very much defined by the ordinary meaning of corruption, and the High Court has had a lot to say about the scope of that in the Cunneen decision. So, in terms of what it would cover, it's very much about exercising powers, duties and functions for an improper purpose, or conduct that involves impropriety by a public official. So it has a set scope of meaning. In terms of instances, we at this point haven't identified anything that limb would capture, that the preceding limbs of the definition would already pick up, but have put it there as a catch-all that already exists in legislation.
And I assume by that the Commissioner would make that final decision about what other corruption might be investigated.
They would, but they could only do that within the legal limits of that term, which are sort of very much within the meaning of what corruption is, and have been clearly articulated by the High Court.
Okay. With respect to hearings, the Commission will be able to hold hearings as part of its investigative functions, and there is a presumption that hearings will be held in private. How does this compare with the state and territory anti-corruption commissions, and which state and territory anti-corruption commissions have a default that hearings will be held in public?
So I will just have to pull up the thresholds. I think the threshold in the National Anti-Corruption Commission bills is closest to Victoria for the IBAC. I can go through each state and territory if you like.
If you can do so briefly, if not, perhaps you can provide that information to the committee.
I mean, happy to provide it on notice, but all of the, the South Australian Commission and the Northern Territory require that all hearings or examinations must be held in private. For the other states and territories, there are a variety of thresholds for public hearings involving public interest. As I mentioned, Victoria has public interest in exceptional circumstances, and different mandatory factors that some of them must consider.
And just out of interest, in relation to public hearings, could public hearings have occurred under the former government's Commonwealth Integrity Commission exposure draft?
No, they couldn't, other than for the law enforcement division.
Thank you. Moving on to warrants. When will the Commission need to access warrants in order to execute powers, and what will be the threshold for accessing a warrant?
I think we'd need to take that on notice to provide detail because it depends on the warrant. Yep. So the Commission will have access without warrant to the premises of Commonwealth entities, excluding parliamentary and some other limited defence premises, for example, but will have the ability to access, say, departmental or agency premises to obtain information, and the ability to issue its own notices to produce. But then the kinds of powers for which warrants will be needed were search warrants, for example, telecommunications interception would be another power for which a warrant would be required. Surveillance devices, but they very much use, in some cases with some slight modification, but we're very much picking up the existing warranted powers and thresholds that apply.
And who will issue those warrants, or who can issue them?
It will be the same issuing officers who issue search warrants, telecommunications interception warrants and surveillance device warrants under those regimes that exist now and that already apply to the Australian Commission for Law Enforcement Integrity. And, for example, in the case of telecommunications interception warrants, apply in the same way for every state and territory anti-corruption commission.
Does that include the Administrative Appeals Tribunal?
It does for Telecommunications Interception and Access Act warrants, and that has been in place since 1997, and again applies for the Australian Commission for Law Enforcement Integrity currently, for every state and territory anti-corruption commission and all other enforcement agencies.
So the AAT, just to get this clear, has been able to do that since 1997.
Yes, that's right.
Thank you.
A subset of members who've got legal qualifications.
Chair, may I just ask a follow-up, please? Is there a process by which they need to record and report on where warrants have been declined?
There is quite an extensive record-keeping process for those warrants, but I'd need to take on notice the details.
And is that, in terms of existing arrangements, would be typically
Yes, we
private?
totally picked up the existing regime, so whatever those record-keeping authorisation arrangements are, the National Anti-Corruption Commission is very much plugging into that existing regime, which has been in place for a very long time.
And would you anticipate this might be something included in the annual report to
There's
make
separate
transparent?
reporting requirements that already apply for annual reporting for telecommunications interception and access warrants. So I think that would be covered there rather than doubling up in this process.
Mr Wallahan?
Just a couple more quick questions.
Yeah, sure, go.
I'll be finished. Does the legislation provide for legal or financial assistance for anyone appearing before the Commission?
Yes, it does.
It does. Under what circumstances?
Slightly different schemes that apply to different individuals. We'll just track that down. We've got I think there's a regulation making power for those in the bill, and we can, did you want to?
Yes, sorry, Tara Inverarity. This clause 280 of the bill allows regulations to be made prescribing arrangements for the Commonwealth to provide financial assistance in respect of a person's representation at a hearing by a legal practitioner, among other things. So those details and the criteria that apply will be a matter to be set out in the regulations.
Thank you. And lastly, are there any time limits on what the Commission can and cannot investigate? In other words, after a period of time that something might have occurred, does that mean that the Commissioner can only go back so far?
No, there's no time frame specified in the legislation. I think I would just say two things about that. One, that it would have to be within the definition of corrupt conduct at the time it occurred. So to the extent it was picking up conduct as corrupt, it would either, if it was criminal, for example, there would have to have been a criminal offence at the time that occurred. For non-criminal conduct, it would have to be in breach of the standards that applied at the time. We would also expect that as more time has elapsed, that it's both, one, more challenging to get evidence, but I think also considering the seriousness threshold that applies for the Commission, the Commissioner would need to consider whether, historic conduct, which had been quite some time ago, actually met that threshold. So I think the further ago conduct's occurred, I think the less likely the Commission would say that it met that threshold and be a priority, but there's no particular time frame.
Thanks, Chair.
Mr Wallahan?
Thank you, Chair. If I could start with, was it Ms Inverarity? You spoke about legal aid just before. Was that?
Inverarity, yes.
It's Inverarity.
Yes,
Sorry
okay.
about that. My name's always gets mispronounced too. I just want to clarify whether, so it is by regulation that legal aid is given. Is that discretionary or mandatory in the bill?
So the bill allows the regulation to prescribe arrangements for the Commonwealth to provide financial assistance. Those arrangements will be set out in the regs. Under the provision, it doesn't require them to be either discretionary or mandatory.
And we can provide some more detail on notice, but it's probably worth mentioning too that there are some existing schemes that apply for categories of public official that are already in place that would cover interactions and participation in hearings of the NAC as well, in addition to the sort of new arrangements that the regulations enable. So it's probably a combination of the two, but there'd be some schemes that already exist under the legal services arrangements for categories of public official, and we can provide more information on that as well.
Do you mind, if the Chair is all right, if we do get just a short briefing note on the schemes, because one of the questions will be for us committee is whether it is discretionary. If the executive chooses not to make, or the minister not to make a regulation, then people may be left in limbo. So we'd like to know if that's something that should be made more express. So if you could outline the regime.
I mean, I can say it is absolutely the government's intention to make those regulations.
Okay, thank you. I'd like to focus the next few questions on Section 8, the definition of corruption, if we could go to that. The first part is Section 8.1a, and I know it's been briefly mentioned before, which says any conduct of any person, whether or not a public official, that adversely affects or that could adversely affect. So I want to focus on that part, the could part. Does that test appear in the LEIC regime?
No, the current Law Enforcement Integrity Commission regime is focused very much on law enforcement agencies, so it includes things like perversion of justice and abuse of office. That formulation doesn't appear there. We've taken that, it's a pretty standard clause from State and Territory Anti-Corruption Commission legislation. What the LEIC Act has in it is the corruption of any other kind. For a public official, so it would cover that to some extent for public officials. But that clause and the formulation we've taken from state and territory models.
Thank you. And if you go to subsection 8.10, it says conduct amounting to conspiracy or attempt. It says conduct comprising conspiracy or an attempt to commit or engage in conduct covered by subsection 1 is itself corrupt conduct. My question is this, what work is the could test doing, if I could refer to that isn't otherwise covered by subsection 8.10?
I think section 10 works in tandem with 8.1a. So it's attempting conduct that could adversely affect. Yes, so I think that they work together to make sure that conduct that's undertaken with that as a possibility or an intention can be captured.
Is that necessary though? But if, say, for instance, the could part wasn't there, wouldn't that effect be there anyway?
No, I think it provides a slightly expanded definition that is more comprehensive in its coverage of corrupt conduct.
Could you perhaps give an example that would be covered by having the could test there that wouldn't be covered if it was removed?
Yeah, we'll take that on notice.
Okay. I'd like to now go to section 8.1e, corruption of any other kind. And you've noted that this is taken from the LEIC regime, is that right?
That's right.
And I think, correct me if I'm wrong, when asked what examples or hypotheticals, you couldn't identify any, is that right?
That's right.
Okay. And you said it was a catch-all.
Yes, that's right.
And if you go to the explanatory memorandum at page 75, 247, you'll see there from 246 onwards, it refers to this limb. And it says in 247, this limb of the definition would provide the Commissioner with the flexibility to address emerging areas of corruption. They may not currently be foreseen and may not fall within any of the other more specific limbs of the definition. Where does that part of the explanatory memorandum come from?
From the department, we wrote the memorandum.
But it wasn't, was it inspired by the LEIC Act or explanatory memorandum?
We obviously have spoken a lot to ACLI about how they use that limb, which in their definition, which they do use in a range of instances. In part, that's because other limbs of their definition are narrower than what is proposed in the National Anti-Corruption Commission Act. But I'd also take you to paragraph 248, and following where we've set out the fact that it would still apply to conduct that constitutes corruption and what that would encompass, which is still a very defined term.
And you say then in, it's 249, where you say it came from the Law Enforcement Integrity Commission Act. But if we were to compare their definition of corruption, which is in their Section 6, that's quite different to Section 8. It's got 3 limbs. Is that right?
Yes, that's right. Abuse of office, perverting the course of justice, and corruption of any other kind.
And the second one of those, perverting the course of justice, doesn't appear in this definition in Section 8.
It would be covered by other limbs, but it's. I think it appears in the LEAC Act because it's sort of very relevant to law enforcement in particular. It would be captured by, we think, the sort of broader set of limbs in this definition.
But leaving the any other kind provision in 61C of the LEIC Act aside, there's 2 limbs left in the LEIC Act. Is that right? So would it be fair to say that the catch-all has more work to do for the LEIC Act than the catch-all would have to do in this bill?
Yes, I'd agree with that.
Just bear with me. I'd like now to go to section 9(1)(c), please. And this is the definition of a corruption issue, and it's got 3 parts: an issue of whether a person A has engaged in corrupt conduct, or B is engaging in corrupt conduct, or C, and that's what I want to focus on, will engage in corrupt conduct. Where did 9(1)(c) come from?
We have also taken that from the LEIC Act.
And when you, if I could refer you again to section 8.10, which is about conspiracy or attempt, what work is 9(1)(c) doing that isn't otherwise covered by the attempt and conspiracy provisions?
Sorry, would you mind repeating that question?
If you look at section 8(1)(10), which is just above on the same page, it says it's about conspiracy or an attempt to commit or engage in conduct covered by section 1. My question is this: what work is 9(1)(c) doing that isn't already covered by subsection 8.10?
I think they're just different things. So a corruption issue, so sections 8 and 9 work together to link through to how the Commission then exercises its powers and functions. So it's very much, it's more a technical operation between the two. They're not expanding out the definition per se. It's just that what the Commission does is deal with corruption issues. And I think the intention of 9 is to make sure it can look into corruption in sort of different temporal aspects.
Yep.
Why will and not may in 9(1)(c)? It's will engage in corrupt conduct rather than may engage in corrupt conduct. May would seem to be a broader term.
It would, but the Commission should be focused on evidence of corrupt conduct. And then
Evidence
there's
of
further
future.
links to that. It's an opinion that it's corrupt conduct that could be serious or systemic. So the Commission's job is, I guess, it then can investigate whether there is corrupt conduct, but it needs to be in fact corruption.
Yeah, I can't quite work out, in terms of we're talking about future crime, the difference between will and may. Perhaps you could provide on notice what was intended to be not included by using will rather than may. You could provide on notice what was intended to be excluded by using will rather than may?
I think it's just that you end up with a much more tenuous link to corrupt conduct if you expand it out. So it's a judgment about how far to reach when exercising significant powers.
Sorry, Kev.
It's all right. If you could just go, and staying on this issue, if you could go to the objects of the Act on section 3, it's page 3. The object of this Act includes the following: A1, detect corrupt conduct, and I want to focus on A2, the timely investigation of corruption issues that could involve corrupt conduct that is serious or systemic. If corruption issues is then by 9(1)(c) involving future conduct, isn't that already covered in the objects where it says could involve corrupt conduct? So is 9(1)(c) necessary?
Yeah, yes, it is necessary because it's the way the Act works to capture how the powers the Commission has will function, which relate to corruption issues.
And I might also add, it doesn't, the term corruption issue flows through to a few different parts in the bill. It's fundamental to how the Commission uses its powers. It's also highly relevant to how the mandatory referral obligations on agency heads operate, such that if an agency head becomes aware of a corruption issue, which might constitute a concern that a staff member in their agency has not yet, but will engage in corrupt conduct, the term corruption issue also enlivens their referral obligations so that matter comes to the Commission's attention.
And I might just add, the importance of 9 is that it's about an issue of whether, so that is where the emphasis is in that clause, that otherwise you end up with a situation where things like the dealing with corruption issues provisions, if you had just corrupt conduct there, you would have had to identify that it was corrupt conduct before you could then investigate whether that was corrupt conduct, if you like. So it would make the Commission's powers non-functional without. So 9 does very important work in making it clear it's about the issue of whether there is what it's doing.
And I'll move on from this issue, but one last clarification. Is it possible that one of the things 10 does, 8(1)(10), where it says conspiracy or an attempt to commit or engage in conduct, is one of the differences maybe intent, that 9(1)(c) doesn't require an intent, but 8(10) does?
I think that there's not a requirement of intent. It's more what the conduct could, the potential result of the conduct. Intent is kind of, I suppose, imported by an attempt, that you have to have some sense of, if a person undertakes an overt act, that the outcome that they intend from that or expect from that will be corrupt, will fall within the definition of corrupt conduct. And then intention might well be imported if you've got specific of criminal offences, etc. as well, that you're looking at.
Those are all my questions, Chair. I just want to thank you. I know you've probably done a lot of work before appearing before this committee, so thank you.
Thanks. Mr Lim?
Good morning. Was there a reason that the National Anti-Corruption Task Force did not look to models operating overseas and only look at the state bodies as the guide for the architecture of this commission?
There are obviously a significant number of state and territory bodies and an existing Commonwealth body, so they're that work within the Australian environment. So we thought that they were most relevant and had an extensive amount of material and experience to work with in the Australian context.
Who made the decision about what will be investigated under the National Anti-Corruption Commission legislation? Who make decision?
The Commissioner will make that decision with regard to the thresholds and legal requirements within the legislation.
Is this the case for everyone included in the Commission's jurisdiction?
Yes, it is. Yeah.
Under the definition, there has been some reporting about a carve-out for unions in Section 12 of the legislation. Is that correct? And will unions be exempted from investigation?
No, they won't be exempted. They would be captured by, for example, the first part of the definition of corrupt conduct. So if any union official tried to adversely affect the honesty or impartiality of a public official's exercise of powers, functions or duties, they would be captured. The reason we have put that clause in Section 12, along with officers in corporations, for example, and those acting in the ACT and Northern Territory governments, for all of those, is to make sure we don't inadvertently capture those categories in this extension of who's a public official, which applies to any individual performing or assisting a Commonwealth agency under a law of the Commonwealth. So the intent of what that provision is generally doing is to make sure that people can't escape the jurisdiction of the Commission through a sort of outsourcing arrangement where someone else is given a function under statute. This makes it clear, though, we're not intending to pick up various categories, including union officials, but also those acting under sort of body corporates, etc., who are sort of undertaking regulated functions that you wouldn't ordinarily consider public functions in any event.
Thank you. Under hearings, in reference to Part 7, Subdivision B, Section 73, 2A, the last word is "and." This section is about the threshold for public hearings. And we have seen the New South Wales Integrity Body hinge public hearings on the terms "in the public interest." Why do we also qualify the need for a public hearing to also require exceptional circumstances in the federal body? And do we expect to see less public hearings than we do in, say, Victoria or South Australia?
The definition, the thresholds that are in Section 73 are fairly similar to the ones that exist for the Victorian IBAC, with both public interest and exceptional circumstances. And the Commissioner will be able to decide whether those circumstances exist. We know that in Victoria, the IBAC has conducted public hearings with those same thresholds, and it was included very much about getting that balance, reflecting that it's a very significant power to hold public hearings. There are risks of reputational harm and risks to prejudice of future criminal trials, so that it's right that it should be a more exceptional power with private hearings as the default. So that was the reason for inclusion.
Thank you. And who could appear at the public hearings?
The Commission could call in any witness to a public hearing.
Last one is, who make the decision on whether or not to hold a public hearing? Is that a commission?
It would be the Commissioner.
Thank you. I have no question. Thanks.
Thanks. Senator Shoebridge.
Thanks, Chair. And thank you all for attending. This is one of those rare occasions where the explanatory memorandum that you've been responsible for drafting is actually longer than the bill. So thank you for that. Could I ask you, first of all, I think, Ms Chidgey, you said in your opening that the intent of the bill was to implement the design principles, the NAC design principles that the government took to the election?
That's right.
Yep. And And where you've deviated from those design principles, is there a coherent explanation that you were given in the drafting about why there would be a deviation from the design principles?
I would say it builds on the design principles, so it implements them, but obviously, as you'd expect, it's a substantial bill,
Yep.
and we have then fleshed out and added considerable detail to those principles.
Well, I mean, I've got a copy of the design principles here, and it's nice and colour-coded, but under public hearing it says the NAC will have the power to hold public hearings where the Commission determines it's in the public interest to do so. Now, that's not what the bill provides. So, can you explain why the department deviated from the design principles in the drafting of the bill?
So I wouldn't describe it as a deviation. We've added to those design principles a further requirement of exceptional circumstances.
But if the Commission determines it's in the public interest to have a hearing, but there aren't exceptional circumstances, the Commission can't have a public hearing under this draft. And you'd agree, wouldn't you, that's a significant deviation from the design principles?
I think it builds on those design principles to add to them, and it was included for the reasons I've outlined previously.
Well, it doesn't build on them, does it? It greatly restricts the instances where the Commission thinks there's a public interest, but because of those additional limitations in the bill, it actually restricts the circumstances which in a public hearing can happen. It's not a building, it's a tearing down and restriction, isn't it?
I wouldn't describe it as such. So it's for the Commission to determine, but can consider the public interest and then also determine whether there are exceptional circumstances having regard to a range of factors.
You said in response to Dr Haynes that you'd provide on notice when those instructions came to put in the additional threshold of exceptional circumstances. You're not in a position now to identify when that happened?
No.
Are you able to explain to the committee where those instructions came from to put that additional restriction on?
The Attorney General had asked us about adding that as part of the threshold.
And the explanation you were given at the time to add that, what was it?
Well, we were sort of asked for advice on that addition, and I'd have to take other details on notice.
And I think you said in response to Dr Haynes that you didn't expect any additional legal challenges or vulnerabilities as a result of that. I assume you've read the submissions that have come in from a raft of quite highly credentialed academics who have a very different view about that.
Yes, I'm aware of that.
How do you explain the department has such a different view to some of the most highly credentialed constitutional law experts who've looked at this? How do you
Chair, it's only fair to note that there are many highly credentialed submissions that say the opposite, and that should be put to the witness as well.
Well, I'm asking about the raft of submissions that provide the opposite conclusion to the evidence you've given about the lack of vulnerability. How do you explain that?
So we think whether or not exceptional circumstances were included, there is a right to seek judicial review of that decision, and that exists in part under the Constitution. We don't think the inclusion of exceptional circumstances materially adds to those rights of judicial review that exist in any event.
It may not add to the right to seek judicial review, but it sure as heck adds to the ability to successfully obtain judicial review. If the person seeking to shut down or delay a hearing can make the argument that there weren't exceptional circumstances, that the right may be the same, but the ability to exercise that right and shut down a hearing is far greater, isn't it?
So the bill limits review of the interlocutory investigation decisions, including on holding hearings, as much as possible, but they would have existed. There are certain review rights that remain, and they would have existed around other elements of that threshold, like public interest, for example. And the Commission has scope to make its own decisions, provided it does so in a reasonable and lawful way. We don't think this would add materially to the risk.
Going to a different point, the criteria for appointment of a commissioner are set out in 241. What was the rationale for not including the additional restrictions you find in, for example, the ACT bill that prohibit a former politician from being a commissioner? Why wasn't that included?
I wouldn't say that there was a decision not to include ACT criteria. There were specific criteria that were included that reflect existing approaches about qualifications, former judge, 5 years legal practice. But then what I would emphasise is the process through which a parliamentary joint committee also has a role in approving nominations for that position.
But there would be nothing to prevent a future government appointing a former Attorney-General, a future Commissioner Brandis or a future Commissioner Porter under this provision, would there? There's no restriction on that.
They'd have to go through that parliamentary committee process.
And it's a government majority committee, isn't it? With the chair has the casting vote and the government has the ability to determine policy on that if it directs, correct?
The chair has the casting vote, but as with most committee processes, obviously there's an opportunity for all members to consider that and make public comment on it as well.
Yeah, so why isn't there a constraint to prevent a future government, or potentially this government, appointing a political appointee, a former politician? Why don't we put that in the design principles to future-proof this bill?
You mean in the bill?
Yes. Why don't we put it in the bill to future-proof it against a future noxious government?
That would be a matter for government as to whether they wanted to rule out politicians. I think it is, there's a question about someone who's ever had a political role, whether they should be entirely excluded, but that would be a matter for government and the parliament to determine. There's quite a robust process to ensure that there is an individual with significant qualifications and probity and appropriateness for the role in the process that is in the bill.
And as I understand your evidence, you didn't consider the ACT restrictions in the drafting of this bill? The ones that clearly prohibit a current or former politician, you didn't consider that in the drafting
We
of the bill?
considered all state and territory legislation. We didn't, but we adopted existing approaches of the qualifications.
Yes, but I ask you then, why did you reject that element in the ACT bill? And you said you didn't. If you considered it,
We
but
didn't make a
include
decision
it,
not to do
understand.
that. Our starting point was what is in the bill, which we thought was appropriate.
Could I ask you about what happens if there's no public hearing? And I think it's probably around about 169 or so. If there's a public hearing, then the inquiry report has to be tabled. Is that right in Parliament?
That's right.
Yep. And that's good, and that's a surety of transparency, isn't it? And that was intended.
I think where an inquiry had already been on the public record, we'd adopted the approach that it would then have to be tabled because it was already a public inquiry.
But if there's no public hearing, it's literally up to the Commissioner whether or not any or all of the report gets published. There's no requirement at all to publish the report, is there?
That's right. I mean, I would say the objects of the Act would be relevant to the Commissioner's consideration, which go to issues like the
but they wouldn't make you
educating and providing information to the public on corruption, but it is a matter for the Commission to determine whether it be in the public interest.
The objects wouldn't in any way read down Section 169 and limit the discretion of the Commission. You're not saying that,
They
are
don't
you?
bind the Commissioner, but the Commissioner needs to have regard to those objects in exercising his or her role.
And remarkably, even if there's a finding of corruption, there's no requirement to publish a report, is there, if there hasn't been a public hearing?
That's right. We would expect if there is a finding of serious or systemic corruption that it would then be in the public interest and the Commissioner would publish.
But if you expect it, why don't we say it? Why would you leave uncertainty about whether a finding of serious or systemic corruption leads to it, at a minimum in those circumstances, the publishing of a report. Why wouldn't we say it in the bill? Why not?
The principle underpinning the bill is that the Commission is an independent agency, and in a range of ways, the Commissioner is then given the ability to make decisions about how to proceed, having regard to the public interest and other factors.
In fact, if there's no public hearing, the only politician who's guaranteed to find out what happened, the only one in the entire Parliament, in fact, the only person outside the NAC, is the Attorney-General. That's right, isn't it? Or potentially another minister, if it affects their agency.
Yes, in theory, but the Commission can make its decisions, and it's an independent statutory office holder, so it's very much that the Commissioner can decide in the public interest to publish a report.
But the way this bill is drafted, there could be millions and millions of dollars spent, months and months or years of NAC Commission time, detailed reports provided, and the only people who know are the government, the Attorney-General and senior ministers. That's a real lack, isn't it, in a national anti-corruption body? That's a real gap, isn't it?
So the annual report, unless there are particular sensitivities, also needs to identify investigations and could be subject then to parliamentary committee oversight and questioning as well. So I think if we ended up in a situation where the Commissioner wasn't publishing reports where that was in the public interest, obviously that would be an issue we'd expect the Parliamentary Joint Committee to take up. But the bill is constructed on the basis that the Commission is an independent authority acting appropriately in the exercise of its powers.
But all that's required in the annual report is to provide a description in terms of identifying investigations.
That's right.
Is a description of the corruption investigations conducted by the Commissioner that the Commissioner considers raise significant issues. That description could be utterly generic.
So my point was rather that it would be identified and the Parliamentary Joint Committee would have the capacity to make inquiries.
This is the one with the government majority and a government chair, that committee.
It's a government chair.
Okay. And if the attorney receives a copy of a report that the Commission thinks should not be published, the attorney can use parliamentary privilege to table it in Parliament regardless, without any. There's no statutory considerations or limitations in this bill, is that right?
That's a function of parliamentary privilege, not the result of anything in the legislation. But parliamentary privilege applies and hasn't been abrogated.
But in practice, that's how it works, isn't it? As I described it to you.
It's a function of parliamentary privilege, not of the legislation. So the legislation doesn't enable the attorney to do that. It's parliamentary privilege which exists outside this bill.
Nor does the legislation put any additional consideration or criteria or limitations on what the attorney can do with it.
It couldn't, even if it did, it wouldn't override parliamentary privilege.
Well, unless it expressly
unless
said.
it expressly abrogated it in that instance.
Well, given
which we need to kind of look into the legalities of that.
Just quickly on funding. Under this model, if the NAC runs out of funds in the course of an investigation during a financial year, and let's say they're investigating multiple corruption issues in relation to the government of the day, who do they go to get additional funds?
Additional funding arrangements will go through usual budget processes.
So they go to the government, the Attorney-General, the Treasury. That's
and
who they go.
appropriations through the Parliament.
Yep. Do you see the potential conflict?
I'd say the only sort of alternative avenue that sometimes occurs is we occasionally as a department have provided some additional funding to portfolio agencies to assist with some inquiries they're running. That would be a sort of targeted arrangement that may be possible as well. And as you're aware, obviously the Parliamentary Joint Committee can inquire into sufficiency of budget also.
But do you see the conflict of interest there? If the NAC's got the need for additional resources to undertake one or more resource-intensive corruption investigations of the government, if they have to go to that same government, cap in hand, to ask for funds, you're building a conflict of interest into the heart of this bill, aren't you?
So I'd say that agencies are funded in general for their workload, usually, but also, as you would expect, given we've got a democratically elected government in Parliament, and appropriations are dealt with and put forward by the government on that basis for all Commonwealth entities. The same process would be followed in this instance, and the same arrangements apply to all Commonwealth integrity agencies, irrespective of the nature of inquiries that they're undertaking.
You must have been aware of how that's been used to starve state-based anti-corruption commissions. For example, it's quite notorious in New South Wales with the ICAC. The government doesn't give the funds. The New South Wales ICAC needs to do its work. You would be aware of that problem, but you didn't design it out.
I'm not aware of that.
Okay.
I clearly am aware that the ICAC has continued to undertake investigations into
Right.
government officials.
Is there a reason you didn't put in place in the bill the arrangements that apply, for example, in New Zealand, where the budget is run through a non-government dominated committee, where the budget process happens through that committee and is then recommended through Treasury? Is there a reason that wasn't provided in this bill?
Well, firstly, New Zealand doesn't have an anti-corruption commission, so it doesn't have an equivalent, and the closest arrangement they've got, I think, on their serious fraud would go through their usual budget processes in New Zealand.
Right. Well, for their audit committee, their parliamentary integrity committee, which deals with integrity agencies in New Zealand, they have that proactive role for the committee, don't they? Why was that not applied for this bill?
I suppose there is no equivalent to this body in New Zealand at all, and government of the day that's elected obviously has the scope to put forward appropriations and make budget decisions across government and allocation of public resources.
Well, closer to home, the ACT model, it has a non-government chair that considers the budget bids from its integrity committee. That's a very close model. Why wasn't that considered?
I think that's quite close to what we've got in the bill, where there's a parliamentary joint committee that can inquire into the sufficiency of budget and make comments on that.
I had one other point, Chair, but I can... Yep. In terms of the definition of corruption, if a third party made a generous gift to a political party with the intent of that gift getting them additional access or perhaps having their interests heard ahead of the public interest, would that meet the definition of corruption?
Sorry, can you just repeat that?
But if a corporation made a large gift to a political party with the intent that that would gain favour by the government of the day and perhaps have their interests advanced ahead of the public interest, would that meet the definition of corruption?
So firstly, it'll be a matter for the Commission to determine particular scenarios based on all the facts that they have at their disposal at the time. And I think I would just take you back to the definition of corruption, that it would have to be the conduct of a third party that adversely affects or could adversely affect the honest or impartial exercise of a public official's powers.
So a very large donation with the intent that that corporate's interests would be advanced ahead of the public interest, would that meet the definition of corruption?
I would just repeat my previous answer on that.
But I don't understand whether or not you think that would or would not meet the definition of corruption.
Saying that it would be a matter for the Commission, not for me, to decide what the Commission will investigate. It would depend on all the facts, and the relevant part of that definition is whether its conduct that could adversely affect the honest or impartial exercise of a public official's powers.
But I'm not asking you to guess the Commission's view. I'm asking for your considered opinion on the drafting of this bill, whether or not that scenario would fit within the definition of corruption. And it
And I
seems to
have
me...
nothing to add to my previous answer.
Thanks. Senator Scarr?
Thank you, Chair. And thank you, Ms Chidgey and everyone for joining us today. And if I can give my compliments to the draftsperson of the explanatory memorandum, it's a magnum opus or something, they said,
Thank you,
War and
Senator.
Peace. So congratulations
yes.
to all concerned.
Well, I must give credit to Office Parliamentary Counsel, who did an extraordinary
that's
job.
very gracious of you, Ms Chidgey. I'd like to ask some questions in relation to the inspector. And that's something we haven't canvassed this morning, and I think it's an extraordinarily important check and balance. And in particular, I'm going to make reference to the submission from Mr Bruce McClintock SC in this regard. And I note, just for Hansard, that Transparency International strongly recommended that we consider Mr McClintock's submission, and I actually read that reference after I read Mr McClintock's submission. I couldn't agree more with them. Do you agree, and I'll go to paragraph 7 of Mr McClintock's submission, quote, "It is critical that such an agency," talking about the National Anti-Corruption Commission, "be made accountable for its actions and subject to adequate oversight. There are 3 available oversight mechanisms: the courts, the Parliamentary Joint Committee on the NACC created by Division 1 of Part 10 of the bill, and the Office of the Inspector. Of these 3, the most important and the most effective is or should be the inspector. This is because that office will have the day-to-day oversight of the NACC. In contrast, the courts can only intervene on a case-by-case basis, and in relation to matters such as an error of law, not of fact, denial of procedural fairness, etc. The powers of the Parliamentary Committee are appropriately more general and higher level than those of the inspector." End quote. Do you agree with that proposition, Ms Chidgey, that the inspector really does have a key role, and because of their day-to-day oversight function, to some extent they're the agency or the power, if you like, that can deal with issues most effectively and most quickly?
I think it's definitely the case that the inspector plays a key role and is part of a set of oversight arrangements for the Commission.
Okay. Mr McClintock then raises a number of issues which, in his experience as the New South Wales ICAC inspector, the Northern Territory ICAC inspector, and the New South Wales LECC inspector, he notes the probable performance issues are, and this is paragraph 11 of his submission, failure to give adequate reasons for conclusions of misconduct, failure to accord procedural fairness, failure to consider the rights of persons not under investigation and so cause reputational or other harm to them, and investigation failures resulting from incompetence or lack of training on the part of agency staff. End quote. Would you agree, or in terms of the department's analysis, in terms of the role of the inspector, are these the factors which, from your perspective, you think the inspector needs to focus upon?
So I would probably just refer to the legislation which sets out its functions in section 184, which are very much about providing a mechanism should any corruption issues arise within the Commission itself, and then dealing with complaints. So, we had spoken to integrity experts in crafting the inspector's role, and had then made it targeted towards those issues, but we've also had discussions with Mr McClintock as well. So there are different approaches you could take to constructing the inspector's role. Obviously there's the Parliamentary Joint Committee. The Ombudsman has oversight of the exercise of certain powers by the Commission as well, but the inspector plays an important role at looking at issues within the Commission.
All right. Well, unfortunately, did you consult with Mr McClintock?
We spoke to other experts before the bill, and we spoke to Mr McClintock last week.
Well, Mr McClintock's view, and I quote from his submission, is this, which I find deeply concerning. I quote paragraph 12, "There is a serious gap in the draft legislation." And this ties back to his introductory comment at paragraph 2, which is as follows, and I quote, "Unfortunately, Part 10 as presently drafted is defective and not fit for purpose. It addresses a false issue, corrupt conduct within the NACC, and fails to give the inspector the essential powers to ensure that the NACC both complies with the law and behaves fairly," end quote. And then Mr McClintock refers to those issues which in his experience, his real life experience as an inspector, are the issues which have caused him the most concern in discharging his role as an inspector. Failure to give adequate reasons, failure to accord procedural fairness, failure to consider the rights of persons not under investigation, investigation failures resulting from the incompetence or lack of training on the part of agency staff. Does it concern you that someone with Mr McClintock's level of experience has a concern that there's an actual defective, in his words, Part 10 as presently drafted is defective and not fit for purpose?
So I think we would just, I would say that the inspector can look at those issues. It's able to do that under 1841E. It's not limited to just looking at corrupt conduct. It can investigate any complaints made. So it doesn't have a sort of just general free-ranging audit function, but a complaint could be made about any of those issues to the inspector, and he would have the ability to investigate them using the full range of powers.
Okay, so Ms Chidgey, you said the inspector doesn't have a broad-ranging audit function. Mr McClintock in his submission says, in terms of his advice to this committee, his submission, that it should have that sort of audit function. And he actually proposes that the inspector have the following functions, and I quote from his proposed clause: to audit the operations of the NACC for the purpose of monitoring compliance with the laws of the Commonwealth, detecting agency maladministration and officer misconduct. So he's proposing that there actually be particulars inserted in the bill with respect to the sort of complaints the inspector should be considering, and those in particular are agency maladministration and officer misconduct. Do you see the merit in what Mr McClintock's proposing?
So it could look at any of those issues if there is a complaint made.
Ms Chidgey, Mr McClintock also says that the issue with using just the concept of complaint, instead of going down into defining agency maladministration or officer misconduct, is in his real life experience as an inspector, all sorts of complaints are referred to him. So he's getting sexual harassment complaints, he's getting bullying complaints, he's getting all sorts of things which you'd describe as an organisational type complaint, which would go maybe to the Fair Work Commission, the Australian Human Rights Commission. But he says his concern is if you just use that term complaints, you're not specifically addressing the issues in relation to agency maladministration and officer misconduct.
So
are you prepared to admit that there's some basis in terms of his submission, in terms of how the legislation could be improved to cover what he's referring, this experienced inspector is referring as something which is defective and not fit for purpose?
So that would be a matter for government. I mean, we could always add more detail about the types of complaints, but that term does mean it could absolutely encompass any maladministration or misconduct.
Okay, so I think we've dealt with that issue. He did raise a few other issues, technical issues, which I'd just like to ask you, and maybe you can take on notice. That is, firstly, and I quote from paragraph 17 of his submission, "While I note clause 183 of the bill, there should be a provision that provides specifically that the inspector is not subject to the NACC itself. See, for example, section 57B3 of the New South Wales ICAC Act."
We're just finding that relevant provision.
You could take this on notice and just provide a
yeah.
response if you like. These are
Yes.
technical issues. Second, that clause 210.3 should be deleted. Clause 210.3 is the one which says the inspector can only consider serious or systemic corruption within the NACC. So it seeks to replicate what the NACC does for other government agencies. And Mr McClintock says, well, really, the inspector, given his role, you should drop the serious or systemic nature of the conduct. He should just be examining how the NACC is operating more broadly. So if you could take that on notice as well. And the third point he raises is that the inspector should be entitled, and it should specifically state in the Act, that the inspector is entitled to full access to the records of the commission and to take or have copies made of them. So if you could
We've
consider
definitely
that.
got that. That is absolutely covered. It has
Okay.
full access.
Okay.
Yeah.
Just in relation to the inspector more generally, the bill countenances that the inspector could potentially be a part-time role, and I must say that causes me concern because I think the inspector is an absolute crucial check and balance. What was the thinking behind it potentially being a part-time role?
I think in part informed by the experience with ACLI, where there've been kind of specific instances where someone has been brought in to deal with issues, but not expecting that it would need someone to deal with any allegations of corruption or complaints on a full-time basis. That said, I mean, the provision can be for an inspector to work to the number of complaints and the amount of time that they need to deal with the scope of their role.
Do you accept the proposition that if the government were minded to amend the bill, or Parliament amends the bill to include an audit function, as proposed by Mr McClintock, and or to include, as proposed by the Victorian Inspectorate, mandatory reporting, and I refer to their submission, paragraph 6. This submission focuses on a key difference in oversight capacity, namely the requirement for IBAC, that's the Victorian body, to provide notifications to the Victorian Inspectorate when exercising coercive powers, and the value this requirement adds to the Victorian Inspector's oversight functions, end quote. Do you accept the proposition that if the functions of the inspector were expanded to include what I consider to be legitimate functions, including that audit function, plus considering every exercise, or at least being notified of every exercise of coercive powers, that really this position then morphs from part-time to a full-time position?
I mean, obviously, we need to consider that proposal, given the Commission's also subject, for example, to the jurisdiction of the ANAO, the Ombudsman and other existing Commonwealth integrity agencies. But I think there'd still be a question about whether a full-time role was required, were the role to be expanded, and I guess depending on any expansion.
I've got a firm view on that matter, and I think the inspector should be very, very busy from my perspective, and it shouldn't be a part-time role, but that's just my opinion. I want to move on to the issue of legal professional privilege and the privilege against self-incrimination.
Yep, sure.
Sure.
With respect to the auditing functions or the lack thereof, perhaps it's described in the bill. So is it the case then that the inspector can't audit the decisions of the commissioner, such as, for example, where the commissioner may choose to not publish a report even where there's a finding of corruption?
So the inspector has a broad remit to look at complaints about the Commission, so it could include those matters about whether there'd been appropriate decision-making on publication of reports, for example.
But Ms Chidgey, if there's no complaint, there's no audit.
That's right, it's responsive to complaints and
So
allegations.
if someone's in a particularly vulnerable position and they haven't made a complaint, as the bill's currently drafted, the inspector doesn't have proactive powers to actually see what's happening in the Commission.
It is about investigating corruption issues or having a complaint.
So it's
that triggers
reactive.
its Jurisdiction
So it's reactive.
for complaints.
Yeah. Can I ask some questions in relation to the privileges against self-incrimination, the privilege for, in terms of legal professional privilege? Do you accept that both of those privileges are foundation stones of our common law system and our system of democracy and justice?
I think there are differences between the two. Parliamentary privilege is obviously about...
Sorry, not parliamentary privilege. Privilege, sorry if I misspoke. Privilege against self-incrimination and legal professional privilege.
They're significant privileges. There's a range of ways in which they've been modified over time in different circumstances.
Okay, that doesn't sound as, you don't sound as attached to them as I am, but let me put some propositions to you from the Law Council of Australia submission. And these are their recommendations. I'd like to put each to you, and feel free, if you like, to take these on notice. But from my perspective, if the Law Council of Australia makes recommendations with respect to these important matters, they should be considered very carefully by this committee. The first is the privilege against self-incrimination should only be abrogated to the extent that both the direct use and derivative use immunity apply in civil and criminal proceedings. Do you want to take that on notice or give a response?
Happy to say more on notice. What I would say is there are a range of other circumstances in legislation in which the derivative use is expressly permitted. Direct use obviously is important to the preservation.
I recognise it could occur in other places, but just because it occurs in other places doesn't make it right in this place either.
We've picked it up in you considering like circumstances in Commonwealth legislation, and it's a very standard approach that we've adopted.
Yeah, I like to look at something at face value and consider if it's right, as opposed to whether or not perhaps the same mistake's being made elsewhere. But
we do think
can I give you other recommendations quickly?
Can I just add one thing? We do think the ability for derivative use is important to the effective operation of the Commission.
Okay, but if you could take these on notice and having considered the Law Council of Australia submission, because they do refer to the explanatory statement, so I think it's fair you have an opportunity to respond to that. The second one is the abrogation of the privilege against self-incrimination in Clause 113 be conditioned on requiring the NACC to demonstrate that all other less coercive avenues to obtain information have been exhausted prior to compelling a person to give evidence in circumstances where the privilege is abrogated. And the next one is paragraph 1133A, providing for an exception to use immunity for confiscation proceedings be removed. So if you could give a response to that as well in particular. The last one, my last question, and this is a bit of a bugbear of mine, so just bear with me, indulge me if you can. Section, or I ask the committee to indulge me, Clause 168 refers to tabling of inquiry reports in Parliament. And it refers to sitting days. Why are sitting days relevant in terms of the timing for tabling of a report in Parliament? Why isn't actually just the time, whether or not it's 30 days or the next first sitting day after a 30-day period, if it's outside of 30 days? Why is it tied to sitting days?
The sitting days is obviously a very standard approach for tabling requirements, and I think we've adopted one that applies pretty universally in order to allow sort of an appropriate time. We can obviously take that on notice.
So, Ms Chidgey, I hate standard approaches. I think you're getting that feel from me. But my concern with sitting days is I did some analysis on the sitting days in terms of from 1 July. And if you ran from 1 July, so the first, if a report was given to the Minister on 1 July, 15 sitting days, the 15th sitting day would be 23 September, which was the day of the condolence motion for Her Majesty Queen Elizabeth II. If the Minister received the report on 23 September, the next 15th sitting day would be 24 November. So you've got a period in one case of 2 months, 3 weeks, and the other one's 2 months, 1 day. So there's a difference of 3 weeks. Why wouldn't we just put in 30 days or the next following sitting day? Because it doesn't really matter what's happening in Parliament in terms of the Minister tabling the report. To the extent the Minister needs to prepare, that's totally irrelevant. The sitting days are totally irrelevant, aren't they?
I mean, I should say that the Commission itself could publish the report, irrespective of the tabling, but we will take that on notice.
Take that on notice. And I accept. I've seen this formulation in other acts, and that's why I said it's a bit of a bugbear of mine.
I assume the intent is to allow a reasonable amount of time to consider it.
Yes, and obviously, the sitting day formulation is how those arrangements for tabling are generally always constructed in legislation. Clearly, they vary in terms of then calendar days, depending on.
Well, and I don't think that makes sense, but that's my view. But that's a bugbear, as I said. Thank you, Chair.
Ms Lawrence.
Thank you. Just to go to the CEO of the Commission. So, as it stands, the process for the CEO's appointment is quite clear. I'm just interested, though, in the need, if there was circumstances to arise where the CEO needs to be terminated, his position needs to be terminated. At the moment, it's defined under 261, where perhaps there's misbehaviour, incapacity or bankruptcy as a basis for the Governor-General to terminate the appointment of the CEO. But what, in your view, would happen should the Commissioner's relationship with the CEO deteriorate and just be, is broken down irretrievably? What capacity is the Commissioner to make a recommendation to the Minister to then make a recommendation to the Governor-General to terminate the CEO's appointment on that basis? Is there any capacity to do that in the bill?
I mean, the CEO could consider their own position, but the grounds for being terminated without the CEO choosing to resign are as set out in 261. So you need to identify one of those grounds if they were going to be terminated without consent.
Okay, so those grounds then wouldn't extend to the relationship between the Commissioner and the CEO?
They don't as currently expressed, unless that involved an element of, for example, misbehaviour. Yeah.
Sure, no worries, thanks. We talk about the findings of the Commission. Can you please talk us through the findings that the Commission will and won't be able to make under this proposed bill?
Thank you. So they'll be able to make a range of findings, with the exception of any finding of criminal conduct, and obviously expect the findings in particular to deal with whether they have or have not identified corrupt conduct.
So, sorry, I might just add to that. So clause 149 deals with how the Commissioner reports on corruption investigations. In addition to the broad things that the report must set out, there are some additional limbs. So, for example, in clause 3, if the Commissioner forms the opinion that a person whose conduct has been investigated has engaged in corrupt conduct of a serious or systemic nature, then the report must include a statement to that effect. And following on from that, if the Commissioner forms the opinion that a person whose conduct has been investigated has not engaged in corrupt conduct, that must also be stated in the report. And then there's an additional discretion where if a person gives evidence at a hearing and is not the subject of any findings or opinions, the Commissioner may include a statement to that effect if it's appropriate and practicable to do so in order to avoid damage to a person's reputation.
When you were doing the research, did you find any examples where witnesses making statements in a public hearing that where corruption was then, found to have occurred, those statements were then inadmissible in a criminal proceedings, so that ultimately jeopardised an outcome?
So the privilege against self-incrimination means that if an individual's compelled to provide evidence, it can't then be used against them. So that material can then affect criminal prosecutions. And for that reason, in terms of, for example, holding hearings in public or when a hearing would be conducted, the Commissioner it's one of the factors that they would turn their mind to in whether to hold a hearing and particularly whether to make it public.
And the findings are able to be made against anyone, but what if they're not an Australian citizen?
They can be made against someone who's not an Australian citizen. There's just a requirement in the course of investigation in certain circumstances involving those who are not Australian citizens where the conduct's occurred overseas for consultation with the Secretary of the Department of Foreign Affairs and Trade, but there's nothing that prevents the Commission looking at the conduct of those who aren't Australians and making findings.
And I appreciate this is about people, not companies, but where there's a company engaging in a contract with the government, for example, what is the, and say, for example, that company is not domiciled in Australia, what's the reach of the Commission in terms of making its investigations?
So the Commission is able to investigate matters if there was corrupt conduct by a company colluding with public officials, for example, and it was a foreign company. I think there's just the same limitations that apply in any investigation that might need to have an offshore reach, where for the exercise of some powers you might have to seek mutual assistance in criminal matters from a foreign state, and obviously the Commission itself can't execute things like search warrants on premises that are overseas. It would need to go through those avenues of gathering evidence if it's offshore.
And will those instruments be developed outside the bill then?
They'd be the same arrangements that would apply, for example, were the AFP investigating, and it would mean, the Commission would obviously be able to compel, so if there was a government department that was interacting with that company, that government department could be required to obviously hand all of its records to the Commission. It would just be if it needed then access to the company's documents and that company was offshore. You'd need to use the same thresholds that currently apply for mutual assistance in criminal matters and then identify criminal offences and go through that process if there was a need, say, to have a search warrant executed to obtain material on premises that were not in Australia.
Thank you. This is just perhaps a little technical one. In Part 2, under key concepts used in the Act, so the definition of a staff member includes contractors and subcontractors. Appreciate the need for, that reach. Does there need to be any sort of caveat that just makes clear, though, that no definition of a staff member under this Act has effect beyond the purposes of this Act, just so that there's not an interpretation, therefore, that the contractors and whatnot can be, deemed to be staff for purposes of other potential benefits or anything else under the Commonwealth?
So we think it works that way already through the combination of the definition of corrupt conduct and the definition of public official, where it's clear because of that definition also that if it is a contractor, it very much has to be actions that they're taking. If it's capturing a contractor as a public official, it's very much about the actions they're undertaking in that role for the Commonwealth or as a contractor for the Commonwealth. If they're performing other contractual duties entirely unrelated, that's
so
not
this is
captured.
contained only for the purposes of this bill. Thank you. That's all for me.
Thanks. Senator Chandler?
Thank you very much, Chair, and thank you, Ms Chidgey and the Department for appearing today. I just have a couple of questions around the surveillance powers under the Act and potential for foreign interference. I might start with the latter rather than the former. What will the Commission's processes be to identify whether a complaint is or has the potential to have been generated by a foreign entity for the purpose of causing interference in our political system? We know in recent times that there are a lot of extreme lengths that state and non-state actors are going to interfere with our democratic institutions. So what guarantees do we have in place that this won't be the case rather with the NACC?
So we expect the Commission would have relationships and arrangements with other relevant government agencies who support that. I think there's particular arrangements for consultation, for example, with the Director General of Security on matters that might involve security issues, which we can find and point out to you in a minute. we would very much expect that it will work closely with other Commonwealth agencies to assist in identifying that. And then did you want to?
So clause 237 of the bill provides for the Commissioner to consult with the head of the Australian Security Intelligence Organisation if corruption investigations or public inquiries relate in any way to security matters.
Does that include the need to consult if there is a suspicion that a complaint may have been initiated by a foreign entity? Or is it just the content of the investigation that they have to consult with ASIO over?
I think it's drafted fairly broadly, so it just relates in any way to a security matter. So if the Commission suspected that it was made for reasons of political interference, we'd expect there would be that consultation. But it will in any event be working closely with the Inspector General of Intelligence and Security, ASIO and other intelligence agencies in its functions.
Okay, and that's included within the legislation?
The provision for consultation with the Director General of Security is in the legislation at clause
237.
And again, does that consultation occur when the complaint is received or when the complaint is being investigated? Do you see what I'm trying to figure out?
Yeah, certainly.
Where in the process it actually occurs?
It's broadly drafted such that the consultation requirement kicks in when the Commissioner becomes aware that the corruption issue or a public inquiry they're undertaking relates in any way to a security matter.
Okay. Okay. Okay, I think that's all right. The next question I have, in terms of cybersecurity, obviously under the Act, the NACC is going to have the capacity to undertake a lot of surveillance on a lot of individuals who could have access to classified or sensitive material. So what mechanisms are going to be in place, again, both in the legislation and in practice, to ensure that that information that the NACC is gaining through an investigation, surveying through an investigation, isn't going to be thrown to cyber theft or espionage? I know there have been a few thought pieces in the media since the bill was introduced, with various experts raising concerns about this.
So I might say three things. One, in the development of the bill, we worked closely with the national intelligence community and the Inspector General of Intelligence and Security on constructing the bill to ensure the legislation itself had appropriate protections for national security information, and they are set out in Part 11 to ensure that information is appropriately dealt with. So the Commission will have access to that information, but then it will be appropriately secured and not further disclosed, is the sort of basic effect of those provisions. Then in addition to that, the Commission itself will be bound by the mandatory cybersecurity requirements that apply under the Protective Security Policy Framework of the Commonwealth, which includes the mandatory Essential 8 cybersecurity requirements, the secure gateway requirements, and all of the other cybersecurity arrangements that will apply. And we have been working on different tiered systems, obviously very secure systems to enable it to manage a range of information at different classifications as well. And I should say, not just about the systems, but Commonwealth protective security requirements will require it to have all the appropriate security clearances of personnel and physical security arrangements, as well as secure systems.
And I might just add one example from the bill about how this is provided for. So clause 239 particularly when dealing with intelligence information, requires the Commissioner to take reasonable steps to enter into an arrangement with the head of that intelligence agency to make sure that appropriate arrangements are in place for the obtaining, storing, accessing, using or disclosing of that intelligence agency. And then the Commission needs to act in accordance with that arrangement just to ensure that particular sensitivities for that information are proactively dealt with.
So when we say appropriate arrangements, is it envisaged that that would be the identical security requirements around that information were it out in government land where it belongs, as opposed to with the NACC being held as potential evidence in an investigation?
I think it envisages bespoke arrangements that would meet the standards of the intelligence agency for particularly sensitive categories of information that come from the intelligence community. And then more broadly than that, across the board would be the protective security policy requirements that it would have to comply with.
Yeah, so in effect, you are confident that if sensitive or protected or classified information is out in the government under certain protections, when that information comes over to the NACC as evidence in a potential investigation, evidence in an investigation potential outcome of that, that information is being held and maintained as securely as it would have been out in government.
That's right, and there may be instances, we know it occurs in other law enforcement contexts, where arrangements are actually made to access the information that it remains within the intelligence agency, and the investigating agency accesses it there, for example, could be the case for some particularly sensitive categories of information.
Mm-hmm. And just finally on the surveillance powers, what was the basis for the department determining that a member of the AAT would be able to approve a surveillance warrant?
So we have not made any changes to that. We've adopted entirely the existing framework in the Telecommunications Interception and Access Act. The AAT members have been able to issue those warrants if they've got the requisite legal qualifications since 1997, and they do so for all enforcement agencies and all existing anti-corruption commissions.
There's the potential for these surveillance warrants, though, to be issued for the Prime Minister, other senior ministers within government. Is there a specific reason that the department determined the AAT was still appropriate to approve those such warrants rather than a senior judicial officer?
Well, that exists as a possibility right now, in that enforcement agencies can investigate, for example, criminal activity by any individual now. It's a framework that has worked well for almost 30 years, and those members of the AAT have particular qualifications. So it's not an issue that has been raised by us. There are clearly existing state and territory anti-corruption commissions that investigate parliamentarians, politicians currently, and have done so for many years, and who apply for those same warrants from AAT members currently.
Do AAT members have tenure?
That's not an area, I think they, to varying degrees as far as I know, but I'm not an expert on the AAT. I could take that on notice.
If someone from your department could take that on notice, thank you, Ms. Tucci, that might be handy. More senior judicial officers, I assume, would. Would just be a concern if there are individuals granting warrants for surveillance at 1 year, and then the next year no longer necessarily being in that role. We want to make sure that these people who are granting search warrants, particularly over potentially very sensitive.
No one would politicise the AAT, surely.
I might just mention as well that there's a review of electronic surveillance laws underway. So in terms of issuing authorities broadly, that's an issue that will be considered as part of that review. I think it's very much appropriate that this arrangement for the NAC adopts the existing regime as it applies, and the thresholds and arrangements that are actually in the Telecommunications Interception and Access Act. We're making no change to those, and we're following the practice that has been in place for many years.
I'm just sort of trying to determine, I mean, there is, one can assume, a greater likelihood that the NACC is going to come across sensitive information in its investigations by very virtue of what it's meant to be investigating. So how do we ensure that that balance is appropriately struck, that the right person with the right level of authority is granting surveillance warrants when the information that could potentially be gained from that warrant is, like I say, has a very, probable likelihood that it could be very sensitive.
So I don't think the National Anti-Corruption Commission legislation particularly raises that issue. As I've mentioned, for many years, all of the state and territory anti-corruption commissions have been obtaining exactly those warrants, doing the same sensitive kind of investigations, using exactly those same processes. And I'm not aware that anyone has raised any issues.
Okay. I think that covers off on all my questions for today, so thank you very much. Oh, for this witness, I should specify for the chair. Thanks.
Very quickly.
Can I just clarify that there's no limitation on the Commissioner seeking advice from the Commonwealth?
Sorry, can I just add one clarification? I think it's all state and territory with the interception warrants, I think might be an exception for one or two of the commissions, and ACT, possibly ACT and NT, but all of the others have them.
Sorry, if I could just clarify, there's no limitations on the Commissioner seeking advice from, say, the Commonwealth Director of Public Prosecutions before making a decision as to pursue a public versus a private inquiry?
They could consult. Generally, the Commonwealth arrangements are that if an investigating agency, which would include the Commission, is considering the construction of a brief of evidence, that they will work with the Commonwealth Director of Public Prosecutions on that. So I think it would depend what was occurring within the investigation and whether they thought they'd identified potential criminality, but then there are arrangements where that consultation occurs.
Okay, thank you.
Thanks. Mr O'Brien?
Thanks very much, Chair, and thanks to you in the hot seat. Watching you there, I feel for you. It must be a day at work that you really look forward to.
You don't have to answer that.
I'm just going to cover off on a couple of quick points. First one is a jurisdictional one relating to public officials and more specifically staff members. Under Section 12, Division 4, Section 12, meaning of a staff member, Section 5, subsection 5, makes exclusions to that, and some of those are repeated from the Section 8 definition. Obviously, that's very clear on who's excluded there. I'll just draw your attention to the graph on the page 24, where it outlines staff members of Commonwealth Agency, rules for certain statutory office holders and other individuals. Subsection 2, an individual other than an official of a registered industrial organisation who exercises powers or performs functions conferred on the individual by or under a provision of a law of the Commonwealth other than by, and then it gives... Can you just go a bit further into that and explain the element about other than an official of a registered industrial organisation?
So I think I covered this earlier, but for the officials of registered industrial organisations, and the same is for those operating under company laws and ACT and Northern Territory self-government laws, that there's a category which I think and we've allowed a provision to prescribe additional individuals who need to be excluded from this particular aspect of the definition of public official. The intention of including that provision was to make sure where, in a way, say a Commonwealth Act kind of outsources a public function or duty to someone else who's not employed, for example, within a Commonwealth entity, that we're also capturing that. But we've included those set of exclusions, the four of them, as things we're aware of at the moment, where they wouldn't, to just make it clear that they're not intended to be captured because they wouldn't ordinarily be thought of as public functions or duties being performed under a law that are sort of outsourced. They're more things that are regulated because of the nature of that legislation and therefore needed to be excluded so that they're not unintentionally or inadvertently pulled in as a public official where they shouldn't be.
So the definition of, in the Act, a person who holds an office within the meaning of the Fair Work Act in an organisation registered as an association recognised under the Fair Work Registration Organisations Act 99, that would include volunteer positions within associations and unions?
No, we need to look at that and take that on notice. I would say all of those individuals who might be operating under those laws would be captured by the first part of the definition of corrupt conduct. So if they undertake any conduct that could adversely affect the honesty or impartiality of a public official's conduct, they would be captured. What this is doing is just saying they are not themselves captured as a public official. If they're affecting a public official's honesty or impartiality, they absolutely would be. But they're not captured themselves because they're not within the ordinary understanding of that term, performing a sort of public function. The reason for those exclusions is to just make that clear so that we don't go too far in capturing individuals acting under a Commonwealth law to perform functions that are conferred on them, just because of the nature of some of those particular laws, establishing corporations, self-government and registered organisations.
So just to be clear, someone who is captured by that definition, an individual of a registered industrial, who exercises a power, performs a function conferred on the individual. If it is the case that they are both and they're acting corruptly in the performance of their duty as a public official, they come under the jurisdiction of the Act.
So if they're adversely affecting the honesty or impartiality of a public official, they would be captured and within the Commission's jurisdiction.
As a public official.
Yeah.
But if at work, holding both, they were breaching public trust in another way that was associated with their membership of a registered industrial organisation, that wouldn't be captured by the NACC?
Well, if outside that capacity they were doing just different functions separately as some form of public official, they'd then be captured. But as, I am not familiar with the registered organisations legislation, but it obviously regulates the conduct of officials and would capture appropriate conduct in its own right. It's just not corrupt conduct, it's regulated separately.
So just to be clear, someone at work who's a delegate of an industrial organisation or an association, in that capacity is not captured by this bill, but they can hold another role in the same organisation, in the work, in the agency, that will see them as
Well, not necessarily in the
public official.
organisation. I suppose the same goes for someone who's working for a company established by Commonwealth law and undertaking functions that are regulated by Commonwealth law.
Yeah.
This provision also says within that scope, you're not captured as a public official, but were you separately influencing or trying to corrupt a Commonwealth public official, you'd be caught.
So I think maybe a person could fall within multiple parts of the definition, might be one other way to think of it. So you could be a staff member of a Commonwealth agency and a public official in that capacity, if that's the example that you're referring to. So in that situation, you would be a staff member for the purposes of the NAC.
Under just the separate
Just
limit
under
of
your
definition.
under a separate part of the definition whereby you're a staff member of a Commonwealth agency.
Right. So if you're an employee or a staff member within a Commonwealth agency and you're doing something that you shouldn't be doing, but in the capacity as an official of a registered industrial organisation, the NAC doesn't have a jurisdiction.
It just would depend on the facts as to whether that was somehow meaning you were falling under one of the other limbs. I don't think it's not easy to answer that in the abstract.
Right. I've just got, did you have a follow-up question?
If I just jump in there for one follow-up. Just to run that hypothetical a little bit further, on page 24, where it says under 2, an individual other than an official of a registered industrial organisation, now that doesn't distinguish between capacity and position. And I'm going to give a more express example. A staff member of a parliamentarian, that's their full-time job, but they're also a delegate to a union. Does that position give them exemption from the
No,
NAC?
it doesn't. They're covered as a staff member of a parliamentarian, and then in exercising their functions as a staff member of the parliamentarian, if they do anything that falls within the definition of corrupt conduct, it's covered by the NAC's jurisdiction.
But shouldn't that provision there separate capacity and position?
I don't quite understand the question, but it is just entirely separate. So it's a definition with multiple limbs. I think, as my colleague Ms Imber already said, it's possible you could fall under different elements, but if you're a staff member of a parliamentarian, you're clearly covered by that definition. Under a separate element of the definition, this is just about extending it to other individuals performing functions under Commonwealth law.
It has no limitation on any other part of the Act.
No, it doesn't
Just the
restrict
definition.
any other element of the definition.
Thank you. Sorry, Mr. O'Brien.
That's all right. Well, just on another relating to journalists and their exemptions. So under, sorry, just bear with me 1 second. So protections for journalists. Protections for journalists' informants, section 31. Subsection 2, neither the journalist nor the journalist's employer is required to do anything under the Act that would disclose the identity of the informant or enable the identity to be ascertained. That's pretty clear. And then we go down to 4, and it talks about executing powers under a search warrant, not applying to that previous subsection. Is it the case that, say, an investigation under the NAC was exploring or investigating a breach of a non-disclosure notation? Would the National Anti-Corruption Commission be able to make application for a warrant to search those premises of a journalist for that information or for information relating to that offence?
So if there is suspicion of a criminal offence, the thresholds could then go through the thresholds for a search warrant. As the note in that provision mentions, there's specific provisions for a public interest test that would have to be considered by an issuing officer before there could be any issuance of a search warrant in relation to a journalist.
So there's nothing specifically excluding a search on a journalist's premises for information relating to an informant?
Well, if there's suspicion that there's evidence of a criminal offence on a journalist's premises, then that threshold for a search warrant, they'd have to go to an issuing officer. The issuing officer would have to consider that public interest test.
And perhaps I might just set out what the content of that public interest test is for clarity, and it's in clause 124 of the bill. Yeah. It requires the issuing authority to have regard to whether the public interest in issuing the warrant outweighs the public interest in protecting the confidentiality of the identity of the journalist's source and the public interest in facilitating the exchange of information between journalists and members of the public so as to facilitate reporting of matters in the public interest.
Yeah. So basically, if hypothetically they're investigating a potential offence in relation to a breach of a notice, a non-disclosure notation, and the judge sees fit upon application being made, the NAC can go to a journalist's premises and conduct a search in accordance with the Crimes Act, as has been done in the past.
Well, not as in the past, because we've inserted this new public interest test.
No, but I mean the search, the actual mechanics of the search and what happens in the premises. Someone being detained, sat down, for 7 hours they go through a journalist's house. That can still occur, but there needs to be an added test by a judge first.
So, yes,
And the provisions are doing slightly different things. Clause 31 is about protecting the journalists from being required themselves in a coercive hearing or otherwise to do anything that discloses their source. In the context of a search warrant, obviously the journalist themselves is not being required to do anything. It's a different type of investigative power which doesn't require the journalists themselves to provide information. So different arrangements are appropriate in those different contexts.
But I suppose if a search is going on and there's a book with information relating to informants and the journalist has that book in their hand during that search, that journalist can't be required to hand that book over. Whereas if the book was on the table and the journalist didn't have possession of it, that could be seized as evidence. Is that right?
Under a search warrant, the executing officers would be empowered to take that book in your example.
So,
I think, though,
so an executing officer conducting a search of a journalist's house and a journalist has either a laptop in their possession, on their body, with information relating to informants that could relate to a disclosure, which is an offence of potential 5-year imprisonment, an officer could require that journalist to hand those informant's details over if they were on their person.
If it's evidential material of a criminal offence, then a search warrant authorises an executing officer to seize that material.
So the arrangements for execution of search warrants are the same as for all search warrants, but there is a very significant public interest test that a magistrate issuing a search warrant would have to consider and be satisfied of before that could occur.
Right. So the protections come down to simply not being forced to require.
No, that's not right. We've added that significant public interest test to search warrants, and we've also added the protections about disclosure of sources.
And the protections about disclosure of sources apply more broadly. The NAC obviously is not limited to investigating criminal corruption, so the investigative powers in the bills could be used by the NAC in a much broader range of investigations. Search warrants, as Ms Chidgey has stated, are for obtaining evidential material of criminal offences. So the protections in Clause 31 do broader work than just the search warrant provisions, which can only be used in a more limited range of circumstances.
Yeah, so I suppose the reason I'm using the the breach of a non-disclosure notice is because it is a pretty serious breach within the Act, and I don't know what a judge is going to ultimately make the decision in terms of public interest, but I would imagine that'd be up there. And so if somebody who's been required to give information or has been engaged in an investigation then goes to and speaks to a journalist.
So I think it would be a matter for the AFP to, in all likelihood, investigate that offence. And I should say, in fact, this provides extra protections because there's arrangements for non-disclosure notations, for example, for Australian Criminal Intelligence Commission examinations at the moment, where the same issues could arise with a breach of non-disclosure notations. Those kind of criminal offences would be a matter for the AFP. But for search warrants under this Act that the NAC is seeking relating to a journalist, we have added that further protection.
Okay. And just one last query in relation to a range of things, but particularly the non-disclosure provisions, 95, I think it is. I see in some of the other submissions, I think the Law Council makes a recommendation that there should be an exemption provided for the purposes of seeing a registered mental health professional. Is there any reason why that's not in the Act, or can you tell me why it's not in the Act?
So the Commissioner can allow the disclosure of information in an open-ended range of circumstances that could include that.
So how does someone know if they're wanting to see a psychologist or a psychiatrist because they're in great need of it as a result of the hearings? How do they know that that's available to them, and how do they know that they're not going to go to jail for 5 years if they do it?
We would have all of that material included and information given to witnesses, and under 95 subsection 2, the Commissioner can then include that permission in any notation.
So that'll be provided to all witnesses that
Yes,
they can seek
obviously
permission to...
It'll will ultimately be the sort of Commission who finally decides on the materials given to witnesses, but we would envisage, and we're working with the Australian Commission for Law Enforcement Integrity on that range of guidance that would include material that would be provided to witnesses. And I can say that I know that the current head of the Australian Commission for Law Enforcement Integrity, but other Anti-Corruption Commission heads are very much cognisant of that issue of the safety and well-being of witnesses in hearings.
And could that extend to family members?
Yes, the Commissioner has scope to include that as a permission.
Can I ask a follow-up question on that? Because this is an issue of deep concern, right? So someone is subject to an inquiry, they're in psychiatric distress, they need to see a professional. Those professionals are subject to professional obligations and confidentiality. They might need to see one of those professionals as a matter of urgency as opposed to going through a process to get permission from the Commissioner. For the life of me, I can't understand why someone in that sort of distress can't get medical assistance on an urgent basis rather than having to go through this administrative process. What's the mischief that you're trying to prevent in terms of someone going to get professional psychological assistance because they're suffering from a chronic health issue? Why should someone have to get the consent of the Commissioner to get the health assistance they need?
It might depend on how it was crafted and whether it was sort of appropriately specific. I think what I'd say
well,
more
Ms.
generally...
Chidgey, I mean, that's the issue, isn't it? That's the issue. Sorry.
I think it's just worth referring to the reason that the non-disclosure notations exist in the first place, which are themselves to protect confidentiality in the exercise of very significant powers, where if those non-disclosure notations are sort of not applied, it could itself result in harm to safety or reputation of others. So it's about that appropriate balance, about whether there are arrangements where the Commission itself gets to specify a medical practitioner. We could obviously consider opening it up, but then that carries a contrary risk of whether you create latitude where it might itself create a risk of harm.
So I'm charged with attempted murder. I can go and see a psychiatrist without getting permission for a judge. If I'm subject to a corruption commission, why can't I go and see a psychiatrist without getting someone's permission?
You can. The non-disclosure notations apply very specifically to information within a hearing.
Yeah, but if I'm getting medical advice, the person giving me medical advice needs to know what are the circumstances leading to my condition, right? In order to work out, is it reactive depression, endogenous depression? I'm not a medical expert, right? But it seems to me that it's necessary in terms of the person getting the health assistance they need. Do we really need, if it's a medical professional who's subject to obligations of confidentiality, do we really need this bureaucratic process? Or can we put the health of the individual as a primary concern?
I don't think it is bureaucratic. The Commissioner can make all of those things at the same time they're actually doing the notation. So I would expect they would do it right up front, having raised those issues if there was any need for a person to disclose to a medical professional.
But they might not know up front. This might arise on an urgent basis.
Then there'll be arrangements in place for the Commission. We'd have to consider the competing issues if there was a more open-ended ability to depart from a non-disclosure notation.
That's all from me, thanks. Thank you.
I think Senator Shoebridge has another
Thanks,
new
Chair.
question. One.
I heard that. I'm concerned about limiting the jurisdiction of the Commission, and particularly here at Section 8, subsection 2, which expressly excludes the Governor-General and or the Deputy Governor-General. Why wouldn't you want the NAC to be able to investigate, say, for example, if the Governor-General was privately lobbying the Prime Minister for the benefit of an organisation associated with the Governor-General? Why wouldn't you want that to be able to be investigated by the NAC?
Yeah. It does cover the Office of the Governor-General. I think that exclusion is just because of the special status. We could take that on notice, but yes, there's just the special status of the Governor-General was a reason for excluding the Governor-General and Deputy.
But if that special status is being abused to benefit a third party without due process, surely that special status shouldn't protect anybody, including the Governor-General, should it?
We'll take that on notice.
No.
Thanks. I have a question. And I've been thinking about your answer in relation to the inspector. And in Victoria, the inspectorate is empowered to report on improving the capacity of IBAC in the performance of their duties and the exercise of their powers. In the last couple of weeks, they've published a report about, and they've got a wider jurisdiction, so they can report on. So the IBAC also has a role in relation to police complaints. Okay, so the inspector there wrote a report last week, highly critical of IBAC about the way in which, under that jurisdiction, their powers were exercised, and I guess you could describe it as maladministration. When I read and so I don't expect an answer now, but could you look at that report and see if, in the circumstances of that report, advise us, if in the circumstances of that report, whether the inspector or any other body could investigate the complaint that was made. So uniquely in that case, the complainant made a complaint actually to IBAC, and IBAC had to refer it to the inspector. But it probably does fall into maladministration. And secondly, in their submission, the Ombudsman suggests that they can look at NAC and review the administrative issues in NAC. So, and it's not clear what administrative issues mean. And could you look at with the issues raised by Mr. McClintock about administration, whether that would fall in their jurisdiction, and similarly whether this case that I'm talking about, I think it's called Re-Emma's complaint, something like that, but it was literally in the last couple of weeks.
Thanks.
If you could look at those, I'm not asking for an answer now, but I'm interested, again, the Ombudsman submission suggests they can look at administration.
Yes.
Does administration embody maladministration, or is it more bland than that?
It would, but we'll have a look at that.
Yeah, if you look at this particular case, again, I know it's not the same jurisdiction, but it's the circumstances of the complaint, and it is, it's interesting reading.
Thanks. We'll come back on that.
And that be my last question. And so I can say to you, thank you for your attendance here today. It's been, quite arduous, I'm sure, but we appreciate immensely your responses, and note that you have said that you will provide some additional information, which would ask that you forward to us, to the Secretary within 5 days from today. I think we're seeing you before that, actually, aren't we? So, but if you are able to expand on that perhaps on Friday, that would be helpful too. You'll be sent a copy of the transcript of your evidence, and we'll have an opportunity to request corrections to transcript or errors. Okay, so I am going to suspend proceedings now until let's say 11:47. Is that 15 minutes? The representatives of the Australian Federal Police. For the Hansard record, would you please state your full name and capacity in which you appear before the committee?
Thank you. Deputy Commissioner Investigations Ian McCartney.
Commander Professional Standards, Commander Jason Kennedy.
And Commander Christopher Woods, Commander Economic, Corporate Crime and Corruption.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you, Chair, and thank you for the opportunity to appear today in relation to this bill. Corruption detracts from government priorities, undermines democracy and impacts the broader Australian community. The AFP very much supports the establishment of a National Anti-Corruption Commission to investigate and report on serious and systemic corruption in the Commonwealth public sector. In the AFP's view, a dedicated agency focused on corruption will bolster efforts to prevent, detect and investigate this conduct. The AFP was consulted on the draft legislation and contributed advice to the Attorney-General's Department through an operational lens. To date, the AFP has had primary law enforcement responsibility for investigating serious or complex corruption against the Commonwealth. In the AFP's experience, investigations into criminal corruption offences are generally complex, protracted, and require specialised skills and significant resources. Once established, the AFP will provide expertise and capabilities in support of the Commission's investigations where needed. We expect that the new Commission will strengthen and complement the work of the AFP in combating corruption across the Commonwealth. The bill does not remove the AFP's jurisdiction to investigate Commonwealth offences relating to corruption. In the AFP's view, this is appropriate. From our operational experience, we know corrupt behaviour is often linked or integral to other serious forms of criminality. For example, espionage and foreign interference, foreign bribery, secrecy offences and transnational organised crime. The AFP will continue to respond to serious, complex and organised crime offences such as these. We'll work closely with the new Commission in its early days to establish practical arrangements to clarify and formalise how the AFP and the Commission will work together to refer matters between agencies, to deconflict and to avoid duplication of effort. We also recommend the proposed oversight the Commission will have of Commonwealth law enforcement agencies, including the AFP. Since its establishment in 2006, the Australian Commission for Law Enforcement Integrity, or ACLI, has played an integral role in detecting, investigating and preventing corrupt conduct in the AFP and other Commonwealth law enforcement agencies. We're keen to ensure the collaborative and robust working relationship we currently have with ACLI continues under the proposed new Commission. If it would assist the committee, the AFP is well placed to advise the committee on the operationalisation of the legislation as drafted, including operational matters necessarily arising from the scope of the bills, that particularly how the AFP will support the establishment and ongoing operations of the new Commission, and our continuing role in the investigation of corruption offences and other crimes that may intersect, including fraud and foreign interference. Chair, thank you again for the opportunity to appear here today, and we're happy to answer any questions.
Thank you. Mr. Wyatt?
Thank you, Chair. Thank you, Commissioner McCartney and Commander Kennedy and Commander Woods for appearing today. Your current, leaving this bill aside, your current staffing levels in this low unemployment era, have you got all your positions filled, or do you have many vacancies?
Well, firstly, Mr. Willan, you'll get me in trouble. I'm acting commissioner, not the commissioner. So, listen, I think it's in terms of filling vacancies at the minute, it's a vexed issue, not just for the AFP, but for all law enforcement. It's also a vexed issue for private sector agencies that we engage with. I think we're not at full level, but we're moving towards that. I think in the next 6 to 12 months.
And I'd now like to turn to staffing, because when you look at the roles and functions that the NAC will do, it seems quite clear when you're looking for staff that your organisation will be one of the first places you would go. Would you agree with that?
Potentially.
And if that's the case, is there a risk that you will lose staff to the NAC?
I think that's a potential risk, but it's also an opportunity for some of our staff if it's on promotion. I think we used to have a saying in law enforcement, there was nothing as X as an X, but we actually support our officers moving to other organisations, learning new experiences, whether through promotion and then the opportunity for them to return to the AFP. I think in terms of selection of staff for the NAC, it just won't be solely focused on the AFP. There's other state and Commonwealth agencies out there that they'll draw those resources from.
And in terms of the work of the NAC, when it comes to security clearances, will those undertaking surveillance work, particularly digital surveillance work, require a different security clearance to those doing other investigative work?
Not necessarily, Mr. Willan.
Would it be fair to say that most of the investigators will require some security clearance?
I think they will all require a security clearance, Mr. Willan.
And what do you think the baseline security clearance will be?
Jason, what's the baseline? It's MPP1. Yep. NV. So MV1 is the baseline security clearance.
How long does it take to get an NV1 at the moment?
I think it's upwards of, I think some people already have them before they join the organisation.
A fresh person?
Listen, I think it's upwards between 3 and 6 months.
And a PV, how long does that take?
That will take a little bit longer.
More than a year?
But it depends on the circumstances, depends on the individual. It can happen quicker than a year, or sometimes it takes longer. But I don't envisage the requirement for any employees within the NAC requiring a PV or a significant number of employees, Mr. Willan.
Okay. If I could go to part 10 of your submission, and then, sorry, not part 10, if I could go to 15, you talk about the Memorandum of Understanding between the AFP and ACLI. Would it be possible for us to have a look at that MOU, if you could produce it?
I haven't got any problems. We'll probably just need to ask the Commissioner from ACLI, but I think it's a fairly straightforward document, so I think we'll seek some advice and come back to you on that.
Thank you.
just with respect to the proposed MOU that may be in place between the Commission and Parliament, what elements do you believe are needed to be able to effectively operationalise the bill functions?
Yeah, I think the bill has three major impacts on the AFP, and firstly, it does reduce some of the work that we undertake in this space. I think between July 2017 and June 22, there was 69 investigations that had a corruption or an information security aspect to them, so there are potentially investigations that we won't do into the future. I think because the bill has a broad definition, as I've outlined in the opening statement, there will be a need for deconfliction in terms of what matters the Commission undertakes, what matters that we undertake, what matters, as we do with ACLI, we may undertake in a joint arrangement, and that would be facilitated through that MOU. And also the third aspect in terms of the impact on the AFP will be that requirement for capability support, whether it's technical capability, digital forensics, or potentially cybercrime investigation support to the NAC. So I think in relation to the last two, those two components would be included in the MOU.
If I could go to follow up on that, if you could go to paragraph 23 of your submission. This is about the relationship, and you said your agencies will need to carefully consider how matters are triaged and referred between them. Are you touching there on whether the primacy of the criminal justice system takes over the non-criminal parts?
No.
No. So tell us what you're referring to there.
Well, I'll give you a practical example from an ACLI perspective. So we're investigating a serious organised crime syndicate allegedly involved in importation of drugs into Australia, and we identify a corrupt Commonwealth official. Through the MOU, we will sit down and triage that matter with ACLI to decide who takes responsibility for what aspect of that investigation. So again, I think the lens that I look through, that concept of triage with the new Commission is along those lines, is the who has responsibility for the different aspects of the criminal investigation.
Are there scenarios where you could imagine that it's preferable for a corruption commission to stop what they're doing because it's interfering in your roles and tasks?
Listen, I think our experience with ACLI, we find neither ACLI has to stop or we have to stop. We can actually complement, and again, it gets back to the point that we're engaging, we're deconflicting, we're making sure that the priorities of both investigations complement each other and don't impact on those matters.
On paragraph 24, you support the current section 73, is that right? Which is the public hearing test?
Correct.
And my final question, you note that on 26, there is an MOU, Memorandum of Understanding on the execution of such search warrants in relation to members of Parliament. Could we get a copy of that produced as well, please?
Of course, we've produced it before. I think it's a joint MOU with Parliament, so
yeah.
you should have a copy, but we're more than happy to provide that to
I think
you.
they don't give that to new members like some of this committee, so we are keen to read it. And those are my questions. Thank you.
Thank you.
Mr. Zappia?
Thank you, Chair. Assistant Commissioner, in your submission, the AFP says that you support the establishment of a National Anti-Corruption Commission. Can I ask this question, therefore? What type of corruption investigations can the proposed commission do that the AFP currently cannot?
Well, I think they'll undertake investigations that we're currently undertaking, Mr. Zappia. So it's not as if they can do investigations that we can't do. They'll, in effect, it's a transference of a remit from the AFP to the new commission.
Yeah, so to understand your response, would the AFP be able to carry out the types of investigations that are proposed to be done by the National Anti-Corruption Commission?
Yeah, we could, and we do at present.
You do. And since 2006, when the Australian Commission for Law Enforcement Integrity was established, how would you describe the relationship between the AFP and that commission?
I think it's, from my perspective, it's been productive. I think, and there's really two aspects in terms of our engagement with ACLEI. Firstly is obviously their investigation of potential allegations of corruption of AFP members that, we fully support ACLEI in relation to that work. The other aspect is, as I've a reference in my response to Mr. Willihan, when we're investigating a serious organised crime syndicate or other types of syndicate where we identify corruption as part of that offending, is our engagement with ACLEI in relation to joint arrangements in relation to that. So I think from my personal experience, I know from my colleagues' experience, it's been a productive relationship.
And who within the AFP determines whether a matter will be referred to ACLEI as opposed to being solely investigated by the AFP?
Yeah, so there's two aspects in relation to the scenario of an organised crime matter that would relate to myself in terms of engagement with ACLEI in relation to a potential allegation of corruption in relation to an AFP officer, and I might pass to Commander Kennedy to outline the arrangements in that place.
Thank you. Yeah, so we have our own professional standards command within the AFP, and under Part 5 of the AFP Act, that is what sets up our integrity framework. So the Professional Standards Command only investigates AFP members because that's what our jurisdiction is limited to. If it's another Commonwealth official that falls under the jurisdiction of ACLEI, then that falls within the Crime Command who work alongside ACLEI, or depending on what decision they make, whether ACLEI will make a decision whether they investigate the matter by themselves, whether they do it jointly with the AFP, and if it does involve an AFP member, they can also refer it back to the AFP either with or without oversight.
And lastly, there have been several anti-corruption commission or similar bodies in each of the respective states and the territories. Does the AFP work similarly to ACLEI with any of those bodies?
When at times that they cut across our remit in terms of potentially serious organised crime, we've had engagements previously with predominantly ICAC in New South Wales, where a matter that's in effect cuts across an AFP investigation and cuts across an ICAC investigation. And again, this is after our experience in dealing with agencies of that type have been very productive.
Can I just clarify, does the agency contact the AFP and ask for assistance with the investigation, or is it the other way around?
It depends on the case. It can work both ways. Just depends on the circumstances.
Thank you. Thank you, Chair.
Dr. Haynes?
Yes, thank you very much for your submission and for coming today. I note that you talk about in your submission, point 29, that the AFP will be relied upon heavily to assist the NAC in developing in-house capability. I'm wondering, given that, do you think it's a realistic timeline that the government is setting to stand the NAC up by the middle of next year?
Yeah, what I'd say to that, Dr. Haynes, is there's been ongoing engagement with AGD in terms of the consultation process, including the implementation process, particularly in the first 12 months. And we envisage, in the advice we have from the Attorney General's Department, that first 12 months will in effect be focused on setup, but also triage of new matters that come in. So we're comfortable with those arrangements.
Thank you. And given your point also, 31, about the prioritisation you need to have around allocation of resources, providing policing to other agencies and so on. What is the AFP's capacity to go beyond investigations and to investigate more broadly systemic corruption issues and to report on that and to assist us as a nation systemically around stamping out corruption?
Well, I think we do. Presently investigate systemic fraud and take into account systemic fraud, or work through some of our joint task forces, including Task Force Integrity. A key role in relation to that work is an advisory role and a focus on prevention, providing advice to that agency and other agencies on fraud prevention in relation to the programs that they will introduce. Our work in relation to AGD Counter Fraud Prevention Centre, and I'll get Commander Woods to talk a little bit about that in a minute. And further, whilst at times we may investigate individual cases, if we identify systemic weaknesses in terms of the fraud control guidelines and processes of that agency, we'll engage with that agency and provide that advice. There's an example of that. A number of years ago, there was a significant number of frauds being committed on childcare centres in terms of Commonwealth grants and money being paid to those centres. We provided advice back to the relevant agency in terms of the systemic issues that we were identifying. In terms of reporting, obviously we don't report, but we provide that advice to the ACIC, and they've, through their reporting on strategic intelligence reporting, they've provided that reporting to relevant agencies to understand not just the individual case, but the systemic issues that we're dealing with. And I think at a practical level, in terms of systemic issues and systemic fraud, we don't investigate these matters by ourselves. It's in partnership with the respective agency. So as we're learning, they're learning too in terms of what they're identifying through that investigation. But I might just pass to Commander Wood, just in terms of the work that we do around the Counter Fraud Prevention Centre.
Thank you, sir. I think the point to note here is our engagement with the Counter Fraud Prevention Centre, housed within the Attorney General's Department Fraud Prevention and Anti-Corruption Branch. This is a centre that's been up and running for some time now, a number of years, focused on the prevention messaging, resources and support to the wider Commonwealth Government. Part of our engagement in that environment is introducing lessons learned and outcomes of our investigations, akin to reporting, but not publicly, over to this centre, where there's a standing committee of senior officials, the Counter Fraud Reference Group, which I co-chair with an Assistant Secretary from the department. And then that group reports into a First Assistant Secretary or Assistant Commissioner level, Band 2, Commonwealth Senior Officers Fraud Forum, again for the sharing and ventilating of lessons learned and opportunities for strengthening vulnerabilities that are identified, from a mindset that we don't really want to keep applying resources to the same instances recurring. And so really working with departments, agencies, Commonwealth entities and the department to actually take tangible action to strengthen those vulnerabilities. And I think that's the best way to characterise how we engage through the department with their remit on the prevention front, distinct from our investigative work we do ourselves.
Do you think there's an opportunity to build on that through the National Anti-Corruption Commission? Is there space there that we could engage in, use this commission for a pro-integrity framework, let's say?
Without a doubt, and we can, in terms of the work that we do and the work the Commission, I think it can complement each other, Dr. Haynes.
Okay, and could I ask you then, do you feel that you have adequate resources within your current remit to undertake this systemic work?
I think if you ask any acting commissioner, he's going to say you'll never have enough resources.
Okay.
But I think in terms of our prioritisation model and the work that we do, and again, I think this is a team sport. And we work, all of the fraud work that we undertake within the AFP is it's a joint approach with those Commonwealth agencies, with the ACIC, and again, I think with the Commission, we see that as another important partner in the work that we do in this space.
Would there be any recommendations that you would have specifically around this structural issue with corruption that we could improve this bill, that relationship, or that there may be something in the MOU, or is there anything that you could say about that?
Yeah, we're having been involved and having been consulted on the legislation, we're satisfied with the legislation. I think the work for us will be in the MOU that we craft with with the Commission and just ensuring those issues, and that focus is covered off on Dr. Haynes.
Okay, thank you very much.
Thank you.
Thank you. Senator Shoebridge.
Oh, thanks, Chair, and thanks for your submission coming today. It'll be an interesting relationship you have with the NAC, won't it? Because unlike the Law Enforcement Integrity Committee, you'll be both working with the NAC and the subject of investigation by the NAC. And that'll be quite different, won't it? Unlike ACLI.
Well, we do that at the minute with ACLI. We have joint investigations with ACLI in relation to organised crime matters. So again, the scenario where a sophisticated organised crime syndicate are importing drugs or allegedly importing drugs into the country, and they're utilising a corrupt Commonwealth official. There's been circumstances where we've formed joint investigations with ACLI in relation to those matters, Mr. Shoebridge. Senator Shoebridge, sorry.
Yeah, and how do you deal with the clear separation between your organisation's functions and ACLI at the moment? How do you draw those lines to ensure that you protect the independence of ACLI?
Well, so I think we do that through our structure. So I'm the Deputy Commissioner of Investigation. So if it's a focus on organised crime, that comes to me. If it's a focus on corruption involving our own members, that's a separate Deputy Commissioner that deals with ACLI and those issues, Senator Shoebridge.
The law as it currently applies, I think, provides that if you're undertaking a corruption issue and you refer it off to ACLI, you have to stop the investigation. That's, I think, Section 20 of the current Act.
Yeah, there it does talk about significant and non-significant corruption. So based on the definition of significant, non-significant, which is actually within an agreement that the AFP has with ACLI, if it is significant corruption, essentially, yes, our Professional Standards Command must report it to ACLI, and we can't undertake any inquiries. The only inquiries we can undertake is to gather evidence which may not be present if we were to delay the collection of it, but it's really just to hold that evidence for ACLI until they make a decision. If it's non-significant corruption, again under that agreement, we are allowed to investigate, but we do report it to ACLI because we have mandatory reporting requirements.
Yeah, there may well be a separate agreement, but it's a statutory obligation on you under Section 20 of the Law Enforcement Integrity Commissioner Act to stop the investigation once you refer a significant corruption issue.
That's right,
the current
significant
law.
corruption, yes.
Is that repeated in the current NAC bill?
That I don't know.
I'm not sure, Senator. I mean,
So how do you envisage that operating under the NAC bill? If you're not aware of whether there's a statutory prohibition on you continuing,
again,
how do you? Let me finish. How do you envisage that working if you've got an internal investigation? How do you envisage that about a corruption issue? You refer it to NAC. How do you expect that to work under the current bill?
Getting back to your question, so I'm not sure the specifics of the legislation, but as it's been advised to us, is in effect ACLI is consumed, becomes a component of the NAC, and our arrangements continue as they have before.
Well, will ACLI in their submission point out this difference?
Okay.
That's not found in the NAC bill.
Yep. Well, Senator.
So I'm just wondering how you're envisaging it working.
Yeah. So, Senator, perhaps we'll take that one on notice and come back to you, Senator.
Do you think it's important to have that kind of provision so that you're not having two parallel investigations?
Well, I think it's important there's clarity, but again, in terms of the issue you've raised, just that we're providing sufficient advice to the committee, we'll take that on notice and provide some advice back.
But when you say it's important to have clarity, do you think it would be at all useful to have allow parallel investigations of a corruption issue, one inside the AFP and one inside the NAC?
Yeah,
or do you think the current law should be replicated in the NAC bill?
I think that from our perspective, the current law works well, but I think in relation to the issue you've raised, we'll take that on notice and provide a more fulsome response.
In terms of your lessons learned communications, you provide that to which part of the AG's office, Mr. Woods?
This is to the Counter Fraud Prevention Centre, the Commonwealth Fraud Prevention Centre, sorry.
And that's a subset of the Attorney General's Department, is it?
Yeah, it is. There's a website that
Yep.
they have publicly available outlining their roles and responsibilities.
But you don't publicly report on these lessons learned documents?
That's correct.
Yep. How long are the reports as a general rule? Are they detailed, investigative reports?
I wouldn't characterise investigative reports being disseminated. I'm talking about instances during investigations where vulnerabilities are identified in government payment programs or other services through these meetings, these regular meetings of officials. Actual reporting or intelligence output from the AFP is disseminated to the ACIC, the Criminal Intelligence Commission, for their work around strategic and operational intelligence reporting to the rest of government.
How many, if any, members of the AFP's primary job responsibility is to identify and report on these systemic fraud and other corruption threats to the Commonwealth?
Well, Senator, I think anybody that undertakes a fraud investigation in the AFP, that's a primary responsibility we do, as I've explained. In any investigation we undertake, if we identify systemic weaknesses in fraud controls, we'll provide that to the relevant agency.
But if you've got officers looking at these individual frauds, it's quite different to having a team, particularly a trained and skilled team, to be tasked with linking together, looking at patterns, looking at systemic vulnerabilities. They're quite distinct, wouldn't you agree, Acting Commissioner?
So I think we've got very experienced and trained officers. I think, as I've explained, if we're investigating a single fraud and we identify, obviously, linkages to other cases, that'll get taken into consideration. But if that single fraud is we've identified a systemic weaknesses that other frauds are being committed, we work very proactively with the relevant agency in terms of providing that advice across.
It's not clearly one of your functions under Section 8 of your Act to do this kind of work.
What's a function that we undertake, Senator?
But it's not one of your statutory functions, is it? It's not one of your clear statutory functions under Section 8. Is it something you
Section 8 in
freelance
front
on?
of me, but I can say it's a function. It's an activity we've undertaken for a very long time in the AFP.
And you're not in a position to identify any individual or team whose primary task is to undertake systemic reviews and look across more than one case. It is simply, as I understand your evidence, Acting Commissioner, it's an expectation or a function of officers as they do the individual investigations. Is that right?
There is, but I think there's a small team within.
Yeah, perhaps I can expand and assist, Senator. Within the AFP, we have an Economic, Corporate Crime and Corruption Command, an associated which I lead, sitting within the Crime Command, which is a wider body. And attached to this EC3, as we style it internally, there is an EC3 intelligence team capability, which is dedicated to these matters. But the operating model of the AFP is such that around the country where we have our investigators and our investigative teams, they're prioritised to matters of the day that are assessed against our operational prioritisation model, of which part of that effort is fraud and anti-corruption work. So our EC3 group leads policy and strategy on this front with that intelligence support, looking for those outcomes of investigations and trends and issues in real time, not necessarily at the end of an investigation, and works closely with the rest of the Commonwealth around those kinds of indicators and opportunities for strengthening of systems.
How many full-time staff are there in that Economic Crime Command? Is that the EC3, the Economic Crime Command?
That's right, with the associated intelligence team.
So how many full-time staff are there in that Economic Crime Command?
I'd like to take that one on notice to give you a correct figure.
Right, and if you could identify what their skill set is that enables them to do this task.
Certainly, can do. Thanks.
That's all me.
Thanks. Senator Scarr?
Thank you, Chair. Welcome to the witnesses from the AFP and Acting Commissioner. I think the Commissioner would be pleased with the discharge of his responsibilities here this morning. So I just want to take on the line of questioning Senator Shoebridge referred to in relation to the functions of the AFP, and I just quickly called up Section 8 of the Act, and as I read it, the function of the AFP extends to the provision of police services in relation to laws of the Commonwealth, property of the Commonwealth, the safeguarding of Commonwealth interests, and then it lists another number of other things. And the concept of police services encompasses prevention of crime. So it would seem to me, if you put the very nature of police services together with protecting the interests of the Commonwealth, the property of the Commonwealth and the laws of the Commonwealth, clearly it would extend to dealing with corruption threats involving large government programs where there might be systemic issues that need to be addressed. Would you agree with that analysis?
Very much so, Senator. I think key role for us and for other law enforcement agencies is the focus on prevention, and that's not a position we just have. I think it's a position that Robert Peel mentioned in 1829 in terms of his principles of policing, and that was the first principle, the focus on prevention as a law enforcement agency.
Okay. I want to then move on to another point that Senator Shoebridge raised, which is quite a very legitimate point in terms of the fact that the AFP is in this situation where your members or members of the AFP can be subject to investigation by, at the moment, ACLEI, but you also provide assistance to ACLEI with respect to their investigations. Yep. So I wanted to ask you, from your perspective, and I guess I've had the benefit of being on the ACLEI Joint Parliamentary Standing Committee, as Mr Zapier has, from your perspective, there are plenty of examples of ACLEI working well with the AFP in terms of conducting investigations, whilst at the same time ACLEI might have been conducting investigations into individual members of the AFP with respect to other matters. Is that a fair comment?
That's a fair comment, Senator.
Okay. And then in relation to the arrangements between the AFP and ACLEI that are currently in place, as part of the transition to the NACC, would the AFP be looking to have some sort of engagement with the NACC, considering what's currently in place with ACLEI, to make sure that sort of transitions across to the NACC? Are you actively considering the transition issues that are raised for the AFP in terms of your liaison with the new Anti-Corruption Commission with the broader remit than ACLEI?
Yes, Senator. I think some of the answers I've given this morning in terms of highlighting the productive relationship we have with ACLEI and in terms of our engagement and MOU with ACLEI, in some respects, we potentially, and we would use that as a blueprint in terms of our engagement with the new Commission in terms of how we'd operate.
But you recognise there is going to have to be some transition involved in terms of those arrangements?
Absolutely.
Okay. I want to move on to another subject area. First, I want to ask, how many members does the AFP have? Just broad terms. You'd have to give me a specific number, just very broad.
I think it's 7,400.
Okay. So each and every one of those members will be subject to each and every one of those members today is subject to the jurisdiction of ACLEI. Is that correct?
Correct.
And each and every one of those 7,400 approximately members will be subject to the jurisdiction of the NACC, correct?
Correct.
Right. In previous estimates hearings, I've asked questions of the AFP in relation to workplace health and safety, so the safety of your members. And I know this is something the Commissioner and the leadership of the AFP care about deeply, and a number of positive steps have been taken by the AFP to, in particular, deal with mental health issues within the agency. I'm interested to know, in terms of any learnings or any processes you have in place that specifically might apply when a member is subject to a stressful investigation or inquiry. Allegations have been made against them, perhaps by members of the public, and I've never been in that position, so I can do my best to empathise. But what are the learnings from the AFP's perspective in terms of the support that needs to be given to members in that position?
Senator, I think it's a really good point, and I think, the first point I'd make is, as an organisation, we have zero tolerance in terms of potential issues of corruption within the organisation. But if an officer in the AFP is investigated, we understand it can be a stressful situation, not just for that officer, but for their officers' families, depending whether he or she is still at work or suspended from duties. But I might pass to Commander Kennedy just in terms of some practical processes we put in place.
Thanks, Senator. So we investigate all serious misconduct and corruption within our Professional Standards Command. And under our Category 3, which is serious misconduct, we do have a time limit of 256 days. It does have an impact on the members, and we do, through the AFP's new SHIELD program, which consists of a number of practitioners, including psychologists and the like. But we do ensure that there is welfare support for our members that are under investigation once they're actually made aware of the investigation, because there may be a period that the matter is under investigation, but they may not actually be aware of the investigation at that point whilst we're collecting evidence. But once they are informed, they are provided the opportunity for welfare and the SHIELD program. One of the learnings is also keeping people informed of where matters are up to. So as a rule, our investigators do inform the member or the subject of any complaint monthly of where the actual investigation, the matter is up to. A really important point for us is also providing procedural fairness. So we have a number of procedural fairness places within our system. So when the person is informed of the allegation, they're provided a right of reply, so they're informed of the allegation and they're provided the opportunity to either agree or rebut the allegation. Even at the time that the investigation is finalised, if it's the investigator's recommendation that the matter be established, again they're provided a full copy of the investigation report, and they're provided that opportunity again to provide a right of reply. And if it is a established serious misconduct matter, when that goes to the panel, even when the sanction is decided, again they get a right of reply. So there's actually 3 separate points where the procedural fairness is afforded. But certainly from our point of view is timeliness of investigations, because it does have a ripple effect, not only on the subject, but as the Acting Commissioner mentioned, on their family, but also on the workplace as well. And particularly if members are suspended from the workplace, there's that extra care put into that, because, being suspended from the workplace isn't something that we take lightly, but at times is necessary in order to reduce or mitigate the risk that they present to the workplace.
Okay, so Mr Kennedy, that was a very useful answer, and I've just made some notes as you're providing it, and it seemed to me there were 3 key points. I always try and distill it into 3 points, but there might have been more sub-points. But the first point was timeliness. So it is important for someone who's the subject of an investigation and they're dealing with the stress of that and indeed the impact on the broader organisation of perhaps them being suspended until the investigation's concluded. It is important to do everything reasonably practicable to complete the investigation as timely as possible. Is that correct?
Yes, that's correct. And just noting that some investigations are more complex than others. Some matters can be dealt with reasonably quickly, whereas others, particularly if it is systemic or does involve frauds and the like, they can take longer. So again, we prioritise our investigations. One of the key things for us is really that prevention piece. So we put a lot of emphasis into the lessons that we draw from our investigations, to put that back into the system to actually inform and educate our members on where the potential pitfalls are, because if we can actually have our members comply with the integrity framework, then that's actually a better result than investigating and then ultimately exiting the organisation. So we do draw on those lessons, very similar to our external prevention piece. But again, we also work very closely with ACLI, who actually do have a really good prevention platform as well. But that's really key, is our prevention, proactive engagement, education piece.
Okay, excellent. The second point I noted was the need to keep the people subject of investigations informed in terms of the right result, and presumably in terms of, and again I'm doing my best to empathise here because I'm not in this situation, but I may be, I guess, given the new legislation, but hopefully not. But presumably the unknown, people can populate the unknown in their head in terms of an investigation, and that can have a negative impact in terms of their mental health. So giving them finality in terms of an investigation is important, so they know one way or the other, has this been completed, can I move on, or are they still going to be concerned about it? Is that a fair summary?
Yes, that's correct. So they do get monthly updates just to keep them updated where the investigation's up to, when they can expect the investigation to be concluded. And it's also really an opportunity for the investigator just to touch base with them, just to make sure that they're doing okay, because sometimes they may not necessarily want to engage welfare services at the beginning, but they'll sort of provide that opportunity to guide them into support services if they require, and also extend that to their families as well.
And then the third point was with respect to procedural fairness. You mentioned the need for procedural fairness to be adhered to. I just want to put to you a paragraph from the submission from the Law Council of Australia, because when you mentioned procedural fairness, it reminded me of this paragraph. So, and I'll read it to you. Paragraph 136 from the Law Council of Australia submission, they state, witness access to legal as well as mental health and other support services will also be important to ensure fairness is afforded in practice. End quote. Would you agree with that proposition?
Yes.
Okay. All right. Thank you very much.
Sure.
Thank you. Just picking up on Senator Scarr's last comment, can you just tell us how that support is given to people in your circumstance?
Yes, so there's a number of avenues. So if the subject of the complaint is a member of the Australian Federal Police Association, they're afforded that support from a legal point of view. We also have a new SHIELD program that's been instituted into the AFP, which includes welfare officers, includes psychologists, includes a number of health professionals in order to support our members. And it's also the investigator maintaining regular contact, monthly contact with the subject of the complaint, again just seeing how they're travelling and also giving them the updates in order to try and minimise the impact it is having on the person. Because even where a matter may turn out to be not established, it's bringing them back into the workplace as well, to make sure that potentially our people still continue performing at the level that they are.
And can I check, people being investigated, do they need to seek permission from anyone to get outside assistance, or is it they can just do that straight away?
Yeah, so we do have secrecy provisions under the Australian Federal Police Act. So Section 60A is our secrecy provision. So someone who is subject of an investigation is not allowed to talk about the investigation. They're not allowed to share any information about the investigation unless they get what we call an 18.3 disclosure. And ordinarily, when they seek a disclosure, it would be to obviously get legal advice, to seek counselling. We do have some blanket disclosures where we do allow them to speak to the association and the SHIELD program and the like. If they did want to speak to, say, their family member or friend, we basically, the only reason we do it is to make sure there's no conflicts of interest or the person may not be a witness to the inquiry. And so that disclosure requirement is actually really important, again, to provide that support to the members.
And could I ask, what kind of time frame does it take to seek that permission and be granted that permission?
Oh, very quickly. So if the subject of the complaint speaks to the investigator and seeks that 18.3 disclosure, very quickly we'll provide that because we do know it's important to their welfare.
Okay, thanks very much.
Can I just ask a follow-up question myself? So do you give that support, or that do you, for people who are not AFP members, so people who are you're investigating, you look to charge, do you give them those regular updates about where it's at and how it's going?
Yes, and it's quite interesting. Within the Professional Standards Command, we may be investigating a person for both a criminal matter but also an administrative investigation as well. So we do have that sterile corridor between the two, because anything that we gather in an administrative investigation we can't actually use in a criminal investigation. So we have to be very careful that the sterile corridor. We do quite often run investigations side by side, and again that's to also ensure that there's timeliness rather than doing their criminal investigation first and then looking at the administrative investigation. Because there may be events where we're looking at the criminal because they've committed an offence against the law, but the administrative investigation is looking at a breach of a code of conduct. So, but yeah, it's very important from our point of view is, again, with that sterile corridor, is the support that we provide the member, you know, depending whether they're in a criminal and also administrative and the like. But we do very much, it's very big on us is to provide that procedural fairness piece and really to keep them updated in where investigations are up to and ensure that they do have the proper welfare provisions in place to look after the member and their families, and also the workplace that they're from as well, because it does have an impact there.
Yeah, I appreciate that distinction. I think what I was talking about was your ordinary punter who you're investigating, so not a member, but a person who is outside, who you're investigating, who's in a criminal, who you're investigating charges against. Do you give them regular updates about how it's going?
I think once a person's charged and it's before the court process, Senator, I think through that person's legal representative, they'll get regular updates in terms of where the matter's at.
So before they're charged?
Well, if they're under investigation, normally we don't tell them they're under investigation until we charge them. So I think, but there may be circumstances if they want to reach in and seek advice, we can provide that advice.
Sorry, you get the point I'm making.
So I think if someone's charged, they're before the court. So again, usually they'll seek legal representation once that matter's before the court, and they'll receive regular updates on that issue. So.
Yeah. But while you're investigating them, you may not be in contact with them because it's, one, they might not know, or two, you're still piecing together what's happened.
Correct.
Thank you. Ms Lawrence?
Yeah, thank you very much. If I may start with the issuing of warrants, what judicial officers do the AFP generally seek search warrants from?
Normally, it depends. It really depends on the jurisdiction in which we operate. So, but normally across the country, it's at the magistrate level.
And so, what's your attitude to being able to seek a warrant, as proposed in this bill, from a person who is not legally qualified?
Maybe if you can explain.
So, under the current drafting, for example, a warrant can be sought from the AAT,
Yes.
where members may not be legally qualified.
So I think our experience, I've been in the organisation slightly over 30 years, and I think I think in the scenario you're presenting, you're talking about telephone intercept warrants and surveillance device warrants. I think for over 30 years we've been dealing with experienced people from the AAT in terms of the sign-off of those warrants.
But generally, though, you would expect that the person would be minimum like a magistrate or a minimum legal, like retired judge, or have some legal qualification to execute.
Well, I think that's an issue in terms of AAT members. That's an issue for the government in terms of who's appointed. We in effect apply the legislation, and under the legislation as it currently exists, we can and we have for a long time applied for telephone intercepts and surveillance device warrants from an AAT member. I think the other important part to make, ultimately, whatever we do in relation to these matters, once we bring them before the court, and the court oversights our actions in relation to what's actually occurred.
The bill doesn't make reference to minors and any protections for minors at all, so I'm hopeful that they wouldn't ever be engaged in corrupt activity, but where they may be having material on them that relates to corruption inquiry or investigation, do you feel the bill meets sufficient safeguards for the protection of minors?
I think there's sufficient safeguards in a range of other bills and evidence acts in respective jurisdictions.
So that would refer back to like the Crimes Act, for example?
Absolutely.
Okay. In the UK, warrants for journalistic material is subject to a contested hearing before a judge.
Mm-hmm.
I note that in your submission, I think you made the comment that you were satisfied with the public interest test But do you have any other views on contested hearings on such warrants, or on the issue of who should hear those warrant applications for journalists' material?
Yeah, I think we're talking about journalist information warrants, and that's the obtaining warrants in relation to unauthorised disclosure investigations, where the focus of that warrant is potentially to identify the source of a journalist. I think that issue has been well ventilated through many committees, and there was a PJCIS committee in relation to press freedoms, a number of recommendations that were made around that very issue. I think the decision point on that one, Ms Lawrence, is not with the AFP, it's with the respective departments in terms of what decision they make on that issue. But from our perspective, we're satisfied with the legislation that currently is in place.
Thank you. And in your submission, you described that corrupt behaviour is often linked with or is integral to other forms of criminality, for example, serious fraud against the Commonwealth, organised crime, espionage and foreign interference. So earlier this morning, we heard that the limitations of the reach of the Commission will primarily be to Australian citizens and companies domiciled in Australia, unless there's instruments that enable for bodies like your own to be able to seize material or interview people from around the world. I'm just curious as to, whether there are any or what number approximately of countries you don't have that arrangement of cooperation in place.
We've got, as we speak, we've got 95 liaison officers overseas posted in 32 countries. We've got very good working relationships with all of those. I think every crime that we investigate in the AFP has an international connection. 70% of the organised crime targets that impact on the Australian community are not based here, they're based offshore. So, we place a huge focus in terms of police-to-police cooperation, but obviously through the Attorney General's Department, we require evidence for matters in court through the Mutual Assistance Act. So I think I think it's fair to say those arrangements are mature, robust, and effective, Ms Lawrence.
Thank you. So you don't have any concerns about perhaps some of the reach of the Commission being limited by the jurisdiction?
No, what I'd envisage in terms of the MOU that we'll sit down and craft with the Commission, that the AFP can provide any international support that the Commission requires in terms of inquiries. We can provide that support to the Commission, and more than happy to do that.
And in terms of the Commission's deliberations as to whether to conduct a private or a public hearing, and whether to publish reports or not, do you have a view as to whether you believe the AFP should be consulted in those deliberations?
I think ultimately that's sort of, if it's a matter that intersects with an AFP investigation, I think through the arrangements we should be consulted. I think obviously it's a decision for the Commissioner. It's been a decision for the government in terms of how it's crafted the legislation. Just from a practical perspective, I think it depends what the Commissioner wants. Do they want to shine a light on that activity, or do they want a successful prosecution? Because through our practical experience, if a matter is heard in a public hearing and witnesses are compelled, that evidence is not admissible in relation to an investigation and to prosecution, and potentially information obtained through that public inquiry, they can't use it as part of the investigation. So it's a complex space. So I think, as noted in the legislation and noted in AGD's submission, it will be a balancing act for the Commissioner. And again, if it's a matter that impacts on the AFP, I think it's fair to say that we would be consulted on that issue, Ms Lawrence.
Thank you very much. Thank you, Chair.
Thanks. Mr Lim?
Thank you. Thank you for coming.
Thank you.
Can you please outline for me whether you believe the Commission could be hindered in any way by no longer being a function of AFP? And can you please see it having access to the same significant investigative experience and specialist capability that until this point anti-corruption investigation have benefited from until now?
Thank you. I think in relation to the answers I've given this morning, I don't believe the Commission will hinder our work. I think part of what we see as beneficial, it will actually take over some of the work that we're currently undertaking, and some of that is complex work. I think I think if we utilise ACLI as a blueprint in terms of how we engage with agencies of this type, we see that engagement and productive engagement continuing with the new Commission.
Thank you. My second question is, the AFP will be working closely with NACC in a supporting function in matters where there is a broader criminal nexus and other potential offences intersecting with the corrupt behaviour. Has the AFP considered steps to distance itself whilst still providing support in a scenario in which anti-corruption investigation may have come a crossover within the AFP?
Yeah, and I think with some of the answers I've given this morning, we've many practical examples of AFP investigations that we undertake, and in the course of those investigations we identify a corrupt Commonwealth official. And our practical engagement with ACLI in relation to those cases is one, in terms of that practical engagement, we see that very much continuing with the work of the new Commission.
Thank you. The AFP will continue to have jurisdiction to investigate Commonwealth offences relating to corruption. Is there a hierarchy or MOU that assists to clarify, avoid duplication, or de-conflict of a matter in which both the AFP and the NACC are aware of?
There isn't at present. Once the legislation is passed, I think that'll be the focus of both organisations to craft that joint MOU.
Is it the understanding of AFP that in an instant in which a journalist source has committed an offence to obtain information which a journalist has then reported upon the uncovered corruption, does the journalist source protection take precedence over the offence committed to obtain that information?
I think in relation to journalists and our interaction from the AFP, as I've noted, I think some of those issues have been well ventilated over the last couple of years. I think there's a number of important components at play. Firstly, in 2019, there was a ministerial direction that was given to the AFP subsequent to a number of search warrants that were undertaken in relation to journalists and their properties. And the ministerial direction was quite specific. It formalised public interest considerations specifying the importance of a free press. It directed the AFP to exhaust alternative investigative action prior to considering investigative action involving journalists and news media operations or organisations. It proposed the seeking of voluntary assistance, and it directed AFP to strengthen its guidance and processes re unauthorised disclosure matters, which we subsequently have. We initiated a review by John Lawler in terms of how we undertook these sorts of investigations. So subsequent to that, there's a very set process in place that we review matters and sensitive matters of this type relating to journalists. So I think to satisfy ourselves that we're, I think in your words, finding that balance.
Thanks. Can you please outline the extent to which the task force work with Australian Defence, Intelligence Agency and defence contractors to understand way to mitigate the hindrance of the Commission ability to investigate corruption? Do you feel as though the legislation is given sufficient power to investigate and is unlikely to have hearing hindered by the guise of national security?
Okay, I think I think in terms of, there's a couple of components to your question. I think in terms of what do we think the Commission will have sufficient powers as articulated in the current draft legislation is yes, and we've provided that advice to the Attorney General's Department. In terms of where it intersects, the work of the new Commission intersects with the Defence Force or the intelligence agencies, I think, again, that'll just be part of their normal practical consideration of matters that come before the Commission.
Okay, last question. Can the AFP outline how whistleblower protections in this Act interact with the current Public Disclosure Act?
Yeah, I think in relation to just in relation to, I think this, in terms of the NAC Act, my understanding it expands it. It contains protections for persons providing evidence or information to the Commission in relation to corruption issue. These protections are modelled on those in the PID Act, but will be available for all persons, not just public officials. So there's an extension. But also, I think the Moss review under the PID Act, which was a number of years ago now, I think the work of AGD is reviewing those recommendations to see whether the PID Act needs amended. So I think in terms of how the legislation's been drafted, it very much takes into consideration that issue.
Thank you very much.
Thank you.
Any other? One supplementary, yes. Senator
Thank you.
Schubert.
You're a tough chair. In terms of if you believe you have the AFP has jurisdiction over a matter, and the NAC believes it has jurisdiction over the matter, and it may be clear that in fact the NAC has jurisdiction. Do you believe that the NAC investigation should take priority over the AFP investigation? Or do you think it's just going to be a kind of arm wrestle going forward?
Well, I don't think it'll be an arm wrestle. If it's a corruption matter that relates to an AFP officer, it's pretty straightforward who has primacy. I think in terms of where it's a matter where it's for example, an organised crime investigation, and they identify a corrupt Commonwealth official. From personal experience, Senator, it's never been an arm wrestle. These investigations are very resource intensive, and I think we utilise the example of ACLI actually coming together and complementing each other in terms of powers and resources has been really productive.
Well, I'm just reading paragraph 23 of your submission, and you say, where there are concurrent AFP and NAC investigations, it will be important to establish procedures to ensure agencies can deconflict and preserve the integrity of the respective investigations. What do you mean by deconflict?
Well, I think if for example, if it's an organised crime investigation that involves other corrupt Commonwealth official, we wouldn't want the new Commission to undertake actions or inquiries that might impact on the wider investigation in terms of, I suppose, the example of a timing issue in terms of how people and when people are contacted. So again, how we put that into effect is a joint agreement or a joint arrangement with the Commission.
Well, do you think that would be assisted by any statutory clarity on it? I mean, an obvious point would be if it's an internal investigation about the integrity of one of your officers, a very clear statutory statement that NAC takes priority, you wouldn't have any objection to that?
No objection to that issue.
Although it's not contained in the bill as I understand it.
Well, I think in terms of I think in terms of the work that we've undertaken with ACLI has primacy in terms of investigation of serious corruption on AFP officers. But I take your point, it's not contained in the bill.
Yeah, and that clarity might be useful.
Well, it might be useful, but I mean, I think from a practical perspective that will be the case.
But in terms of where you've got concurrent investigations, there may be a sort of Venn diagram where they overlap. There's no direction currently in the bill, is there, as to how that's to be resolved?
I think what I'd say is these can be really complex matters with many moving parts. The ability to actually legislate might be difficult. And again, I think in the answers I've given today, at a practical level, not just with agencies like ACLI, but agencies like ICAC, it's always been a really productive arrangement and engagement, Senator.
Well, in fact, your submission seems to indicate there may be circumstances where you may take a view that a disclosure of national security information to the NAC is unauthorised, and you in fact may go after and have an investigation that into the potential, as you said, criminality of the NAC being informed of something. That might put you in a direct conflict with NAC, mightn't it?
I wouldn't say direct conflict, but I mean, if we believe a serious offence has occurred in relation to those set of circumstances, we need to have a look at that.
But you may well have the NAC doing an investigation into the substance of that complaint, the substance of some corrupt activity, and at the same time, you may be doing an investigation to seek to find some criminality against the whistleblower who informed the NAC of that. That's a very real conflict, isn't it?
Well, it's a potential conflict, but it's one, I think, in terms of the agreement that we'll form with the MOU that we'll form with the NAC will cater for issues of that type.
Thanks. I was just going to ask you that. Do you see the, let me just confirm, you see that some of these intersections between the NAC and the AFP could be covered off in the MOU with NAC? Is that how you see it?
Very much so, Chair.
And just remind me, you do have a MOU with ACLI as well, don't you? So has that been the vehicle for covering off these issues as well?
It has.
Has that ACLI agreement been comprehensive as far as you're concerned for all the issues that you've faced?
I think what I'd say is that the MOU is the MOU, but in terms of a practical daily interaction with ACLI, it's been very positive, both on the internal corruption, but in relation to other matters that we deal with ACLI.
Okay, thank you. I think we're done. So thank you for your attendance here today. You have, I think, been asked to provide some additional information. Would you please forward it to the Secretary within 5 days from today? You'll be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to transcription errors. So thank you again for coming, and we're sorry we delayed you, but we appreciate your evidence today. And with that, I will say that proceedings are now suspended until 2 p.m. Thank you.
Sorry, Chair.
You ready? Can I start? Thanks, everyone. I think we will commence today. Can I welcome the representative from the Human Rights Law Centre, Mr. Pender, who's going to give evidence today. For the Hansard record, would you please state your full name and capacity in which you appear before the committee? Mr. Pender?
Thanks, Chair. Kieran Pender, Senior Lawyer at the Human Rights Law Centre.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to discussion.
Thanks. Chair, committee members, I wish to begin by acknowledging the traditional owners of the land I'm speaking on today, the Ngunnawal and Ngambri people, and acknowledge that sovereignty was never ceded. I wish to thank the committee for the invitation to appear today I regret that I was unable to make a written submission to the committee, which I intended to do so before being unexpectedly preoccupied with appendicitis last week. I'm glad to be back to health and speaking to you today. I'll focus my remarks on the intersection between the National Anti-Corruption Commission, the NAC, and whistleblower protections. I know there are many other aspects of the NAC design that the committee is considering, and I'll leave those matters to the informed views of our civil society partners who are speaking later. I've got 4 primary points to make. The first is that the NAC bill in its current form is a missed opportunity when it comes to whistleblower protection, and that will significantly hamper the effective operation of the NAC. To be effective, the NAC will be reliant on individuals who are aware of corrupt conduct speaking up. Unless the NAC can foster trust and confidence among such individuals that they'll be protected and empowered in speaking up, they will remain silent. The current NAC bill does the bare minimum when it comes to protecting whistleblowers, and it must go further. Second, the single most significant thing that this government could do to protect and empower whistleblowers would be to establish a whistleblower protection commissioner or authority to oversee and enforce whistleblowing law and provide practical support to whistleblowers. Such a body was first proposed by a Senate inquiry in 1994, again by a joint parliamentary inquiry in 2017, and most recently in the NAC bills that were moved by Crossbench and the Greens in 2018 and 2020. Whether established within the NAC or as a standalone body, a whistleblower protection authority would be a vital contributor to an effective National Anti-Corruption Commission. Third, the whistleblower protection provisions in the NAC bill and its integration with the Public Interest Disclosure Act replicate rather than remedy existing shortcomings. Now, I'm happy to go into more detail later on that point. The government has committed to PIT Act reform and indicated this will come before the NAC is operational, but its commitment so far has been limited to implementing the now outdated recommendations of the 2016 Moss Review. I would urge the committee to recommend that the government undertake comprehensive whistleblower protection reform as soon as possible to ensure that whistleblowers to the NAC are protected and empowered. And I note that Transparency International Australia, the Griffith University Centre for Governance and Public Policy, and the Human Rights Law Centre will soon be publishing a comprehensive roadmap for whistleblowing reform. Finally, the need for robust whistleblower protections extends to protecting journalists from being forced to disclose their sources, the so-called SHIELD laws. In a number of states and territories, we've had anti-corruption commissions use coercive powers against journalists and been rightly criticised for doing so. I think that Section 31 of the NAC bill is a good start, but it needs to be improved before becoming law. It lacks the necessary breadth and depth to be effective in practice. Ultimately, improved SHIELD provision within the NAC bill must be the first step in wider comprehensive press freedom reform. Thank you, and I welcome questions.
Thanks. Dr Haynes?
Well, thanks very much, Mr Pender, and a speedy recovery, I hope, to you, and thank you for coming in under difficult circumstances. Could you tell me, please, given the Human Rights Law Centre's framework for a fair democracy has a strong National Integrity Commission as its number one ask, in your view, is this model, outside of the whistleblower protection issues you've just raised, and I'll come to those in a minute, but is this model a good one?
Certainly, the model as currently provided in this bill is a good starting point. It needs to go further, both in terms of the whistleblower protections provisions that I've indicated and in terms of the other issues that have been raised by our civil society colleagues who I know that you're hearing from later today. But I think fundamentally this is the sound first step. More is needed, but when this is implemented, this will be a landmark step for Australian democracy and integrity within that democracy.
Thank you. You have just told us that this is a missed opportunity, though, when it comes to whistleblowers, and you've told us that without strong whistleblower protection, the key element to a successful NAC, and that is people coming forward and making referrals, will be hindered. Could you tell us then, given your recommendation around a whistleblower commissioner, just what that whistleblower commissioner or authority would look like? What powers would they have? How would this enhance the protections of whistleblowers?
Sure. Thanks for that question. Just as a prefatory comment, I would make the point that for this to work, ultimately we need people who see wrongdoing to speak up about it to the NAC. Are they going to do that? So right now, we have a state of play in Australia where whistleblowers have been under attack for the best part of a decade. We have 2 whistleblowers on trial right now. We have extensive evidence, including from Professor AJ Brown, who I know you'll hear from later today, that demonstrates that Australian whistleblowers are being punished, retaliated against, not protected when they speak up. So if that's the status quo, the Moss Review in 2016 said that the experience of whistleblowers under current whistleblowing law is not a happy one. We have this chilling effect, and I think what that means is that many people who see corrupt conduct, issues that will engage the jurisdiction of the NAC, will have serious and well-founded concerns about speaking up to the NAC. So if that's the starting point, the question is, well, what do we do about it? And the answer is really, I think, twofold. We need to ensure that the NAC is contributing to a positive culture, a culture of trust and of empowering people to speak up about wrongdoing, where they feel safe in doing that. We've seen other state and territory anti-corruption commissions have whistleblowers go to it, and then those whistleblowers have bad experiences. There's a case currently before the courts in Queensland involving a whistleblower to the Queensland Anti-Corruption Commission, Sharon Kelsey. I won't speak on that in detail, given it's before the court, but a case where a whistleblower has suffered for speaking up about wrongdoing to an integrity body. If the NAC, after it's operational, if one of its first whistleblowers who goes to it subsequently suffers and can't use the law to vindicate their position and their legal rights, what message will that send to future NAC whistleblowers? I really think it's perhaps tempting for the government in preparing and designing this bill to think of NAC whistleblower protections as separate matters. They're not. They are closely integrated, because without whistleblowers, without whistleblower protections, without avenues for whistleblowers to speak up in a way that is safe and lawful, we won't have an effective NAC. So what do we do about that? Well, I think there's 2 points, really. And the first is that the existing bill doesn't go far enough. There's no doubt that the whistleblower provisions within it are an important first step. I don't have any technical issues with the way it's been drafted and with the consequential provisions that integrate it within the PIT Act. But to highlight sort of 3 core issues, Section 27 of the bill provides that claims for protection under the immunity provided in the NAC bill, we're seeing all these issues under that identical provision. That's just been copied from the Public Interest Disclosure Act with minor tweaks to fit it here. And those issues are playing out right now in the Richard Boyle case, a whistleblower who blew the whistle on wrongdoing at the Australian Taxation Office. There's been all sorts of concerns around the technical operation of that law that are now just going to be incorporated wholesale into the NAC bill. And so if that ever is litigated, all these issues that are currently before the South Australian District Court, issues around what's the standard of proof, what's the nature of the whistleblowing jurisdiction, issues of open justice, of prejudice, all those issues are going to find their way into the NAC framework. Then we've got the Section 29 provision that criminalises reprisals. Now, that is nice in theory, but we know in practice the identical provisions in the Public Interest Disclosure Act aren't working. As far as I'm aware, there hasn't been a single federal prosecution for whistleblower retaliation. And I would suggest to you that's not because there have not been any whistleblower retaliation cases in the last 9 years. It's because it's too high. It incorporates all these issues from the PIT Act, which have been identified as problematic, and we're incorporating them wholesale into the NAC bill. So I think there's this wider point that we need to fix these provisions. We need a comprehensive reform rather than this piecemeal reform. The government has said it will implement the Moss Review. that's sort of several phases too late. We've had the Moss Review, we've had reform to private sector whistleblowing law, we've had, even since then, international developments. So I think part of this is we need a commitment for wholesale whistleblowing reform that's comprehensive and undertaken before the NAC is operational by mid next year. That's part one. Part two is this body, this Whistleblower Protection Commissioner or authority that actually oversees and enforces these laws in practice. I'm cognizant I've been speaking for some time, but just the critical point there is a body that can enforce these laws and can provide practical support to whistleblowers. So the Human Rights Law Centre has undertaken a review of every single whistleblowing case ever, which we'll publish shortly, and it shows there has only been one case under federal law where a whistleblower has succeeded in receiving compensation. One case. These laws aren't working in practice, and part of the reason is there isn't practical support, there isn't accessible support, there isn't a body, a Fair Work Ombudsman equivalent to oversee and enforce whistleblowing laws. You know, if you're a whistleblower and you want to go to the NAC, but you're concerned about your legal rights, what do you do? Who do you go to? The answer is, at the moment, there is a vacuum. And the answer that the government, I urge the committee to recommend to the government, we need a body to be in that position, the equivalent to the Fair Work Ombudsman. I know in the bill that was moved by Dr. Haynes, by the Greens in 2018 and 2020, it had a body with all of those powers, all of that authority. It's not in the current bill, and I think that's a real problem.
Could I just clarify then, if we were successful in arguing for a Whistleblower Protection Commissioner, and it wasn't to be contained within the NACC, where could it be contained? Does it matter where it is?
The Human Rights Law Centre's position is that we're agnostic on the exact location of this body. I think there are sort of three options, broadly speaking. One, as in the prior NAC bill, it could be within the NAC. As a commissioner within the NAC, I think that's entirely reasonable position for it to be in. Alternatively, it could be co-located with another body, or thirdly, it could be a standalone regulatory authority in much the same way that the Fair Work Ombudsman is. I don't really see that the exact location of it is particularly relevant, because I think wherever it is, it will have similar functions. So whether it's within the NAC or outside the NAC, it will both support the NAC in doing it framework in both a public and private sector context. The prior version that's been proposed, even located within the NAC, it was never suggested that that would be its limit of its jurisdiction. This would be a body that oversees and enforces whistleblowing law, but it would have a central critical function within the NAC, protecting and empowering NAC whistleblowers. And I would submit that that is central to the operation and the effectiveness of this body. If it's going to work, it needs to engender trust and confidence in whistleblowers, and a Whistleblower Protection Commissioner or authority is the way to do that.
Thank you. Thanks, Chair.
Mr. Wallahan.
Thank you, Chair. Thank you, Mr. Pender, for coming today. I'm just going to ask a few questions about why there was no submission, and none of this is a criticism of you. I understand you were sick and you've come here in good faith, so thank you for coming. But how many staff are at the Human Rights Law Centre?
We have about 25 or 30 staff, and within our democracy team, which obviously oversees this work, we have 4 or 5 staff.
And how many are legally qualified or do legal roles out of those?
Probably the majority of staff at the Human Rights Law Centre have law degrees.
Because the difficulty we have is we have 300 pages over 2 bills and a 500-page EM, so 800 pages, folders of submissions of other groups who've taken the time to do submissions. Can you explain why no one else was able to do a submission from the Human Rights Law Centre?
Well, I mean, I just might object at this point. I don't think it's the task of this committee to inquire into how or why organisations pull their submissions together. And this witness has already explained very clearly that there was a medical emergency last week, and I don't think it's a productive or appropriate use of the committee's time to investigate this.
Yeah, look, I think we've got limited time. I think that it's not going to be productive to ask about this. I think your question so far made your point. Somebody else could have written it, but can we get to the substantive matters?
I will, Chair, but I will note the lack of submission has impeded our time because we're not using it productively. Have you read the bill?
Yes, I have. And all I'll just comment is that, of course, civil society has worked, I think, incredibly productively as a whole across this bill, as it does on many other issues. We made a conscious decision in relation to a number of aspects of this bill to defer to the position of our colleagues in civil society who we engage with and interact with on these issues regularly. But my particular expertise is in relation to whistleblower protections, and that's why I'm here today making a submission limited to that matter. As I said, I would have liked to have made a written submission. I intended to, and then I was in hospital on Wednesday, and that's limited my ability to do so.
No, I understand that, and I'm moving on, and I repeat, no criticism of you personally. On the Human Rights Law Centre website, you've got your current impact areas, and you've got 1, 2, 3, 4, 5. You've got 8 bullet points, and the number one is strengthening the legal and institutional protection of human rights. Given that that is your number one current impact area, I just find it surprising that the Human Rights Law Centre has nothing to say about all of the human rights issues that are identified in the explanatory memorandum, and I'm going to list them. So on the explanatory memorandum, there's almost 50 pages devoted to the statement of compatibility with human rights, including an effective remedy, liberty and security, freedom of movement, fair trial and a fair hearing, presumption of innocence, minimum guarantees in criminal proceedings, prohibition on interference with privacy and right to reputation, and freedom of expression. Do you find it extraordinary that a group titled the Human Rights Law Centre has come here and said nothing about those?
I think I've already explained why our submission is limited to the present issue.
But you're here in person, and you've said something about whistleblowers, and that's fine. That's the position of an advocate. But you've come as a representative from the Human Rights Law Centre, and you've got nothing to say on human rights. Is that extraordinary?
I would say that the issues I'm canvassing go centrally to human rights issues around freedom of expression, whistleblower protections.
In a very narrow way.
To
in a very, very narrow way. Is that something that the Human Rights Law Centre should have turned its mind to and have made a submission about?
I've already explained with respect the limitations on our present submission.
Mr. Pender, with respect, it's incredibly disappointing. We are limited on time, and your views, your organisation's views on human rights would have been constructive, but instead it appears, with respect, you've come here as an advocate for one issue and not as someone who's an expert speaking on human rights.
Well, is that a question?
It is. I'd let him respond to that.
Well, I'd object. I don't see how attacking the witness is actually advancing the cause here. And that was much more a statement than a question. And simply statements attacking the witness will not be advancing our investigation of this bill. And I'd ask you to draw the questioning back onto the subject, Madam Chair.
I think you've made your point, right? There is no submission. We've given this witness 45 minutes. It's a narrow frame in which we're looking at it. I would have thought, in assessing the witness's evidence later down the track, or what we rely on, we can look at whether what has been said, and other people might draw out, have questions that go to some of those other issues. So is there any substantive matter in relation to what's been said about whistleblowers that you want to raise? Just raise them now, because I'm about to go to somebody else.
Yeah, all right. And this is relevant for whether this committee chooses to not hear from other witnesses, because by this witness being here, we've pushed others out, and that is not fair. On the issue of whistleblowers...
Again, look, Chair, I'm going to... How this committee has deliberated on witnesses is a matter that we've done in private session. I would contest what has been put on the record, but I'm not permitted to do because we've done it in private session. And I don't think it's appropriate that we have that kind of running, I would say, inflammatory and inappropriate and inaccurate commentary.
Yeah.
I have a question on whistleblowers.
Can you put the question on whistleblowers as soon as possible?
You referred, Mr. Spender, to a roadmap or a report that you will be preparing with others on whistleblowers, is that right?
That's correct.
And who's that with again?
With Transparency International Australia and Griffith University.
And in preparing that report, will that report address the issue of vexatious whistleblowers or whistleblowers who have proven to be making incorrect claims?
I think there's very little evidence that there is a systemic issue in the Australian system with vexatious whistleblowers. The laws already provide necessary safeguards for whistleblowing that is made in bad faith, but there's almost no evidence that that is an issue that needs to be addressed by the law beyond where it already does. Conversely, there is substantial evidence that the whistleblowing protection framework is failing good faith bona fide whistleblowers.
Are you aware of the issue surrounding the Logan City Council?
I briefly referred to that as an example. My preference not to comment in detail on that case, given it's before the courts, but I think it's an example where someone blew the whistle to an anti-corruption authority and they've experienced significant difficulties in vindicating their legal rights.
I think you'll find it's no longer before the court, so do you have a view on the Logan City Council?
I understand that part of the whistleblowing matter remains before the court, so I'd prefer not to comment.
And no further questions, Chair.
Thank you. Mr Zapier?
Thank you, Chair. Mr Pender, just one question. Given that you've got an interest in the protection of whistleblowers, are you aware that the Attorney-General in his second reading speech made it clear that he would strengthen the provisions in the Public Interest Disclosure Act? And if so, are you comfortable with that response?
Thanks for that question. Yes, I understand that the Attorney-General has committed to reforming the Public Interest Disclosure Act. I think the extent of that current commitment, as has been publicly stated, is limited to the recommendations of the Moss review in 2016. There are really sort of three phases to this. So the Moss review in 2016 made a number of recommendations. Those have not been implemented. The prior government accepted those recommendations in large part in 2020. An amendment bill still has not been brought to Parliament. Those recommendations are now 6 years out of date. So they, of course, need to happen, and that's the extent of the government's commitment, but it's not enough. The second phase is that in 2019, Parliament enacted stronger protections for private sector whistleblowers. So we currently have this extremely problematic scenario where private sector employees have stronger whistleblower protections than public servants. The government has not committed to addressing that deficit, as far as I'm aware, on the public record, has not committed to that more wholesale reform. And then since 2019, we've had a number of other issues identified with the Corporations Act protections and then international developments, the landmark EU whistleblowing directive. So we're really sort of three phases behind. The commitment to enact the Moss review is important, but what I would urge the committee to do is recommend that before the NAC becomes operational, wholesale comprehensive whistleblowing reform is expedited to ensure that whistleblowers to the NAC are protected. And just as a sort of general comment, particularly referring to the prior line of questioning, I really contest the idea that my submission is narrow. I really think that these issues go to the heart of an effective National Anti-Corruption Commission. If we don't protect and empower people who speak to the National Anti-Corruption Commission about issues of corrupt conduct, it won't work in practice. And all of my recommendations are sort of pointed in that area because I think that's a really critical area of oversight. As I said in my opening remarks, this is a missed opportunity at the moment.
No. Look, thank you, and I certainly didn't suggest that your submission was narrow. I was just trying to clarify whether you're comfortable with the proposal that there will be a review of the Public Interest Disclosure Act.
Certainly, and so that general comment wasn't directed at your question, but the prior line of questioning. I think, as I said, the commitment to implement the Moss recommendations is a good start, but it doesn't go far enough.
Sure.
And I would urge the committee to recommend that the government go further before the NAC is operational.
Thank you. Thank you, Chair.
Thanks. Senator Shoebridge?
Thanks very much, Chair. And Ms Pender, thanks for attending and giving your evidence today. And I very much join with other committee members and hope you're firmly on the mend. Could I ask you about if we were to make a recommendation about whistleblower protections, there are a bunch of different potential models. You've referenced Dr. Haynes's bill, the Greens' previous bill, but could you outline the difference between, say, a whistleblower commission and a whistleblower commissioner? Can you outline what the difference would be?
So the prior Greens bill and Dr. Haynes's bill contain within it a whistleblower protection commissioner as part of what we now know as the NAC. There is merit in having it as part of that body, I think. It would then be co-located, it could share some resources. Fundamentally, though, it would have a wider remit. It would support and empower NAC whistleblowers and other Australian whistleblowers, particularly under the Public Interest Disclosure Act and the Corporations Act whistleblower protections. So that's sort of one model. I think that's a model with a lot to commend it. I think it's disappointing that the current bill lacks that core component of prior bills, which the government had pledged that the present bill would be broadly similar to. Alternatively, the government could establish an entirely new regulatory authority, a Whistleblower Protection Commission authority, that would have very similar powers, but would stand on its own. As I said, we're broadly agnostic to which form it takes. I think there are some aspects that would make it better within the NAC. There are some reasons that would suggest it would be stronger as an independent authority, but I'm not too concerned about the form it takes. The key thing is it has the powers, functions, and critically the resourcing to oversee, to enforce, and empower Australian whistleblowers.
So if I'm to understand your evidence, it can't just be a single commissioner with maybe a very small support office. There actually needs to be the heft, if I could say that, of some sort of agency which will have the resources and reach to actually assist whistleblowers through their journey.
Correct. And as I understood, and I think if you look at the powers that were set out for the Whistleblower Protection Commissioner in the prior in the prior two bills, the 2018 and 2020 bills, it was always envisaged. It has an expansive range of powers, and with that would need to come sufficient resourcing. It might be that setting it up as a standalone body has some desirability as a result, but as I said, I think either is significant. Is ultimately going to make a real difference, but we need one or the other. The current lack of practical support for Australian whistleblowers is a huge barrier to people speaking up about wrongdoing.
And where you speak of practical support, is it in circumstances where whistleblowers are often without that support? They're an individual against a very large government agency with all of the resources. So is it about supporting them in their legal journey? Is it about providing some adequate financial compensation and assistance? What's the kind of practical support a whistleblower commission could give?
Sure. So I think firstly, it could be an initial point of call. It could provide practical advice and guidance. There are limited support available to Australian whistleblowers at present. The Ombudsman provides some information. ASIC in the private sector scheme provides some information, but there is a significant deficit of initial advice and support, which is alternatively available in other jurisdictions, such as in the United Kingdom, where that role is played by civil society. Then there's the question of providing, guidance and potentially legal intervention. I think it was envisaged in the prior iterations of the legislation that there could be a role for the body to play in enforcing whistleblowing law, much as the Fair Work Ombudsman is selective in the cases it picks. I don't think it's envisaged that the Whistleblower Protection Commissioner Authority would be litigating every single case on behalf of whistleblowers, but where it's strategic and important as part of a wider systemic issue, you could imagine that a body like that would play a particularly useful role in driving change. So it's sort of both an initial port of call and then a subsequent, a sort of significant subsequent role in select cases.
And without the Whistleblower Commission in place at the moment, what, if any, agency is responsible for enforcing the whistleblowers or whistleblower protections under the current PID Act? And who would be responsible for enforcing the protections under this proposed bill?
there's very little current enforcement capacity. The Commonwealth Ombudsman has some role, but it of course is limited from a resourcing perspective in what it can and does do. Sorry. So I think there's a real regulatory gap there, and a lot of this ultimately falls on the weight of individuals to litigate these cases. We have fairly strong protections on paper, which are not working in practice. As I said, there's only been one case of compensation arising out of federal whistleblowing law in either the public or private sector. That was actually a private sector case under the Corporations Aboriginal and Torres Strait Islander Act. So we're not seeing these laws work in practice. Whistleblowers often don't have access to legal support. They don't have the funds to engage private practice lawyers too often. And so the civil dimension of these laws aren't working in practice. And the criminal dimension has gathered dust. As I said, as far as I'm aware, there has not been a single prosecution for retaliation under the Public Interest Disclosure Act. And so I think at the moment, those laws provide limited support, and under the NAC, as currently framed, if enacted, those provisions, while important, will not go far enough.
And ultimately, at the core of your submission is the proposition that on the day that the NAC opens its doors to accept complaints, there needs to be a form of whistleblowers commission, either within the NAC or as a standalone entity, that also opens its doors to provide support. And those two things should coincide.
I think that would be eminently desirable. Of course, I understand there is a limited time frame. And it might be that the NAC opens its doors and the Whistleblower Protection Commission opens its doors a few months later. But as I said, I think this is a core issue, that if we don't protect and empower whistleblowers, how is the NAC going to do its job? And what happens, that's sort of the deficit. Then the worst case scenario, what happens if people go to the NAC, they then suffer retaliation, the current laws don't work. So for example, there's a gap in the current law. The criminal provisions cover all, this is the Section 29 covers everyone to the NAC, but the integration with the PID Act only covers public servants. So there are people who could fall down and find themselves unable to vindicate this law. What if they suffer retaliation for speaking up to the NAC? What if, for whatever reason, obviously criminal standards are very high, prosecutions are difficult to bring? There could be extremely alarming cases of whistleblowers to the NAC suffering for trying to do the right thing and bring information of wrongdoing to the NAC. That would be extremely detrimental to the NAC's efficacy moving forward.
Thanks, Chair.
Thanks. Senator Scarr?
Thank you, Chair. Look, at the outset, I just want to compliment you on your passion for this cause, and I say that as someone who, in a prior life in the private sector, was a whistleblower officer in a ASX-listed public company. So I've got some familiarity with these issues. I just want to come back to this point about delay. So I understand the reasoning. I understand the preference, but in reality, this is a very complicated piece of legislation. There's been a raft of submissions received, as one of my colleagues referred to, and to some extent, I think there's a desire. I certainly have a desire. I won't speak for other colleagues, to get this thing done and in operation. Do you think it is genuinely realistic to do what needs to be done in terms of the whistleblower space, in terms of those reforms, such that it could be incorporated into this process, or would that simply delay things for months whilst we go through this sort of process again? And realistically, if we get this done and then the next tranche rolls on to the relevant whistleblower reforms, can you see the attraction of that latter strategy?
Certainly. To answer that question in two ways. Firstly, I do think it's realistic that there was the legislative sort of suite for the prior iterations, the 2018 and 2020 bills from the crossbench from Dr. Haynes from the Greens, that had a Whistleblower Protection Commissioner within it. So I think a lot of the groundwork has already been done. And then a lot of the work that needs to be done around fixing the Public Interest Disclosure Act, I think, could be done with the effort, with sort of the resources committed to it, could be done easily before mid next year. I accept that a lot of work has gone into this, and a lot of work will need to go into whistleblower protection commissioner / authority and whistleblowing law reform. I don't think that's impossible. However, even if it was accepted that there is an attractiveness to moving forward with this and moving forward with the whistleblowing dimensions in parallel, I just urge that needs to happen as soon as possible in a comprehensive way. The government's current position is it will consider the need for a whistleblower protection commissioner or authority, and it will implement the Moss review. That's what it's committed to. It needs to commit to much more, and as soon as possible, so that whistleblowers to the NAC, when it opens its doors mid next year, feel protected and empowered.
Okay. I want to talk about the concept quickly. I just have two areas of questions. The concept of a whistleblower commission or authority. I've actually raised the case of Mr Boyle in this room during budget estimates, and I just take the opportunity to acknowledge the work Senator Patrick, one of my past colleagues, has done in that space. He's been a fierce advocate in this area. It seems to me the importance of that commission or authority is to make sure that someone who is taking that step, and it's a monumental step, to become a whistleblower, they've exhausted all other avenues. There's a specialist agency that can give them the support, the strategic direction, the roadmap, if you like, as to how to navigate what no doubt will be complicated laws, and to provide them support through the process. And that's why it's essential. Is that correct?
I agree with that entirely. I think the Richard Boyle case is a really good example of the need for this sort of body. And if I can just give one example from the Boyle case of direct relevance here, two issues that have arisen in the Boyle case are the way in which the immunity operates. So the PID Act provides if you blow the whistle, you're immune from prosecution. That's picked up by the NAC bill at section 27. Now that sounds nice in theory, but in practice, the Boyle case is demonstrating that no one really knows how that's going to operate. So firstly, section 27 and the PID Act provide that the proceedings are split out. And so you have the immunity issue decided first. So issues have arisen in that case. Well, what's the nature of that split out proceeding? Is that criminal? Is that civil? What's the burden of proof? Is it beyond reasonable doubt? Is it on the balance of possibilities? Because that case has arisen, because it's split out and determined first, there are questions of prejudice to Mr Boyle and open justice. So the Commonwealth Director of Public Prosecutions sought a suppression order in that case. The Guardian Australia contested that and was successful in contesting that, and that was withdrawn. But there are all of these practical issues as to the operation of the immunity that arose in the Boyle case, are on foot right now before the court, that the NAC is just mirroring and adopting wholesale in the present bill that are then going to arise in the future. And I think having a whistleblower protection commissioner or authority who could intervene in a case like that, could make detailed submissions on these exact points, would be incredibly helpful, because at the moment you have the CDPP and Mr Boyle fighting out to determine the shape of Australia's whistleblowing laws in practice without the sort of informed submissions of a body that has overall carriage and oversight of these laws.
Understood. Lastly, I just want to come back to an area which my colleague raised in relation to general human rights concerns in this space. And there are just two particular issues I'm interested in your views, and happy for you to take this on notice, but I am happy to obtain your views. And the Law Council of Australia has made a submission where it talks about two, I consider, foundational stones of our common law system in terms of the privilege against self-incrimination and legal professional privilege with respect to communications between clients and their lawyers as being fundamental to the rule of justice, to make sure that people actually get legal advice to inform their position. The Law Council of Australia has made various recommendations in that regard. We don't have time for me to put them to you now, but would you mind taking on notice, actually just having a look at the recommendations in relation to those two important human rights areas and providing your views to the committee?
Certainly. I'll take that on notice. Thank you.
Okay, thank you very much. Thank you, Chair.
Thank you. Mr. Pender, I think that, in fact, the Attorney General is on record as saying that the government will update the recommendations of the Moss report, not just implement them. And I think there's a fine difference between that, which and the Attorney General's also said that he will be putting forward the legislation to have it passed by the time that the NAC commences, and that the government is committed to ensuring Australia has an effective framework for whistleblowers. Would you concede that the failure to implement the Moss report is not a matter that the government had any control over?
I would accept that the government only, the present government. On that point, perhaps we're splitting hairs. I know that the government has indicated that the Moss review no longer is current.
Yeah.
But as I understand it, there is no firm commitment from the Attorney General as to what the update on Moss looks like. And all I'm saying is Moss is no longer good enough. We need to go further.
Yeah.
We need to go to the corporation standards, and we need to go beyond that because the rest of the world is moving on. And so I accept that the Attorney General has made these commitments, no doubt commitments in good faith, but we really need more robust commitments that before the NAC is operational, we have best practice whistleblower protection provisions for NAC whistleblowers.
Yeah, I get your point. I don't think it's splitting hairs. I think it's a bit different. So there's the Moss review recommendations in 2015, and there is the 7 years subsequent and what else and ahead. And I take what the Attorney General has said to mean that it's not going to just implement the Moss review. But if I'm right and your interpretation is not right, is incorrect, can I take it that what you would say is that to be forward thinking and to amend the Moss recommendations, you must have a whistleblower commissioner or commission? As you've outlined. That's what you say. If we're forward-looking and beyond Moss, you have to have that.
That's correct.
Thank you. Can I thank you very much for your attendance today, and again join with the others and wish you a speedy recovery. We do appreciate that you have taken the time. There are a couple of matters that we've asked additional information from you for. Could you forward those to the Secretariat within 5 days from today? You will also be sent a copy of the transcript of your evidence, and we'll have the opportunity to request corrections to the transcript if there are errors. So thank you again very much.
Thanks to the committee for the opportunity.
Thank you. Thank you. Can I now welcome the representatives of the Australia Institute's National Integrity Commission and also the representatives from the Centre for Public Integrity to give evidence today. For the Hansard record, could I ask you each to state your names, state your full name and the capacity in which you appear before the committee. I don't know that we have everyone quite yet, have we? No, not quite. We're waiting for a couple of others, I think, to join. We're waiting for, Jeffrey Watson and Anthony Wheely, I think, but perhaps I'll get those on screen. Mr. Charles, do you want to announce your appearance and then I'll go around the screens?
I'm Stephen Charles and a member of the board of the Centre for Public Integrity. I'm also a member of the judges group that David Harper is here representing, but I'm speaking today for the CPI. And I think that Anthony Wheely and Jeffrey Watson may not be available at the moment, hoping to be able to make an appearance later during the hearing.
Thank you. Mr. Barker? I think you might be on mute.
Thank you very much, Senator, and thanks for pointing that out. like Stephen Charles, I'm also associated with the Centre for Public Integrity. Thank you very much.
Thank you. And Mr Harper?
David Lindsay Harper, and I'm here as a member of the National Integrity Committee, the committee which consists of former judges of Court of Appeal in different states in Australia, and we also have as a member Mary Gordon, retired Justice of the High Court.
Thank you.
And
so do any of you wish to make a opening statement on behalf of your organisations?
I'm prepared to make a short statement in relation to public hearings, Chair, if it's convenient to do that now.
Yep, do that now. Thank you.
We certainly support public hearings for a body of this kind, and we have previously supported the Labor Party's proposal when it did not contain an exception or a limit, rather. If they should only be heard when exceptional circumstances exist. We join with a number of the commissioners of integrity systems around Australia who say that will seriously reduce the hearings which can occur. We recognise that public hearings can occasion damage to people's reputations, and there are a number of protections which the bill, which we say will reduce damage. And we also say that the people who are the commissioners of commissions around Australia usually spend their time asserting that public hearings are essential to the role their integrity commissions are created to carry out, and that insertion of exceptional circumstances will dramatically reduce public hearings where the commissioners
Chair, I'm loath to interrupt.
Yeah, it's hard to hear.
We're only getting about 7 words in 10, and so it might be necessary for either the witness to speak more loudly or to review the connection.
Yeah.
Right. Are you hearing me now?
That's a bit better, yes.
Yep. If I put my head closer to the screen, maybe, sorry. We argue that public hearings are essential to the task that integrity commissions are trying to perform, that the exceptional circumstances requirement, which comes from the Victorian legislation, substantially reduces the number of public hearings that occur. That is strongly opposed by the present Victorian Commissioner of the IBAC, and in our respectful view, although we accept reputational damage can occur, there are a variety of ways in which it can be reduced, and they are part of the legislation, the provisions which require the Commissioner to take reasonable steps, such as under sections 149(5), to indicate that people who appear are not responsible for any improper behaviour, matters of that kind, and also the role of the inspector, the parliamentary committee, and the federal court can all operate to make sure that the NAC is not misusing its position.
Thanks. Mr Harper, is there anything that you wanted to say on behalf of your organisation?
thank you, Madam Chair. I endorse, as I know my committee endorses the statement which Mr Charles has just made about exceptional circumstances. We think that it is not appropriate for that to be a constraint upon the Commission in conducting public hearings. We take that position for the reasons which Mr Charles has outlined. We would also seek to have included in a definition of corrupt conduct, conduct by third parties which have no influence on an innocent public official, but might nevertheless involve serious dishonesty, resulting in corruption that affects the public office and the way public offices are conducted. So we think of such things as dishonesty in obtaining public monies and collusive tendering as just two examples where outsiders might be able to severely affect the proper management of government business in a way which is most certainly corrupt, but which at present is not caught by the definition. Can I add to that simply that we recognise the enormous amount of very hard work which has gone into the production of this bill. We acknowledge its great improvement, vast improvement over the previous government's attempt to create a National Integrity Commission, and we would applaud the passing of this bill, but we would hope that it would be improved by, amongst other things, the two matters that I've suggested.
Thank you. Mr Wolahan?
First. Yeah, happy to. Thank you. If I could direct my questioning primarily to Mr Harper. And before I do, Mr Charles, your name is at the bottom of the Australia Institute letter or submission, but you've said you're only here in the capacity as the Centre for Public Integrity. Are you not here for both?
I'm not here for both. I was asked to come along for the CPI. I knew that David Harper was going to be here to represent the other body. I can speak in any answer to any of your questions. I'm here simply for the CPI at the moment.
So when your name appears at the bottom with Stephen Charles, Mary Gaudron, David Harper, Paul Stein, Anthony Whealy, Margaret White and Carmel McClure, but you're not going to speak to that letter?
Look, I can do so if you wish to ask me questions about it, but I'm not here for that purpose at the moment.
Oh, thank you, Mr Charles. I'll go back to Mr Harper. Mr Harper, could I take you to the report that's at the end of that letter, and in particular take you to page 7, please?
I don't have ready access to it on my equipment, I'm afraid.
I'll do my best to summarise it. You probably don't need to refer to it, and if you could take it as a given that I'm not misleading you about what's in it.
Certainly, I'll take that as a given, yes.
Thank you. So on page 7, it has a table up the top, and it's called Table 1, Comparison of Anti-Corruption Agencies in Victoria and New South Wales. And the date range is important, and we'll get to why. It says 2012 to 2021. And tell me if this is correct. ICAC was established in New South Wales on or about 1988, and IBAC in Victoria on or about 2012, and that's the reason that date would be chosen. Is that correct?
Yes.
So ICAC in New South Wales is a more mature organisation that has been around for a longer time.
Yes.
In that table from 2012 to 2021, the case has been made that Victoria holds less public hearings, and the table under Victorian public hearings notes that there are 5. Can I respectfully suggest that this is in error? And the IBAC annual reports, which are published online, note that there were 8 in this period and a further 2 since.
I don't challenge your conclusions. I'm not privy to, I'm afraid, the way that the committee prepared the figures which it put before the committee, but I have no doubt that you have made the correct calculations.
And perhaps when we get to the next session, Ms McLeod will clarify, because her submission notes that there were 8 in that period as well. And the website says that there was 10, but 2 of which occurred after that date range. there's another way to make the comparison, and the comparison here is it says public hearings 45 for New South Wales and 5, or let's say 8 for Victoria. But there's another way than just aggregate hearings, and I want to get your opinion on that. The other way to compare would be to compare total hearing days. And I accept that New South Wales uses the language compulsory examination, but I will say hearing days from here on. And they can be private or public. And I would suggest that this is more helpful because some hearings may be mundane and short and others are complex and long. Do you accept that that will be another way and perhaps a better way to compare?
Well, certainly another way to compare. I accept that respectfully, yes. Better, I'm not sure. I am of the view that it is significant in looking at the question whether or not there should be exceptional circumstance before a public hearing is conducted, that there's such a wide discrepancy between the number of cases in Victoria that were conducted in public and those over the same period in New South Wales. But yes, I think it's perfectly open to subject that broad conclusion by looking more particularly at the number of hearings, public or private, that the two bodies have conducted over that time. I don't seek to defend the conclusion that we've drawn on the basis that it is one that is clear from the figures, from any kind of figures, except the fact that the discrepancy is very great. And it is, I think, quite legitimate to conclude that one of the reasons for that very great difference is a reluctance or an inability in Victoria to find exceptional circumstances where that is not a problem in New South Wales.
I'm just going to, we've done the work on hearing days. I'm just going to quickly go through it and get your opinion on it. The IBAC reports only record data from July 2014, and we can assume it's because they were finding their feet, but that's when they started recording data. So from the period July 2014 to June 2021, we noted, and I'm happy to be corrected, and rounding up, that 53% of the hearing days for ICAC in New South Wales were public, and 28% of IBAC's hearing days were public. And we accept and note that IBAC in that comparison still has fewer hearings, but would you accept that that's nowhere as extreme as this report seeks to make out, which using the figure of 5 was 9 times as many?
Yes, I would have to accept that.
I'd like to move on to, on that page underneath the table, there's a heading that says, the test is vague and open to litigation. And this is a matter that is covered in not just this organisation, but the Centre for Public Integrity, the Accountability Roundtable, and I'm not sure if, Professor Brown, you mentioned it too, so perhaps it's something that we can save time on. So bear with me as I go through it, because it's important. You all raise it. You've said that the test is vague and open to litigation, and then you quote Fiona McLeod, who's, I know, here already, and you say, quoting Fiona McLeod, legal experts are concerned that the test invites legal challenges, and quoting Fiona McLeod, it's a lawyer's picnic waiting to happen. The test means that a person who is under investigation may make issue with a commissioner who seeks to hold a public hearing and delay the investigation with a court challenge. And then later it says, the exceptional circumstances test puts the commissioner in a difficult position. It is an unnecessary grey zone that only adds legal risk and confusion. And it's that argument I'd like to address, please. Now, we don't need to speculate about this, do we? Because thanks to Victoria and IBAC, we have a decade of test cases for this very test. And when we look through the 10 hearings, there was only one that had a direct Section 117 case. Does that surprise you?
If you're saying, I take it, that there was only one case where the question of the existence of the exceptional circumstances was a live issue.
That's correct, and I'm happy to go through each one of them. We've got a table that shows when and where it went before the court. And it was the fourth one. So the first one was Fitzroy, then Ord, then Dunham, and then Ross. And it's the seminal case for Victoria, R&M and IBAC 2015, Victorian Supreme Court 374. And it's a case that is referred to in some of the submissions. But when you go through the other 10, including Lansdowne, Gloucester, Sandon, Esperance, Watts and Bredbow, we couldn't locate any direct cases that were brought before the court for this very issue. Does that surprise you?
It does. I'm not querying the fact, but it does surprise me that someone who is accused of corruption and who is facing a public hearing does not challenge the issue of exceptional circumstance. In one case, that challenge was made. I don't know why the other cases did not also involve a challenge. Maybe the very fact that the notion of exceptional circumstances is so vague, so ill-defined, that the cost of a challenge, the cost to the pocket of the person seeking to raise doubts about the issue of exceptional circumstances and bring them to the court was a disincentive. Legal proceedings are often difficult, but they're always expensive, and it's not to be assumed that they can be taken lightly. A corrupt person with a deep pocket would almost certainly challenge a ruling by a commission that exceptional circumstances exist, even if only to create a delay to stop the proceedings for some time, perhaps a long time, while the queue at the court was overcome. So there are reasons why you might not challenge the ruling that exceptional circumstances existed, but there are also very strong reasons why you might.
Thank you, Mr. Harper, but with respect, that sounds like you're speculating. I've pointed you to actual cases, and you would be aware that in Victoria, at least, cases can only be brought for a proper purpose, and that's in the Civil Procedure Act. So is it really the case that you can, before this committee, speculate about plaintiffs using the procedure of the courts and litigation to delay when there's no evidence of that and it's not for a proper purpose in Victoria?
What else can you do but speculate? We weren't present, of course, at the hearings, and we can't say why it was that the exceptional circumstance ruling wasn't challenged. I'm sorry, with respect, I don't see how you can do other than speculate about the reasons why the challenge wasn't taken.
Thank you, Mr. Harper. Just in conclusion, have you read the submission of Dr. James Renwick?
No.
Can I suggest that after this you do? I think it goes to this very issue as to perhaps why the statistics in Victoria are what they are. And it's a short submission, but I'll read it out, parts of it. In his third line, Dr. James Renwick says, "I consider the risk of a successful challenge to any decision to hold a public hearing is small." And he then outlines why, and he refers 3 points, and including that it would be a jurisdictional fact in the usual, and refers to Hetton, Belbert and Colliery's sense, and then also says that the High Court and Minister for Immigration and Multicultural Affairs against Eshetu, as decided in 1999, High Court Australia 21 at page 137. And he quotes at 137, where the criterion of the court, where the criterion of which the authority is required to be satisfied turns upon factual matters upon which reasonable minds could reasonably differ, it will be very difficult to show that no reasonable decision maker could have arrived at the decision in question. It may be otherwise if the evidence which establishes or denies, or with other matters goes to establish or to deny that the necessary criteria has been met, was all one way. And he goes on expanding that and then says, second, provides a suggestion on another provision. Can I suggest that we accept that there are arguments for having public hearings, there are arguments for having no public hearings. I think everyone on the committee agrees with that, and we've got to wrestle with that decision. But can I suggest for all of the committees appearing today, it's unhelpful to engage in speculation when we have an example from Victoria that shows otherwise. It doesn't assist this committee in addressing that substantive question before us. Thank you, Chair.
Thanks. Dr Haynes?
Thank you very much, Chair, and thank you to our witnesses appearing today. Just to continue on the questions around the exceptional circumstances phrase, on page 9 of the CPI submission, you put forward various proposals if exceptional circumstances were to be removed as a phrase. Is your submission saying that these proposals should all be adopted, or are they alternative options, or would you in fact be suggesting that subclause 73(2)(a) was completely removed for the purposes of your argument?
I think in answer to that our first proposal is that what is now in the bill, subsection 2, should be removed, so that the limitation of exceptional circumstances goes completely. If that leaves the legislation in a situation that is not approved by the Parliament, one proposal is the first one, in other words, to require the Commissioner, by the word must, to consider each of the matters in subsection 3, so that there's no options, no discretion. The Commissioner will have to take each of them into account. That is one alternative proposal. They really put forward, in answer to Dr Haynes' question, as possible alternatives that the committee could consider as an alternative to the exceptional circumstances provision.
Thank you. Thank you, Mr Charles. I want to turn our attention to the definition of corruption, if I may. Given what you know about state-based corruption agencies, why is it important that the definition of corruption be broadened to capture corrupt conduct by third parties when there's no wrongdoing by a relevant public official?
Can I leave that to Mr Barker? He dealt with it previously. I'll come back to it if you wish.
Thank you.
Oh, thank you very much, Senator Haynes. I think it's this question between the sort of corrupt conduct that might be a criminal offence on the one hand, and the sort of misconduct, corrupt conduct as defined, which affects public administration in a systemic sense on the other hand. We've referred in the CPI submission to a number of examples that could be given, and we also refer to what Justice Gageler said in the Cunneen case in the High Court by way of example of why third-party conduct that might be considered to fall within the general rubric of corrupt conduct. The thing is, you can discover that there are people on the outside. It might be the Medicare system, it might be people trying to rort a licensing system, it might be people trying to rort a natural resources approval program who may not have managed to influence the mind of the public official, but whose conduct was certainly designed to do just that. And it's by looking into that sort of complaint that if you discover there is wrongdoing, generally, you can improve the way the system of public administration operates. It's sometimes said, but it becomes obvious that it's not the case, that you could leave that conduct by third parties to the police or some other investigative agency. But they're not really set up, the police, to look into public administration. They're not skilled and trained to do that sort of thing. That is really one of the key reasons why one needs a federal anti-corruption organisation, so you can keep an eye on systemic corruption in the public sector.
Mr Barker, I'm not sure if you heard the Attorney-General Department's evidence this morning, but I put a similar question to them and they seemed very confident that we have sufficient capacity within our existing agencies to undertake that work around investigating systemic and structural corruption. Would you agree that that confidence is well placed, or would you hold that we really do need to broaden this definition of corruption?
I didn't hear the evidence, but I well understand it. 30 years ago, as one of the counsel assisting the WA Inc. Royal Commission and had to think hard about things, we recommended that there be a series of public accountability agencies, and that's what you're looking at. We have in the Commonwealth sphere a number. You can include the police in that at a very broad level. We've got the Auditor General, we've got the Ombudsman, we've got the Public Sector Commission and the like. There are a range of people with very specific responsibilities. Some of the things I've referred to may well get picked up in the course of these other public accountability agencies doing their job. We know about some of the investigations that the Auditor General conducted in more recent times. Things somehow bubble to the surface in those ways. The point of having the Anti-Corruption Commission federally is that there is a very precise, organised agency to take systemic corruption allegations, as well as the hard-edged, what people often think about as criminally corrupt activities, where people are taking money or favours or something like that. I think having them all in the one federal integrity body, the Anti-Corruption Commission, is the right thing to do. It means you don't have any cracks in the system for things to fall between.
Thank you. Could I turn your collective minds towards own motion investigations? And I noted in the submission around concerns about the explicit power for the Commission to commence its own motion inquiries. Could you just tell me what your concerns are that this is not explicit in the bill? Not sure who'd like to answer that one.
I'll defer to Mr. Charles.
The bill does deal with this. I think it's in section 40, isn't it? And what all that we were concerned about is that the explanatory memorandum makes clear that it's intended that the Commission be able to act on its own motion, but it's a critically important power and it's not very clearly expressed. And we would not want a situation to happen when the Commission said, well, we would like to investigate this, and then someone say, well, you've got no express power to do so, where other bodies which have like powers do have that power given to them expressly. That's all.
Can you see any reason why it wasn't specified in the bill? Do you think it could be an oversight? Is it something we can remedy?
Well, a short amendment, just the wording that the Commission may be entitled to investigate on its own motion. short form of words of that kind would be sufficient.
Thank you.
It would be easy enough to do.
Yes, thank you. I have some questions around the Statutory Oversight Committee protections and commissioner appointments. In your submission, it says the requirement that the chair be a government member is a serious limitation upon the committee's independence. Can you elaborate on that, please?
Yes. What we mean by that is that the oversight is there. The Oversight Committee is there to do precisely that. It's to act as a guard so far as the community is concerned. The fact that the chair is to be a member of the government means that the government in effect controls the committee. Now, there are two particular areas that trouble us. One is the selection of the commissioner and deputy commissioners. The other is funding. It would be possible, for example, to have an independent funding tribunal. They exist in a number of different areas. This one will simply mean that the government decides how much the committee is going to get, how much the NAC is going to get, and the government will control it. Now, insofar as choice of commissioner is concerned, again, there are ways in which you could ensure that the government did not have token control. The provision of something like a veto, or alternatively, provision in the case of disagreement for both sides to nominate, say, 3 persons and to find one that was acceptable to both sides. It would be possible to provide for nomination of the commissioner in a way that was not left in the control of government, and whether one wants to leave it in the situation where different future governments have ideas of their own, that's all.
The ex-mem talks about the chair being a member of the government as being consistent with arrangements for other legislated joint committees, such as the Parliamentary Joint Committee on Intelligence and Security. Why in this case do you think it's necessary for a different standard? And do you think that the convention is something that should hold, or do you think that this is such a different statutory oversight committee that we should be looking at something that's not generally the convention?
Simply, I think that this is a particularly sensitive area where it's desirable that the government not have absolute control of certain things. In relation to things like the intelligence matters, I would have thought, while that's exceptionally important, it's much less politically sensitive, I would have thought. You may disagree.
Mm. So for a committee with such an important task to depoliticise something such as the appointment of commissioners, in your view, other models, and certainly in the bill I put to Parliament, there was provision for co-chairs and that deciding vote was not held by a government member. Can you comment on that?
Well, I think it was very, very well chosen provisions, if I may say so. They certainly provide an alternative. Our submission is based on the undesirability of there be governmental control of certain matters.
Thanks, Mr. Charles. That's all.
Could I add that in relation to that, one of the deputy commissioners is not legally qualified, and one matter that did concern us was in case there were to be public hearings controlled by a deputy chair, it seemed to us to be very undesirable that a public hearing be controlled by a deputy chair who was not legally qualified.
Thank you.
So that any public hearing ought to be controlled by someone who had legal qualifications.
Thank you.
Thank you. Ms Lawrence?
Thank you, Chair, and thank you also for appearing for us today. I just wanted to go a little bit further about in your submission again on page 7 and just the reference to the table. I appreciate your endeavouring to make the point around New South Wales perhaps greater comfort with public hearings perhaps as compared to Victoria. But it did make me reflect on what you do regard as the measures of success, because I think just noting the numbers on their own perhaps doesn't give colour to some of the complexities and perhaps the time it takes for some of these investigations to be pursued. So, yeah, I just wanted to see if you had any further comments about what the public should expect as the KPIs for a commission, given the resources that are going to be deployed.
You're on mute, David.
David?
I'm sorry, I muted myself. I was going to suggest that since I spent some time talking about the table before, Mr. Charles might like to add to or correct anything that I had said. But the wider question of KPIs for an independent body is somewhat fraught. Certainly, one would hope that the Commission would see its public expression and its public conduct as being fair and considered and sagacious, and getting that message across to the public in a way that the public could appreciate that the work the Commission was doing was very carefully guided by a really precise appreciation of the power of the Commission and the need to exercise that power with a very clear concept of fairness and justice and in the public interest, in the sense that if the Commission would enable the public to see that the problem of corruption nationally in Australia was being addressed appropriately. And all that I appreciate is not something that you can put in a KPI with figures, but I would hope and expect that the NAC, as it is envisaged by this bill with the improvements that we've been speaking about, would be a body that could project itself in that way, and it could be seen by the public in that way, because it would enable the public to understand what it was doing. And that is a very important part of the very important reason why public hearings are themselves important.
Thank you. And you made one comment about New South Wales' experience with public hearings, and appreciate it was embedded as part of a broader comment. But you mentioned that New South Wales don't have a problem with the public hearings, and I was just wondering from whose perspective you're making that reflection.
I'm not sure that I made that reflection, but I would accept that the ICAC has handled the issue of public hearings on the whole very well, and that many of the criticisms that have been made of ICAC and its public hearings have been misconceived, indeed in some cases deliberately so. The fact is that of three very public figures that have been subjected to the publicity of an ICAC investigation, Mr. Greiner, Mr. O'Farrell and Ms. Berejiklian, all of them have moved on, and you couldn't say of any of them that their careers have been damaged by their experience with ICAC. Mr. Greiner is a respected businessman. Mr. O'Farrell is a high commissioner in India, and Ms. Berejiklian is now on the board of office. Just three examples, I think, of the way that which illustrate that a public hearing certainly does not necessarily result in public opprobrium. and indeed may be the means by which an innocent person has his or her innocence brought to the public attention in a way that would not otherwise be done.
Thank you. And just one last question from me. With respect to journalists and the issuing of warrants, I understand that in the UK, for journalistic material subject to contested hearing before a judge. Do you have a position on contested hearings on such warrants or on the issue of who should hear warrant applications?
I don't think that there is any reason to quarrel with the UK position. It is difficult to define who is a journalist, particularly in this day of people who set up blogs and then purport to be public spokespeople. There's nothing necessarily wrong with that, but it does create a difficulty in definition, and that itself would sometimes at least mean that the person seeking to obtain a warrant might have some problem, but I can't myself quarrel with the position that's been taken in the UK.
Thank you.
Thank you.
Sorry, can I just add on that? I think it's pretty clear it ought to be a judicial officer making those decisions, and the CPA, I think, supports that position directly.
Yes.
Thank you. I appreciate that note.
Thank you. Senator Scarr?
Thank you, Chair, and thank you to the witnesses for appearing today, and thank you for your advocacy in relation to these issues. First, there are three areas I'd like to ask some questions upon. The first is in relation to the Joint Standing Committee and the makeup of the Joint Standing Committee. And Mr. Charles, you've put a very good argument as to the makeup of that committee. I just want the opportunity to test those propositions, if I could act as somewhat of a devil's advocate, if I may, whilst deeply respecting your view. And I say this as someone who's served on the Joint Standing Committee in relation to public accounts and audit in the last Parliament. And the Auditor-General reports to that oversight committee, as does the Parliamentary Budget Officer, and they're both independent positions and highly important positions. And the makeup of that Joint Standing Committee is essentially the same as the makeup proposed under this bill, insofar as there would be, on paper, a majority able to be garnered by the government using the casting vote of the chair. But in practice, the tension, the political tension is such that that committee, as far as I know, has always come to a unanimous decision with respect to recommendations for appointment to the position of Auditor-General or Parliamentary Budget Officer. And to some extent, that would be reasonably expected, because it's not in the interest of government to propose someone who is so unqualified or unsuitable that a balance of the committee would vote against and file dissenting reports saying that the Commissioner were inappropriate, and the majority of the government rammed it through. Can you understand the practical political consideration that perhaps provides a practical safeguard if, on a theoretical level, your observations are absolutely correct?
If that is so, then that's a very satisfactory situation. But if the situation is that ordinarily you reach a happy consensus about important matters, then might not exactly the same thing happen if you had not the government in control. Secondly, that happy consensus may not always continue to exist.
It's true. And they're both legitimate points. I'd like to move on to another area, and that is in relation to the inspector. And Mr. Charles, I think it was in your opening comments, referred to the importance of the role of the inspector. And I just want to put a few propositions to you, Mr. Harper, and any other witness who wishes to comment in relation to this matter. And I want to quote to you from Mr. Bruce McClintock's submission to this committee. And he says, and I quote, "In my experience as Inspector of the New South Wales ICAC, the Northern Territory ICAC and the New South Wales LECC, the probable performance issues in relation to an anti-corruption commission are," and then he lists 4. A, failure to give adequate reasons for conclusions of misconduct, to use a general term, made at the conclusion of an investigation. B, failure to accord procedural fairness. C, failure to consider the rights of persons not under investigation and so cause reputational or other harm to them. An example is the failure to respect the rights of innocent counterparties to communications intercepted by the agency. And D, investigation failures resulting from incompetence or lack of training on the part of agency staff. End quote. Would you agree that from your perspective, Mr. Charles, and I'll seek the view of other witnesses, that those are certainly 4 areas where we should make sure that the inspector has the ability to oversee the conduct of the Commission to mitigate against those eventualities occurring?
Absolutely. In every case, they're very important. And you certainly, I know Mr. McClintock is a very well qualified and experienced inspector, and I agree absolutely with every word he said.
Okay.
And could I add that I also agree with every word that he said?
Well, I should give our. Can I give our last witness an opportunity to provide an opinion?
Look, 2 very learned commentators, but I can tell you that I fully agree, and I'll just add, Senator, to it. The personality and the capacities of commissioners and inspectors and members of parliamentary oversight committees is really, really important. In Western Australia, I know the CCC had a former governor of the state, but he was still at the bar, Malcolm McCusker, as the parliamentary inspector for a period. And the points that you have mentioned, at least some of them, certainly came out of reports that he made to the Parliament. So there's no doubt. I mean, a well-functioning anti-corruption commission has to meet those criteria.
Excellent. Thank you. Mr. Charles, in that respect, Mr. McClintock submits that it is important that the inspector have the ability to audit the operations of the Commission. So instead of simply reacting to complaints, that the inspector actually has a more proactive role in terms of auditing the operations and oversight of the operations. Would you agree with that submission?
Yes, I would.
Okay.
I have never been an integrity commissioner or an inspector, but it sounds absolutely right to me.
Okay, thank you. And then lastly, with respect to the submission with respect to this issue, Mr. McClintock says that it's also important that the inspector not be part of the Commission itself, but actually be independent of the Commission itself and resourced independently of the Commission. Would you agree with that as well?
Yes, I would.
Excellent.
Totally.
Excellent. Can I ask you, and I know all of the gentlemen who are providing evidence today have put an outstanding contribution into these issues as part of our civic debate in relation to this. Mr. McClintock in his submission does propose a clause in relation to the functions of the inspector, and he actually proposes some drafting. Could I ask you to take on notice to review that clause? It's on pages 1 and 2 of his submission. Is that something you would be able to do, gentlemen?
Yes.
Sure.
Okay, thank you very much. Lastly, in relation to the inspector issue, the Victorian Inspectorate has submitted that any exercise of coercion, coercive powers should actually be reported to the inspector as a matter of course, so that the inspector is aware of the use of coercive powers by the Commission. Is that something which you would agree to, Mr. Charles, that the inspector should be, when the Commission exercises a coercive power, that the inspector, as a matter of course, should be communicated of that exercise of that coercive power?
Yes, I do.
Okay, thank you. My last area of questions is in relation to the privilege against self-incrimination and the privilege relating to legal professional privilege. And I'm a lawyer, but I'm not in your ballpark of expertise in terms of the witnesses who are providing testimony here today. So the Law Council of Australia has made a submission where they make a number of recommendations in relation to the abrogation of the privilege against self-incrimination in the first hand, and also in relation to the abrogation of legal professional privilege on the other hand. I'm not proposing to go through those recommendations necessarily on this call, but again, if you could take on notice the recommendations which have been made by the Law Council of Australia in those respects. There are 3 in relation to the privilege against self-incrimination and 2 in relation to the abrogation of legal professional privilege. I'd be very interested in your opinions with respect to those recommendations. Is that something you could possibly do?
Yeah.
Okay. Thank you. Thank you very much, gentlemen. Thank you.
Senator Shoebridge.
Thanks, Chair, and thanks to each of the witnesses, not only for your attendance today, but for the work you've done over many months and in some cases years in this space. Could I ask you if you have a view about whether or not this federal legislation should pick up the provisions that are found in, say, for example, the ACT integrity legislation that prohibit former politicians, or current or former politicians, from taking on the role of commissioner. Do you have a view about that, whether or not that would strengthen the public's perception of independence?
Well, let me start out while the other two think about that. It's a very interesting provision. The whole point of having a Federal Anti-Corruption Commission with the sorts of terms this has been set up under, including the comments that have been made about who should chair a Parliamentary Oversight Committee, are all about reassuring the public that this is, in that sense, free of politics, it's bipartisan. They're there to ensure that we have good government in our country. There's been a lot of debates about political appointments to a variety of positions. Sometimes there's debates about judicial appointments to high courts and the like. There's been debates in recent times about appointments to the Administrative Appeals Tribunal. There is a risk that if there is any sort of conventional practice or something that starts coming about, that former politicians find their way onto an anti-corruption commission, that would eat away public trust in this body. So I think that one should avoid those appointments. Whether or not you put it into legislation, that's an interesting question, which I haven't otherwise seriously thought.
Mr. Charles?
I think that many politicians are of the highest integrity of both sides of Parliament. But one, I think, we were asked about the KPIs of the Commissioner. I would have thought that it's essential that the Commissioner be totally non-partisan for every kind of appearance, which I should have thought mean that as a general rule, and if necessary by statute, you should say that no former politician be a commissioner.
Could I take you back to some questions that were put to you, I think, at the beginning of your session about the Victorian IBAC? Have you had the the benefit of having a look at their most recent annual report from IBAC, where I think at page 6, the IBAC complains about not having best practice legislation. And in fact, I'll quote from it, from the annual report, saying, as it stands, elements of IBAC's legislation cause investigations to be unnecessarily delayed or frustrated by lengthy litigation because we're unable to gain access to crucial evidence and information. It goes on to say that in addition, the recommendations we make arising from investigations are currently required to be made in private and can only be published in special or annual reports. And then requesting legislative reforms in Victoria that match the kind of powers and legislation found in other states. Are you aware of those raft of concerns, if I could put it in that way, about the restrictions on the IBAC
Yes, certainly. I am aware of them, and I share the Commissioner's views. In my view, the IBAC legislation, in a number of ways, is not fit for purpose at all. It starts because of the thoroughly incoherent form of the original 2011 legislation, which was really constructed with a view to failure. It's only because of being part remedied in 2015 that it's been able to function. And it's still large areas. Its jurisdictional level inadequate for it to be able to examine fault parity, for example. The delays in providing reports is something which must be changed and can. And both areas are among those in which the legislation is certainly not at the moment fit for purpose.
In fact, it wouldn't be unfair, would it, to say that not just in respect of public hearings, but in respect of a number of other critical features about an anti-corruption commission, the IBAC is a case study in what not to do?
No, I wouldn't put it that way. I think that the present people working inside IBAC are doing a terrific job, as well as they can, on a somewhat inadequate structure.
Oh, Mr. Charles, I'm not speaking about the personnel. They're clearly striving to do the best they can. I'm speaking about the legislative underpinning, the legislative framework of IBAC. That's not where you'd start, is it, if you wanted best practice?
No, indeed not.
Mr. Barker, did you have any observations on the IBAC?
Well, this is probably obvious from all of us, haven't had the chance to pore through the various submissions. I noticed IBAC Commissioner has made a submission to your committee, and I think it might emphasise the point that Mr. Charles has just been making.
In terms of the best practice for an oversight committee, would the best starting point be to think not about a good government or a government and a parliamentary majority that are interested in transparency, but perhaps we should be crafting a NAC that has in mind a noxious government, a bad government, a government that does not want transparency and that may want to use a political majority to prevent an effective NAC. Do we make laws for angels or for reality?
I think you make laws for reality. One of the first things that you should bear in mind with the NAC is that it must have the ability of research and education, because one of the most important things is that it should be able to educate the public service and getting them back to the level where they are able to give frank and fearless advice without fear of losing their jobs. Certainly, I think there are reasons for thinking that not everyone in government is angelic.
You see, Senator Scarr put to each of you the proposition that there's currently an oversight committee looking at public accounts and it has a good culture. But if we're going to pass legislation for a body with the powers that we're proposing for the NAC, good structure, good law should be our goal, shouldn't it? Not reliance on hoped for positive culture.
The Auditor General is doing a terrific job on limited means and with limited numbers of investigators. He certainly performs part of the function that we would be hoping the NAC will be able to and will undertake. He is essentially engaged in an auditing and accounting function, which he does very well. And what we are looking at is potential misbehaviour in a wide variety of ways.
Have you had the opportunity to look at the parliamentary oversight, the legislative oversight model in the ACT of its integrity bodies, its parliamentary officers more broadly, which has a non-government chair and currently, for example, has an opposition chair in the ACT as a potential model?
I haven't looked at that, but it comes back to the broad principle. When the Senator put those questions, and I was listening to the discussion about it, sure, realpolitik can work its way out. You would imagine on something as important as public accountability and the operation of an anti-corruption commission at the federal level, that all major parties, all members of parliament would see the sense in making sure it works, regardless of who the chair is. But if you're wanting to ensure or reassure the public about the independence of the organisation, then the comments that Mr. Charles made are quite relevant. I have to say, as I've been listening to all the noise that comes through my end of the broadcast today, I'm reminded when I was about 12 years of age, I tried tape recording the family roast on a Sunday, and the only thing I heard was clattering plates and cutlery. I don't know what's happening in the committee room, but it comes through very loud here.
We're sorry about that. No one's consuming lunch, I think, at the moment, that I can see.
You're not the first witness to make that observation.
We'll all sit very still.
Could I add to the opening comments in the last area of discussion? I agree entirely that structure and culture are enormously important if we are to avoid the consequences of the marvellous aphorism that all power corrupts and absolute power corrupts absolutely. The only way to prevent the corruption of power is to set up structurally organisations and committees that can, with a well-developed, carefully considered and embraced culture, remove, so far as possible, the consequences of power going wrong.
Thank you all.
Mr. Lim?
Thanks, Chair. Thank you for your submission. In your submission in the section titled Contribution to Public Trust, you use public sentiment and study as a barometer as to whether hearings should be held in public. Is there a view held in your profession among your peers that hearing may yield stronger result from hearing being held in private?
We certainly take the view that hearings in public inform the community about what is going on and what is being investigated. It educates the community. It should educate the public service as to what is happening. And conducting a hearing in public also results in witnesses coming forward to give evidence about the matter that's being investigated who were not previously aware that the investigation was taking place. In all those ways, we think that the publicity of hearings is highly in the interests of the public so that they know what's going on. In other words, that you are not having secret Star Chamber proceedings. but the public is let into the secret and knows what's going on.
Thank you.
There's no doubt, in my view, that come back to that old saying that the best disinfectant is sunlight. So many examples of the public hearing which brings to public attention something that they can hardly believe. Might be aware of a case in Western Australia relatively recently where a senior public health servant, official, was eventually charged but also came before the Triple C here because he was rorting entirely the system. He was stealing money. He was spending it on horses. And it raised the whole question of how public finances are managed within the public sector. On its own, it was a very important and salient example of what can go wrong. But it's hard to believe that in this part of the 21st century, these things are still happening, even though we've had major public inquiries in Queensland, Western Australia, New South, all the states about public misconduct of that type, as well as public maladministration. And having it in the public hearing really helps to inform the public. It can flesh out further instances of what's happening, and it is critically important to reinforcing the rules by which public administration must be conducted.
Thank you.
It's just a follow-up. So thank you. I certainly take the point that your goal is to build greater public confidence and trust in government through the work of the Commission. But would the publication of the Commission's reports where corruption has been found and the timing of the release of those reports being subject to criminal proceedings having concluded or whatever caveats may be in place, but would that not then achieve the same result without necessarily having to always default to a public hearing?
No, but partly because you will not get a report usually until long after the events have taken place. You won't know what's going, maybe until years after the event. In the coalition's proposed exposure draft, you wouldn't in that case, in cases where there was a suggestion of a criminal offence taking place, you wouldn't have heard of it until a prosecution actually started in court, which might have been 3 or 4 years after the event had taken place. It's too late and it's not effective, and most people don't read reports.
Thank you. Have you finished?
Yes,
yeah, thanks. Senator Chandler?
Thank you very much, Chair, and thank you to all for coming along today and for your testimony. I just had a couple of quick questions. Now, just let me confirm, Mr. Harper, you're here today on behalf of the National Integrity Committee of TAI. Is that correct? And the rest are from the Centre for Public Integrity?
That's right.
Yes.
Wonderful. And just interested from Mr. Harper and someone from Centre of Public Integrity, do your organisations engage much on social media?
Sorry, what did you say?
Do your organisations have social media accounts?
No.
I think we do.
I don't think we're looking at the social media team anyhow.
Well, I'm glad you said that, Senator Shoebridge, because that was just what I was keen to get to the bottom to, was if there were social media accounts associated with your organisations, whether or not any of you were running them. But I don't want to answer the question for the witnesses.
Sure. Well, the committee certainly does not. The committee is associated with the Australia Institute. I'm not sure what arrangements the Australia Institute has, but the committee certainly has no arrangements for other kind that we just mentioned.
Thank you very much, Mr. Harper. And someone from CPI?
Well, I'm not too sure what a social media account is.
Well, I am,
There's a lot
Senator.
of Twitter, Mr. Charles.
I am, but I've just while you've been asking the question, done a quick search on Facebook, and the Centre for Public Integrity seems to have a Facebook page.
Right. Do you have a Twitter page?
I think we might, but let me have a look and tell you. I'm trying to disprove that unfair comment that we wouldn't know what we were doing.
What happens, as far as I'm concerned, is that the CPI frequently gets either investigates something and puts out reports, or alternatively becomes aware of matters that are being discussed in the press, and it receives repeated requests from members of the media, and we are asked to respond to those requests.
I can tell you, Senator, that we do have a Twitter page, and it says appearing before the Joint Parliamentary Committee on the National Anti-Corruption Commission with public hearings, scope, jurisdiction and whistleblowers protection up for discussion.
Oh, it's very, very up to date then, isn't it? I was just wondering whether you knew who within your organisations does run those social media accounts. That might be a question that you have to take on notice, given we just have to Google whether or not they existed in the first place.
Well, certainly, given my distance, I would have to take. I can tell you, as I have said, the committee itself has none of these things.
Mr. Barker or Mr. Charles, were either of you aware of who runs those accounts for Centre for Public Integrity?
I'm not aware of them, no. I've never been on Twitter.
I haven't spent much time there either, Mr. Charles. I was just interested in knowing who was running those accounts, just, looking at some of the things that have been put out by them in the past, and just making sure that we are very sure that there's no perception of bias of your organisations, because you've obviously come here today saying that they are apolitical, and just making sure that that is all stacked up through what is on your social accounts. But if you could perhaps provide that information to the committee on notice, that would be appreciated. Thank you, Chair. That's all from me for now.
Thanks. I've just got one follow-up question. You propose that the limited functions of the parliamentary committee will be undermined if the chair of the committee has a casting vote and if the chair is from the government, I think. And there's been a range of those questions about that. I guess I want to ask you what your view is about the alternative, but bearing in mind, say, that NAC is likely to be investigating historical matters, and so the chair of the government might not be the government that is being investigated by the NAC, or the regime might have been different. And so when you say the government could be biased, couldn't, if it was the opposition, be even more biased in the appointment, say, of the first commissioner, because they're looking it's likely that the first inquiries are going to be retrospective. And similarly, if you put how far do you go is my question, because you could also say, well, let's look at these independents. All the time during the last government, somebody might have voted with the government 9 times out of 10. So how could they be independent? And similarly, could you not go onwards and onwards about that, particularly when you look at it at a point in time? And so when can you consider, I guess, those sort of criticisms, and are you ever going to be exempt from those criticisms? Particularly with somebody could mount those criticisms, and so why wouldn't you just go with the government of the day and take on what Senator Scarr has said and embody a culture from the start of cooperation and public good and review that takes the best interests of the Australian public into account?
Senator, can I come back on that one straight off? For myself, I think there's a perfect answer to that question. There's historical practice that's been pointed out. You can draw some precedents. It's really a question of asking what's preferable in the circumstances when you're dealing with public accountability, you're dealing with integrity, and are you more likely to engender that new culture if you have someone who doesn't come from one of the major political parties? People might differ in their opinions and answers to that question, but it's really a question of asking oneself, what's the preferable outcome for this area of regulation?
I think it gets back again to the question of structure. The best structure is the one that inhibits the improper use of power, and if the chair of the committee is a member of the government, that chair will have a casting vote that's much more significant than the casting vote of a chair where where the chair is not a member of the government, because that person won't have another 5 members of the committee on his or her side necessarily.
All the investigations of...
Not coming through, Stephen.
Sorry. All... Can you now? I don't think I'm muted.
No, you're right. You were just breaking up a bit.
Sorry. All the investigations of the NAC are likely to be retrospective, but only for a while will they be looking back towards the last government. Soon they'll be starting to look at the present government, and we've been making the same submissions to the Victorian government. Nearly all the government's oversight committees in Victoria are chaired by government members. The only one that's not is the Pandemic Committee. And in our view, that's undesirable, and we're making the same submission here as we are to them, that if it's to be an oversight body, it's probably preferable that the chair be a member of the present government.
I don't think there's any further...
If we've got time.
Yeah, we do have a few minutes. Okay. Mr Zapier.
Thank you, Chair, and thank you, gentlemen, for your presentations thus far. Just 3 quick questions, and I don't mind who wants to answer them. Outside of the respective state and territory integrity commissions, which other investigative bodies, to your knowledge, conduct public hearings in the course of their investigations?
Just about every commission takes place in public. The Hayne Commission was public from start to finish. There are a variety of commissions taking place at the moment. As far as I know, all are happening in public.
Yeah, they are commissions of inquiry as opposed to public investigations.
Yes.
Anyway,
yes.
Okay. Also, are you familiar with the changes made with respect to the South Australian ICAC legislation earlier this year? And if so, do you have any comments in respect to those changes?
Yes, the South Australian Commission never conducted public hearings before. It never had the power to. The Commissioner repeatedly complained about it. And the changes that were made in the South Australian Parliament took away most of the power that it had left.
Yes, I'm aware of what the changes were, but do you have a view about whether those changes were appropriate or not?
They were totally inappropriate and destroyed what was left of the South Australian Commission.
Okay, so lastly, I'll ask you this question. The South Australian Bar Association has made a submission. Within their submission, they say, and I'll paraphrase just one line only, hearings should be held in private, and it is imperative that public hearings should only be held in exceptional circumstances. Do you have any comment to make in response to the South Australian Bar Association?
I'm not particularly surprised by the submissions they make, but since they have no experience of an integrity commission in South Australia with the power to hold public hearings, I'm somewhat sceptical about them.
And could I add that I don't think any of us are suggesting that public hearings should be the norm. The default position will be private hearings, and certainly no public hearing should be held unless there is a private hearing preceding it that demonstrates that a public hearing is in the public interest. Most hearings in most commissions are in private, and we would expect that would be the case under the neck.
Yeah. Okay. Right. Thank you.
Okay, thank you for your attendance here today. If, as I think you have been asked to provide additional information, could you please forward it to the Secretary within 5 days from today? You'll be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to transcription errors. Proceedings are now suspended until 4:30. Thank you.
Thank you very much.
I think we want to have a private hearing briefly now. Sorry I've been a bit late, but I now welcome the representatives of the Accountability Roundtable and Transparency International Australia to give evidence today. For the Hansard record, would you please state your full name and capacity in which you appear before the committee? So maybe I'll start with Ms McLeod and then work round.
Thank you, Chair. Fiona McLeod. I'm a Director of the Accountability Roundtable.
Thank you. Mr Moore.
Thank you, Chair. My name is Clancy Moore, CEO of Transparency International.
Mr Zipka.
Thank you, Chair. I'm the Chair of the Accountability Roundtable.
See, I've got my glasses that I can't read anything. Professor Samford.
Yes, Professor Samford. I'm also a board member of the Accountability Roundtable and at Griffith Foundation, Dean of Law.
Thank you. And in the room we have Professor Brown.
Professor AJ Brown, Professor of Public Policy and Law at Griffith University and a board member of Transparency International Australia and Transparency International globally.
Are we expecting anyone else to join us?
We have Mr. Stuart Hamilton with us.
No, it doesn't appear to be on our screens at the moment, but anyway, if he joins, we'll join him in. All right, so although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to discussion. Professor Zivkak, I think you're first up.
Yes, thank you, Chair. And thank you to you and the committee for inviting us to provide a submission to you this afternoon. You will have a submission from us, which I hope that you've had a chance to read, or at least in these opening remarks, I don't plan to address the task.
So the microphone's a bit fuzzy. You might need to sit closer to it, so it's a bit hard to hear at this end.
There was some interference. There doesn't seem to be any more. So I just said that thank the committee for inviting us and indicated that I'll speak very briefly to our submission. And in doing so, I'll address two primary issues. Corruption. Secondly, public hearings. We're getting a lot of interference. Maybe. There's a lot moving there. Future. All right, I'll continue and hope that is. First, the definition of corruption. The breadth of the definition of corruption in the draft bill, and in particular the explicit reference to the concept of trust and abuse of public office and any conduct of a public official involved. I think constructively be extended to clearly cover the conduct of outsiders into induce lies or misrepresentation.
This is, it's really dropping out. We're catching maybe 1 word out of 10. Would it be useful to maybe try and come back online again and see if it works again? The Hansard's suggesting maybe what you could do is call on the phone number rather than through this. Might be a better idea.
I'd rather not do that because it's very difficult to participate if you're on a conference.
It is. That was better. We could hear you then. I don't know what it is, but it's drifting in and out.
So, Chair, you could still keep it on, but mute it and call so it's the audio and vision.
Yeah, that's true. You could mute it, keep it on, and but ring us so that we could hear your audio better.
That will take me quite some time. The static seems to have disappeared at the moment. Has it disappeared from your end?
It has. That's better. Yep.
Okay, well, I'll continue and hope that the static doesn't return. So, as I said, I'm going to deal firstly with the definition of corruption and secondly with matters to do with the conduct of public hearings. Roundtable, well, the breadth of the definition and the explicit reference it makes to the concept of public trust and the public office. And public official involves corruption of any other kind. I think that the definition can usefully be extended, however, clearly to cover the conduct of others, use of bribery or corruption, lies, misrepresentations. And in particular, we would like the definition to cover the conduct of outsiders if they conspire or attempt to corrupt public officials, even if they fail their conspiracy. So the first point there relates to the coverage of outsiders who may be engaged in corrupt activities. Next, as to public hearings, as you'll be well aware by the end of this day, Section 73(2)(a) provides that a public hearing will only be justified in exceptional circumstances. We think that that is too high a bar, and to maintain that bar will have substantial and adverse effect on the conduct of the Commission, and we indicate in detail in our submission what those substantial adverse effects may be. To avoid such effects, in our submission, we suggest 4 graduated alternatives. The utilisation of the words exceptional circumstances. So, to avoid such effects, the first option would be to delete Section 73(2). What that would mean is that the only criterion the Commission would take in determining whether or not just to hold a public hearing would be that the would be the public interest. The second option of the These are graded in priority order. Would be to replace them with
I'm sorry, Professor, we just can't hear you. It's really, we're literally getting one word out of 10 again. I don't know, is there anyone else that can do the opening statement and maybe we can try and work on this, or, but we just can't.
I could I've been having difficulty myself hearing, and so I'm certainly able to make a couple of comments, but I think that we want to be able to get on to the committee's questions.
Yeah.
If you can hear me, I would, obviously, as Spencer says, we've spent some time putting some effort into our submission, which I'm obviously happy to answer questions on. There are just a couple of extra things that we've picked up. Like we'd emphasise, again, like many other people, the definition of corrupt conduct. One thing that we'd actually be interested in is the definition of a corruption issue is when an individual is engaging in corruption or may be engaging in corruption. I think that there's two points we'd make. Always remember that corruption is a joint activity, and so it's not just concentrating on individuals. And the other thing we'd say quite strongly is that we need to identify risks of corruption. And so a corruption issue could be seen as an area where there's a risk of corruption, even if we don't know who individually may be being involved. And I can put that in writing. The other thing is in corrupt conduct, there are a number of people excluded from the definition of corruption in Section 8. In Clause 8, Subclause 2. And so there's a reason, obviously, for judges and gubernatorial officers to be excluded from this. But the thing is that, so what if there's a group of people who are planning to corrupt the Governor General or the Chief Justice of Australia, and they fail? But it's not even corruption if they are attempting to or actually conspiring to. So I think that the relationship between subclause 1, 2, and 10 needs to be examined. But we can put that in writing. The rest of it, of course, is that we have views about. It's very important that the government doesn't control the committee. And one thing that we suggested is that appointments and major decisions have to be involving a majority, including either a member of the government, the opposition, or both of the independents on the committee. But I think one way or another, however much governments would like to be able to control these appointments, there's much more trust likely to lie in the Commission if, in fact, key decisions are actually made by a joint parliamentary committee involving not just government members.
Thanks. We're happy to take the opening statement in writing, so if you want to send us that, we'll make sure that it's on the record. Professor Brown, are you going to speak for Transparency Australia, or is Mr Moore?
I believe if the line's good enough, then Mr Moore will.
Yeah. Okay, thanks.
Thank you, Professor Brown. Look, I'll try and keep it brief and leave plenty of time for questions and answer. But on behalf of Transparency International Australia, I'd like to thank the committee for the opportunity to speak today. Committee members, as we all know, corruption is the abuse of entrusted power for private gain. It can undermine good government, distort public policy, and lead to waste, mismanagement of resources, and exploitation. To be clear, though, the National Anti-Corruption Commission is the most important integrity reform that we've seen in the past 40 years. And our submission today details 5 key areas that will make the Commission as effective as possible in combating corruption. This includes the scope of corrupt conduct, whistleblower protections, independence and oversight, the need for a comprehensive national anti-corruption plan, and public hearings. Committee members, on the issue of public hearings, I think it's important to note that the holding of public hearings or partial public hearings will be important to build the public's trust in the Commission, bring new evidence to light, and investigate corruption effectively. And our research finds that the proposed legislation, as it stands, presents the most restrictive test for public hearings in the country. The requirement that public hearings may only be held where the Commissioner is satisfied that exceptional circumstances exist is not an accurate or useful threshold for this purpose. It poses dangers to the effective operation of the Commission, whether through tactical litigation or inaccurate political expectations. So Transparency International's three-point solution is to legislate a new best practice model around public hearings. And just briefly, this includes, firstly, we need to strengthen through greater clarity that evidence must be given in private if a public hearing might prejudice a person's safety or actual planned or likely criminal proceedings. Secondly, we need to empower the inspector of the Commission to independently verify that the Commission has appropriate procedures and safeguards to ensure that public hearings are only used when appropriate and to fully investigate any concerns that procedures and safeguards have not been followed. If the term exceptional circumstances is retained, we recommend a definition of that term to mean that on balance, the circumstances are such that it is A, either necessary or preferable, and B, appropriate for evidence to be given in public rather than private. On the issue of independence, we recommend that the Commission needs to have its own independent budget track and that the Commissioner, Deputy Commissioner and Inspector roles should be appointed by a special majority, for example, a 2/3 vote of the Parliamentary Committee, rather than appointed by the Government. We also strongly recommend establishing a whistleblower protection authority and greater protections for public interest journalism and confidentiality of journalists' sources. Finally, we urge the committee to follow the lead of the UK and the US and recommend the government adopt a coordinated, ongoing national anti-corruption plan to prioritise and sustain our national efforts. Thank you, Chair.
Thank you. Senator Scarr.
Thank you, Chair. I had some questions for Transparency International, but I'm also happy, and I'll provide other witnesses with an opportunity to provide their thoughts as well. First, can I thank Transparency International for the work you've done in this space. It's been most helpful. And one of the things I found helpful was the reference in the Transparency International submission referring to Mr Bruce McClintock SC's submission. And I just wanted to put to you some of the matters which have been raised by Mr McClintock in terms of that submission. And I think the comments which Transparency International made in their opening statement go to some of the concerns which he raised. So if I can just quote to you from paragraph 11 of Mr McClintock's submission. Quote, "In my experience as Inspector of the New South Wales ICAC, the Northern Territory ICAC and the New South Wales LECC, the probable performance issues," and he's talking about the National Corruption Commission, "are A, failure to give adequate reasons for conclusions of misconduct made at the conclusion of an investigation. B, failure to accord procedural fairness. C, failure to consider the rights of persons not under investigation and so cause reputational or other harm to them. An example is the failure to respect the rights of innocent counterparties to communications intercepted by the agency. D, investigation failures resulting from incompetence or lack of training on the part of agency." Would the witnesses from Transparency International agree that those are the sorts of concerns which the inspector would be right to inquire into and have oversight with respect to? Professor Brown?
I think the short answer would be yes. And I think you'll find that our submission, effectively, if in slightly different language, makes fundamentally the same points. I think what Mr McClintock has been able to point out, which as a member of Transparency International Australia himself, we're very happy to endorse, is that his recommendation is that the best current model for defining that jurisdiction, if you like, for the inspector is the Law Enforcement Corruption Commission in New South Wales sort of definition of scope of maladministration. I guess the key point that we're 100% in agreement on is the need for that complaint jurisdiction, if you like, to be focused on the legality, propriety, the use of powers, issues that will go to the core business of the Commission. And that's currently in the bill, it's clearly it's not defined at all, so it's an unlimited breadth of potentially of different types of complaints, and that's unnecessarily problematic.
Okay, so I just want to give Professor Sanford, do you have a view with respect to the role of the inspector? That list of issues which Mr McClintock outlined, are those the sorts of issues that you would expect the inspector to be empowered to look into and consider and to exercise his oversight function with respect to? Sorry, you might be on mute.
I didn't take note of all those things. I don't have the document in front of me, but they sound pretty well right. And if you like, we'll have ART will have a quick look and give any further thoughts. But yes, those are the scope that I think that most of us would agree with. And if there was anything, it'd be just detail.
Okay.
If I could just make an additional comment there, I think I can be heard now. We agree with those 4 matters that you raised and place special emphasis on the provision of adequate reasons and affording procedural fairness to all who appear before the Commission.
Excellent, thank you. Ms McLeod, did you have anything to add in that respect?
No, I defer to Mr McClintock's far greater experience of appearing before commissions and indeed his role in reviewing the New South Wales legislation post-Caneen, the Caneen decision, and would agree with his observations in the Broad.
Okay, so then Mr McClintock further in his submission provides a proposed clause for consideration in this respect, and it includes things such as the inspector has the following functions: to audit the operations of the NACC, to investigate complaints of agency maladministration or officer misconduct, and he actually provides definitions of those terms. Could I ask each of the witnesses to take on notice to review Mr McClintock's proposed clause and provide just your thoughts with respect to whether or not his proposed clause covers the sorts of things which would be helpful to be included in the bill? Would that be possible, Professor Brown?
I mean, I can give you a straight answer now, which is yes.
Okay. Okay.
Yeah.
Okay. And
I would follow that by, Senator, by saying it's yes from us as well, and I'd be more than happy to provide you with a more detailed analysis of this.
Okay.
Due course.
Okay, that'd be very useful. I want to go to the definition of corrupt conduct, and the Law Council of Australia made a submission with respect to one of the paragraphs in particular in terms of that definition. And I know Transparency International and the Roundtable have raised other issues with respect to the definition, but I'm interested in your views with respect to this matter in particular, because I don't think it was specifically canvassed in your submission. They raise a concern with respect to clause 8.1e, and I'll just quote the clause. It is any conduct of a public official in that capacity that constitutes, involves or engaged in for the purpose of corruption of any other kind, end quote. And the comment that the Law Council of Australia makes is, to paraphrase, and I'm happy for you to take this on notice, but they look at the other sub-paragraphs of the definition and raise the question as to, well, what is paragraph 8.1e intended to capture? And they find it difficult to, as one of my colleagues referred to identify the work of that subclause in the definition of corrupt conduct. And they then say, well, either the subclause should be omitted then because we can't see what it's intended to cover, or there should be some particulars included in the subclause, including potential examples, to make it clear with respect to what that subclause is intended to cover. Now, I'm happy for you to take on notice to give you the time to consider that in depth, but if you've got any preliminary observations in that regard, I'd just be interested to know what they were. Professor Brown?
Yeah, we're actually supportive of having that catch-all. We've always had the view that the definition of corruption in the Ackley legislation, which included that catch-all originally, was advantageous, particularly because, and with all due respect to the Law Council, the jurisdiction that's being created here is not simply a jurisdiction relating to what's lawful or not, particularly what's criminal or not.
Right.
One of the good things about the breadth and the flexibility of this definition, compared to the very detailed technical definitions that tend to dominate at state level, is that it's particularly appropriate for covering what may be grey area corruption or corruption that adapts. And I think that the submissions from the Attorney-General's Department explaining their decision to preserve that catch-all were quite on point. And similarly, I noticed that the Law Council would delete the words "could adversely affect" from paragraph 8.1a for similar sorts of reasons, because of its sort of legal imprecision. But I guess our point would be this is not just about the law, this is also about ethical conduct and about the ability to have a jurisdiction that will enable the Commission to go into areas that are not just about legality. And I guess the other thing that I would add on top of what the Attorney-General's Department said is that concepts of corruption as defined by the courts over time, including our own High Court, they do change, and appropriately so. We're not just talking about a sort of categories of technical that can always be identified with technical precision. In particular, if you look at even things like the classic common law offence of misconduct in public office, that changes over time despite it being a common law criminal offence. Because the standards and the context and the nature of the public trust that's being exercised and the nature of the conduct that is involved changes over time. So although this is happening within a legal framework, as the Attorney-General's Department explained, that does change over time. So with all due respect to the Law Council, we think that those particular aspects of this definition are actually some of its strengths rather than its weaknesses.
Okay, understood. Can I turn to another area before I give the call to other senators, and that's just in relation to legal professional privilege and privilege against self-incrimination. And they're obviously two privileges which are foundation stones of our system of justice. And the bill, in particular aspects, abrogates those privileges. The Law Council of Australia, in their submission, has made a number of recommendations with respect to curtailing those abrogations with respect to the privilege against self-incrimination and legal professional privilege. Could I ask the witnesses, if you wouldn't mind taking on notice the recommendations from the Law Council of Australia? If you want to provide an answer now, that's fine. But it is an area which I think requires careful consideration in terms of the abrogation of those privileges. So I am interested in terms of your general thoughts in relation to those concepts, but also your particular responses to the recommendations from the Law Council of Australia. Professor Brown, first.
I think it's useful to differentiate between those two particular sort of privileges, if you like. And I think, I do think, having had a chance to look briefly at the Law Council's submissions, I think there's a lot of merit in a lot of the submissions from the Law Council. I think it's got to be recognised in relation to legal professional privilege that the Law Council's job is to represent the legal profession, and therefore I think it's doing its absolute proper job of trying to maximise the extent to which legal professional privilege is always protected. And I'm sure that the committee and particularly the government and the Attorney-General's Department can work through all of those specific suggestions in a lot of detail to see where the government and the Parliament thinks the balance should lie.
But at least on the face of it, you see the merit, and so at least in general terms.
In considering all of those carefully, clearly. But the privilege against self-incrimination is a particularly important one. I think giving more consideration to derivative use in addition to direct use, if you like, of evidence is something that is also worth considering, even though we haven't put it at the top of our list of concerns. I think it's also particularly notable in the legislation that the protection against self-incrimination applies to basically preventing the evidence that's compelled from being used against witnesses in criminal matters or matters where a penalty is imposed, but not civil matters. And I notice the Law Council is suggesting that it should also be applied to civil matters. Again, it's a different balance to be struck there. I think, they're not issues to which our submission goes, but I think on that issue it's worth considering each and every aspect of those protection of those traditional privileges, and that's one that's worth the committee giving its consideration to.
The other witnesses, if you have anything to offer in those points.
Can I jump in here as perhaps the only practicing lawyer in this group? Of course, to remind the committee that legal professional privilege and the privilege against self-incrimination are client privileges. They're not privileges of the lawyers. So in that respect, they're common law fundamental rights that should be protected on behalf of clients, not on behalf of lawyers. But I note that the Human Rights Committee consideration of the impingement of those privileges was considered to be necessary and proportionate, and that I was President of the Law Council of Australia at the time that we were arguing various state and territory corruption bodies should not impinge on those privileges, and we essentially came to the view that we were making the argument because we needed to, but nevertheless, to be consistent with other state and territory pieces of legislation, there would be a necessity to protect derivative use but allow for the overriding of those privileges. I also note that the bill states that legal matters, including legal professional privilege, must always be heard in private under the, I think it's section 75.
So, Ms McLeod, are there any of I don't know if you've had a chance to look at the particular recommendations, there's 5 of them in total from the Law Council of Australia, and some of them are conditioned upon an acceptance that there will be an abrogation of as you say, those client privileges in certain circumstances, but there need to be certain additional safeguards. Have you had a chance to have a look at the particular recommendations from the Law Council of Australia?
No, I apologise. I haven't looked at that.
Could you possibly take that on notice and provide your views, if you'd be happy to do that? I'd be interested in your views, especially given your background.
Of course.
Thank you.
Can I just add one thing there? I think that we have to recognise that this is a standing Royal Commission, and the thing is that Royal Commissions proceed sometimes not fully appreciated by the lay public, and in the sense that a Royal Commission, standing or otherwise, sacrifices its capacity to convict an individual in order to understand the general problem that they're looking at, which is, of course, in this case, corruption. And so the thing is that there's often, because that Royal Commissions, standing Royal Commissions like this, are generally frequently chaired by ex-judges, people tend to think of them as if they are criminal proceedings. But I think it's important to recognise that courts and anti-corruption commissions do have different and overlapping functions, and that's where, of course, the issue of derivative use is very important. But I think it's important that people don't see this as a court, because it's set up for a different purpose.
Thanks.
Thank you. Thank you, Chair.
Thanks. Ms Lim?
Thank you, Chair. Thank you, Transparency International Australia. Thank you, Professor Brown. In your submission, you provide a diagram. The diagram figure 1. The diagram illustrates what is, in the view of your organization, the median recommended new best practice. Can you please expand on the specific criteria and circumstances for public hearing and evidence? Particularly, you have noted legal advice in red among the criteria. Does this genuinely differ from the state integrity bodies?
Yep, certainly, Mr. Lim. So I guess the key overall point that we're seeking to demonstrate in Figure 1 is that there is an enormous range in terms of the existing precedents for how public hearing powers operate, when they operate, if at all, across Australia. And that was referred to in the evidence that Attorney General's Department was giving this morning as well. The key thing that I think it's really important for the committee to note, which hasn't been widely aired, is the extent to which in this bill there is the first step towards a new, what could be best practice model for how public hearings operate under an anti-corruption commission. The reason for that is that the bill, and you'll see it there in terms of the Albanese government proposal, and the number of different criteria and factors that need to be considered, both in terms of the Commission's judgment as to whether a public hearing is appropriate for investigative purposes, and the fact that public hearings are already an exception to the rule in terms of a default requirement that hearings will normally be held in private rather than public, which is the little blue dot on Figure 1. But in addition to that, unlike every other piece of legislation in the country, and this is the red dots, the government has inserted, thanks to Section 74 of the bill, which hasn't received much attention, a requirement that evidence must be heard in private, under a very, very, very wide range of circumstances. I think our own view is that most of those circumstances are appropriate, and that some of them could even be beefed up a little bit more in terms of being made even clearer, because already in various parts of the bill, the two key criteria that public hearings should not be used if it might jeopardise a person's safety, their health safety, or if it would jeopardise potential criminal proceedings, particularly any relating to the issues under investigation by the Commission, that those two criteria in other parts of the bill, as we pointed out in our submission, in various other mechanical parts of the bill, get a higher degree of prioritisation, if you like, in the clarity of the operation of the bill. So there's a number of things that could be done to actually enhance and strengthen that set of criteria and those safeguards, which really do constrain the Commission very, very substantially compared to every other commission in terms of when evidence would have to be heard in private. The Commission would not have a discretion to say that this could be heard in a public hearing. Some people might think that goes too far, but that's. But I guess the key issue here is that, and this is the reason why this bill is so significant, is that in the tradition of the states and territories now in Australia, there's been acceptance that effectively what's being created is a standing royal commission, as has been referenced various times today, and in fact has really been referenced by members of parliament from all sides of politics and all sides of the debate, that's what we've accepted we want here, is something with the powers of a standing royal commission. Royal commissions don't have these kinds of constraints on their powers, but then they're not standing, they're not permanent. They're there for a period to do a specific job. So what we're really talking about here is a codification of the circumstances where there is consensus that a public hearing is appropriate, as opposed to evidence being taken in private. So this bill moves into entirely new territory. Dr. Haynes's Australian Federal Integrity Commission bill had already moved into this new territory. This bill moves it further into this new territory of codifying when public hearings should be used. And they're all detailed on our, on that chart, and we can, if anyone's unclear as to where it comes from after referring to our submission, then we're happy to explain where exactly in the legislation it comes from. But I think that the broad picture speaks for itself. The big question that is then raised is, why do you need an exceptional circumstances test at all on top of this entirely new approach and largely, if not wholly, appropriate approach in our view. But it does, but we have sought to emphasise that while there's a whole range of criteria there for why you would only be able to take that evidence in private and would not be able to use a public hearing to do it, on top of the discretion as to whether to have a public hearing at all, that it would be really useful and add some additional safeguard to make it crystal clear in section 74 that personal safety of an individual and not prejudicing, ensuring against any risk of prejudicing criminal proceedings are worth prioritising to that extra level.
Thank you for your comprehensive explanation, Professor. What are the specific provisions that you may include in this legislation to address the difficulties that Commonwealth agencies have had effectively administering the Public Interest Disclosure Act regime?
In this legislation? Well, I think, and there's been obviously been some reference to this earlier on in the day, particularly in the session involving Mr. Pender and the Human Rights Law Centre. And I'd also refer to the question that Senator Scarr asked about this. The ship has sailed in terms of the timing of this bill to actually rectify the whistleblower protection situation. Because the opportunity that was there for the government to fulfil the indications that it had given that it was going to match Helen Haynes's bill or the National Integrity Commission bills introduced by the Greens, etc., and include a Whistleblower Protection Commission function, for example. That decision's been taken in relation to this bill right now. So the question of how to improve the way in which the whistleblower protection regimes operate is a question to be picked up from the point of passage of this bill, in my view, because it's not clearly in everybody's interest and preference to get this done. So I guess the key, our submission spells it out, and I think Mr. Pender spelled it out quite accurately as well, that there's a wide range of reforms that need to be made to the substantive protections of whistleblowers, not just in the public sector but also in the private sector, because private sector individuals will come to this commission as well as needing stronger and consistent whistleblower protection in their own right for matters that got nothing to do with this commission. And so our submission really goes to the fact that the government's indications, very welcome indications, that it is going to at least pick up and start reforming the public sector whistleblower protections under the Public Interest Disclosure Act are absolutely welcome, as our submission says. But that is only one component of what needs to be done. Even if it is updated, and I should note that in the Attorney-General's second reading speech, he didn't actually make reference at that point to updating the approach to reform of the Public Interest Disclosure Act that would be taken post the Moss review to which Mr. Pender referred earlier. I believe that it's only logical that the government would do that, but if the government is going to do that, then this is really of extremely high priority to do it and to do it comprehensively and to do it as quickly as possible. That's the substantive protections on which the whole system relies. There was a lot of reference earlier on, and I've already made reference to the case for a Whistleblower Protection Commission or authority, whether built into this commission or as recommended by the last Parliamentary Joint Committee on Corporations and Financial Services that considered this in 2017, either as a standalone agency or associated or co-located with another independent integrity or regulatory agency. The key benefits of that would be not only to ensure a holistic approach to enforcing whistleblower protections, but really three practical sources of assistance, if you like, to agencies, as well as to whistleblowers. One is to provide the support to whistleblowers that to navigate complaint systems and integrity systems, including the NAC, as was discussed earlier. The second is actually that it provides assistance to all of the integrity agencies, including the NAC, to actually help function as a clearinghouse and a coordination point for the management of whistleblowers, which actually removes an enormous amount of practical burden from multiple integrity and regulatory agencies that currently have to try and manage people who are informants to them and potentially to others, and to assist agencies to navigate their obligations under the Act, including things like applying public interest tests to when this is a disclosure is in the public interest or not, whether or not disciplinary action or prosecutorial action, for example, is wise or not. And then the third is actually to make the protections real by actually creating a facility to investigate detrimental action when it occurs, which currently doesn't effectively have a function that's being fulfilled under our whistleblower protection laws, which is a huge gap and goes to what Mr Pender was saying about the lack of credibility of the current whistleblower protection regimes as long as that's in doubt or missing, which the Parliamentary Joint Committee in 2017 concluded it clearly was for the public sector and the private sector, but particularly for the public sector. And if necessary, to actually take legal action in support of achieving protections for whistleblowers, including their compensation rights if they have suffered detrimental action. So all those things are the practical jobs that are not currently being done in the administration of our whistleblower protection laws. And that's particularly why now the credibility of our integrity systems and any agency like the NAC, but also other regulatory agencies and integrity agencies, now actually hinges on being able to demonstrate that we have the machinery to make the whistleblower protections real, rather than them just being noble-sounding aspirations on paper.
I have the last question, only one more. Can you please take a second to outline for us any gap or perhaps any deficiency in the now out-of-date most review recommendations, and how can we build on this and strengthen NAC?
Certainly. I mean, I think that there are certainly parts of the Moss Review recommendations which are valuable. And in fact, some of them go to a question asked earlier on by Mr Wallahan about vexatious or misplaced complaints, and being able to create effective machinery under the whistleblowing laws to be able to properly triage, sort, filter, redirect matters that shouldn't be being handled under the legislation. That's an example of something that the Moss Review did pick up. Something that the Moss Review kicked the can down the road on very substantially was the question about whether the thresholds for achieving the protections, whistleblower protections, that need to be met, the circumstances that has to be satisfied before you could claim that you've suffered a detrimental action or seek compensation for it, were adequate or not. There was plenty of evidence in 2016 that they weren't adequate. The Moss Review simply recommended to defer that until there was more experience of the operation of the Act. Since then, there's more evidence to conclude that our thresholds, which even on an objective comparison with international recommended standards in Europe or by the OECD now, are out of date. And in fact, the Commonwealth has the most restrictive set of legal circumstances for when you were able to show that detrimental action has occurred to you as a whistleblower in the country compared to all the states and territories. That was a mistake that was made in 2013. It was then replicated in the Commonwealth's private sector whistleblower protections in the Corporations Act in 2019. And as Mr Pender said, the same problematic threshold has actually been replicated in the NAC Act because it's now been imported in there in Section 29 out of the PID Act. So that's an example of something that the Moss Review did not go to. It explicitly kicked the can down the road, and it's a clear example of where the need to do this job comprehensively, looking across all of the Commonwealth whistleblowing laws, not just the PID Act, is now a mission. We'll actually, when we fix those whistleblowing laws, we'll actually have to go back now and fix the NAC Act provision in Section 29, Clause 29 as well, to stop this infection of defective provisions continuing to spread through Commonwealth law, when in fact it should be going in the other direction. So I guess that's reinforces for me why it's so important that that the sights be lifted in terms of what the government needs to commit to if it's actually going to do the whistleblower protection law reform job properly at the Commonwealth level.
Thank you very much.
Dr. Haynes?
Thank you, Chair. Thank you to all of our witnesses for your submissions and your appearance today. Can I put perhaps to the Accountability Roundtable, given Professor Brown's explanation of the safeguards that are built into this NACC around public hearings, can you think of any legal reason, not a political reason, a legal reason why the additional threshold of exceptional circumstances would be there to hold public hearings, why that's been imposed?
Perhaps if I can jump in there. The Victorian Act includes exceptional circumstances, and no doubt the intention is to model that as somehow a stricter test than the existing norm of private hearings, with all of the considerations that Professor Brown has outlined. So, for example, by the time you come to consider whether exceptional circumstances have been met, as he's pointed out, there are the considerations of confidentiality of sensitive information in section 227. There's the consideration of public interest tests, the guidelines to meet, and all of the other considerations. So the only guidance we have in terms of what the provision means in Victoria, as the committee will be familiar, is the R&M case, the decision of the Court of Appeal, which effectively said that exceptional means clearly unusual and distinctly out of the ordinary. The problem is that if it's included in this provision, that doesn't give you much guidance, and it might also harken back to some earlier authority in the criminal sphere, where exceptional effectively means rarely or outside reasonable anticipation or expectation. So what you're going to see happening, I'm sorry if that background noise is me, what you're going to see happening is a commissioner in the first handful of cases will be very unlikely practically to meet a threshold of exceptional, because they won't have the body of work underway to decide whether something's really occurring or not. If you have a case that throws up a single example, whether it's very serious, which points to a certain culture or high incidence of complaints, as occurred in the Operation Ross matter involving the ballot police, that was the foundational case of R&M, how do you make a decision that there is a series of incidents pointing to that culture or culture of misconduct if you're at the early stages? And it does create a threshold which to us appears to be contrary to the objectives of the Act, which is to educate the public around corruption and to demonstrate the detrimental effects of corruption on public administration. So that's why we would say, amongst other reasons that we set out in our submissions, the exceptional circumstances test is unwieldy and unnecessary.
Thank you, Ms McLeod. Has anyone else got any comment on that, or does that?
Yes, I'll go with Fiona there. I think that the inclusion of the public interest test with the criteria and so forth and the exceptional circumstances is confusing. I mean, I think that it's fine to say that private hearings are the default position, and then here is in the public interest, the issues that have to be considered, whether it's going to be a public or a private hearing. I just think that it's confusing, and it also has what seems to be the logical conclusion that even where a public hearing is in the public interest, it'll only be done in exceptional circumstances. Now that's one way you might read those clauses. So I cannot see that it's of assistance politically, legally, or philosophically.
Could I put to you that if that was to remain, if the exceptional circumstances was to remain, when it comes to reporting from the Commissioner, that may indeed lead to fewer reports coming into the public domain as well?
I think that's right. There's a risk of it, which would be a great pity.
I'm just conscious that one of the arguments the Attorney General has made is that exceptional circumstances will not prevent matters coming into the public arena because the report will necessarily have to include a report on those things. But that argument suggests there's no immediacy, no need for immediacy in addressing issues as they arise at the Commission, and that they can wait for a report. But it also suggests that the hearing itself does not flush out further incidents. And in that very case, the Operation Ross case, that's the subject of R&M, the fact that there was a public hearing that was upheld, the challenge was upheld, the challenge was overturned rather in the Court of Appeal and not pursued in the High Court. The fact that the public hearing took place did flush out further evidence of misconduct by police, and that was a matter that was very important in terms of corruption in Victoria.
Ms Haynes, if I might just add to my colleague's points there, we're very supportive of the norm that public hearings will only be used as a sort of fallback. But I think the existing work around the public interest test can be improved as well. And currently, the bill states that under section 73(3), the Commissioner may consider those issues under public interest. We would suggest that that becomes mandatory. So when deciding when a public hearing should take place, they should mandatorily review all those criteria under the public interest test, and that would actually lift the standards for a public interest test and be a new best practice model as well. I think that's already in place in the Law Enforcement Integrity Commission Act, and I think it was actually proposed under your previous bill as well. So that's a specific recommendation we'd like to put forward to the committee as well.
It's a very strong safeguard. Thank you. Can I...
Could I just add to what Ben said here?
Yes, Mr Spencer. Mr Zivak.
Yes, thank you, Senator Haynes. The one thing that hasn't been said, and I think is important, is that there are quite sensible alternatives to the use of the term exceptional circumstances in seeking to justify whether or not public hearings should be conducted or not. You'll see in our submission, and I'll just run through them quickly here. There are, I think, 4 graded alternatives that are available. First is to simply delete section 73(2)(a), which would leave the only criterion for determining whether or not a public hearing should occur as being whether or not it's in the public interest. And that is a position that the Accountability Roundtable favours. If that were not to be considered quite tight enough, we could replace the word exceptional circumstances with the words necessary and appropriate, which would do almost the same job, but represent a slightly lower bar than that which is constituted by exceptional circumstances. If that were not considered to be adequate protection, we could word necessary and appropriate and bolster the provision saying in section 73(3), which are the criteria that the Commissioner must have regard to in determining whether or not a public hearing should occur, that the word may in that provision be a change to the word must. I'm following here in what's just been said, Mr. Moore. But finally, we also suggest that there is quite convenient and I think reasonable alternative, which will give appropriate protection to those who require a private hearing, but provide a basis for there being reasoned regard, having reasoned regard to the circumstances in which a public hearing can be. So the roundtable suggests that while the word exceptional be defined as being necessary, appropriate in the interest of justice and procedural.
Thank you, Mr. Zitkaft. Could I just turn the attention to the scope of corrupt conduct? Professor Brown, you recommend in the submission from Transparency International amending Clause 8 to confirm that corrupting actions of third parties can be investigated and reported upon even if the relevant public officials are not themselves aware that their powers or functions have been or are intended to be corrupted. Can you give me an example of when this definition would apply and what's excluded now?
Certainly. I think this goes to the issue that a number of submitters have made about the need to put it beyond doubt that non-government actors who attempt to or engage in conduct which could corrupt official processes is fully captured, as is clearly the intention under the bill. So we see this as being basically putting something beyond doubt as opposed to being an addition. And I think examples would be collusion that is intended to limit or manipulate the information that's being provided to government officials in a way that would cause them, in effect, to act differently, in some ways dishonestly but without their knowledge, in a way that would then favour particular individuals or lead to a particular outcome, in a way that on some definitions may equate to fraud, but is clearly corrupting, in effect, corrupting the exercise of an official's functions or powers in a dishonest way, and the impartiality of that person's powers. I mean, other examples of where conduct can adversely affect or could potentially adversely affect the integrity, as a broad term, of government decision making that are really, I think, appropriately captured by paragraph 8.1a, but it's worth putting it beyond doubt, are examples of where undue influence is being exerted upon government in a way that is not clearly guaranteed or likely to necessarily result in consciously dishonest conduct by the part of a public official, but it's just pressure, and pressure of such sort of systemic kinds that it will distort what is the lawful decision-making process or the proper decision-making process in a way that will effectively cause a corrupt outcome. So there are some of the things that are suggested in the Centre for Public Integrity's submission, or that are listed in great detail in some of the state legislation now as a result of the Cunneen decision. Those are the types of conduct that should actually be able to be investigated and stopped. But I think with this broad, flexible definition that goes to first principles, all that needs to be made explicit is that the public official themselves doesn't actually necessarily have to be aware that that is what is going on in order for it to be investigated and be able to be rectified. And I think that if that was put beyond doubt, then then the spirit of this definition, which is broad and flexible, would be maintained without adding lots of specific examples, which is what the state legislation tends to do.
Thank you.
Could I just add to that too? I agree with Professor Brown that what we're seeking to do here is clarify the meaning of Section 8.1a rather than amend it or change it significantly. And so, for example, the definition ought to extend clearly to cover the conduct of outsiders who use public officials to engage in forms of corruption, including bribery, coercion, lies, and misrepresentation. Beyond that too, and very unclear whether Section 8.1a would cover any of the following, it's also important to cover the conduct of outsiders if they inspire or attempt to corrupt public officials. And even if outsiders are only attempting to inspire or attempt to corrupt public officials. And those attempts to corrupt public officials are themselves unsuccessful. That does not remove the responsibility of outsiders from possible inclusion in the definition of the corrupt conduct in Section 8.1a. So, conspiracy and attempts to include corrupt conduct by outsiders in collusion with.
We're having problems again hearing you, Mr. Zivkak.
That's unfortunate.
It's in your submission, though, the points that you're making, so we'll refer to those. Thank you so very much. I think it's someone else's turn.
Yep, it is. Senator Shoebridge.
Thanks, Chair. And thank you again for all the work in your submission and leading up to the submission. To you, Professor Brown, and then perhaps to the roundtable. I hear what you say about wanting to clarify the meaning of Section 8.1a, but the evidence, as I understood it from the Attorney General's Department this morning, was that they were pretty clear about it. They wanted to exclude a collusion or or jurisdiction where there was no intent to affect the honesty or the integrity of an official, and they were quite clear, as I read their evidence, that the intent of this bill, as drafted, was to actually not have that covered by the NAC. Did you hear that evidence?
I did. I don't know that I interpreted it quite the same way, but I think that's all the more reason why we should put it beyond doubt that it does. Because I think even if it's arguable that the honesty of an official's conduct can't be affected without them knowing or being involved, and I think that's arguable. I think people's honest conduct can be influenced without them knowing that their honest conduct is being influenced. But certainly the impartial exercise of public officials' functions and powers, etc., can be influenced without that public official actually being party to a corrupt transaction or being themselves involved in a breach of duty because they simply aren't aware or aren't fully aware of the extent to which they're being manipulated, in effect. So I think it's worth putting it beyond doubt. I wouldn't agree. If that's how you've interpreted what the Attorney General's Department is saying, then I would say that's reason to put it beyond doubt that interpretation is not the way in which the Act would be interpreted, because I don't believe that it is that's clearly the result of the current wording, and I think we should put it beyond doubt that it's not the result of the current wording.
I'm not arguing against you trying to stretch the meaning of the current wording to include it. I think that's, heroic and worthy effort. What I'm suggesting to you is, though, the evidence we got from the department this morning, and it seems to reflect the position the attorney has, is that unless there's an effort to actually create some kind of dishonesty or improper performance with some kind of intentional element to the improper performance on the part of the public official, that the government's intention is that's where the line should be drawn on the jurisdiction. I don't know if Mr. Moore heard the evidence of the Attorney General's Department this morning, but I'd ask you, if you could, to reflect upon that and maybe provide an answer on notice. But could I go to a different point, which is, do any of you have a view as to whether or not it's appropriate to allow a former politician to be a commissioner? The ACT legislation, the equivalent in the ACT, for example, expressly excludes former politicians from being commissioners or deputy commissioners. If we're going to set this body up and seek to have it to not only be, but to be perceived to be independent of politics, do you see merit in adopting the ACT provisions and excluding current or former politicians from being commissioners?
We would favour that exclusion, Mr. Shoebridge. Yeah.
Thank you, Professor.
Can I just say, look, I largely agree with that. I think it's a matter of principle. If you've got an appropriate appointment process, there almost certainly will not be chosen. There is one thing, though, of course, is that a former politician, how much former? I mean, there have been some judges, very, very good High Court judges, who have actually, in their youth, have stood for party political appointment, but have become particularly strong judges later on. And so, I mean, maybe the thing is that if you were going to have a exclusion, you might say after 10 or 20 years or something. But it's just it can be very different. There's some people who become warriors 30 years later. So I wonder whether in fact you can handle that by whether you need that, or whether in fact a good appointment process, which is cross-partisan, would actually pick up anybody who's a problem.
Well, Professor, to be clear, that the line that's drawn in the ACT was once a member of, but was elected and served as an elected representative. So was a member of Parliament or a member of the Assembly. It's quite a different thing to at some point being a member of a political party. Would you agree, Professor?
Well, I was thinking of those who actually had stood for office, and some High Court judges who were later very, very independent. Yes.
Professor Brown, you were indicating, I think, concerns about the drafting of Section 74, which is a blanket prohibition. Do you have a form of wording that might make Section 74 acceptable? And this is the provision that says that evidence must be given in private if it discloses legal professional privilege or the like.
I mean, what our submission suggests is that, in fact, what should happen is that should remain the same, and that consistently with other parts of the bill, that rather than being just relegated to the definition of sensitive information under clause 227, subclause 3, that those considerations, personal safety and prejudicing criminal proceedings, should actually be elevated and excluded explicitly in clause 74 to make that clear. I mean, I noticed that Centre for Public Integrity recommended that clause should be changed to evidence may be given in private if giving the evidence would. I mean, our view is that has always been that this was the opportunity to codify the public hearing power of a Standing Royal Commission in a way that institutionalised the criteria for when public hearings, public evidence should be taken in public. So we think that actually having a section that actually says, that then adds a level of safeguard over the top of the existing general public interest test to make sure that these things, that actually codifies when the evidence should be taken in private, must be taken in private, is a step in that direction.
Well, perhaps the other alternative is you take exceptional circumstances out of Section 73 and you move it into section 74. If there is a place for exceptional circumstances, it's probably in section 74, isn't it?
I think it'd be a different test in a different location, I think. I think the thing about exceptional circumstances in general for the holding of any public hearing is, as it's been discussed, is it just doesn't add anything. Yep. It only adds complexity and difficulty. And that effectively what should replace that, if it's really needed, in order to explain what is meant by exceptional circumstances, is other enhanced
I'm now
safeguards
persuaded
and
exceptional circumstances should not be in the bill.
Go
I'm
on.
now persuaded entirely. Could I then just ask, there is no obligation under this bill for there to be public reporting even when there's a finding of serious or systemic corruption. Now that seems remarkable to me, that the NAC can go to all the trouble of having an inquiry, can make a finding of serious or systemic corruption, and then there's no requirement for that to be reported publicly. Do you have a view about whether or not, if there's a finding of serious or systemic corruption, whether or not, at a minimum, that should be made public?
I think there's good reason to look at making sure that the triggers are there to make sure that what should be public is likely to become public. I think if you compare this bill to all the rest of the state legislation, you won't find a requirement for the guaranteed publication of any particular kind of report. You will only find powers in the Commissioner to be able to publish if it's in the public interest. So there could well be an argument for going further than the state legislation. That's the same with New South Wales ICAC, for example. It's the good thing about this bill is that the Commission does have good powers to publish a report if it thinks it's in the public interest to do so. There's the strange provision that is confusing, and I noticed this in the Centre for Public Integrity submission in section 157. There's a reference to a 3-month period after a report is given, which appears to make no sense and should probably just be deleted, and that then the Commission would have maximum flexibility. It has to satisfy natural justice, it has to satisfy all the procedures. In certain circumstances, it has to give the report to the relevant minister, etc., etc., etc. But it's got an open discretion, provided those things are satisfied, to publish what it needs to publish when it needs to publish it. In broad terms, this bill is much better structured and much clearer in providing various ways in which the Commission can make sure that it can report publicly. I think the key, because it's so difficult to define when the Commission should be lumbered with the responsibility of preparing and publishing a report, because there's a workload involved, and publishing, it's not always justified to publish a report as opposed to provide it to the relevant persons for action, to go through the rigmarole of publication. There will always be cases where, yes, corruption is found, and yes, it may even satisfy that required threshold of serious and systemic, but the action is underway, and it doesn't justify, for various reasons, including to protect people's reputations, doesn't necessarily justify publication. If there was one area, reflecting on this, and this isn't reflected in our submission, if there was one thing that could be strengthened to make sure that matters can't be swept under the carpet, it would be clause 158, subclause 1, which is currently the power of the Commissioner to be able to advise a person who made a referral what the outcome was. That could be changed to requiring that the Commissioner must advise a person what the outcome was, unless it's either impractical to do so because they were anonymous or some other reason, or exceptional, here's a good exceptional circumstances for you, or other exceptional circumstances exist to mean that it's contrary to the public interest to provide that outcome to a person. Examples of that could be a vexatious complainant or a vexatious litigant. But I think you would make that broad. But I think the principle that the Commission should report to the relevant persons should extend to should report to the person who made the referral unless there's reason not to. And then that would be a guarantee that it couldn't be swept under the carpet. So that would be, and that's just something that I've thought of in the course of the day while reading other people's submissions and thinking about how to guarantee in a sort of proportionate, practical way. And I think that would be a fulfilment of what the public expects from an integrity agency in this day and age. That's something that, it's not in our submission, but off the top of my head, might well go to rectifying that particular concern.
I'm done.
Can I just add one thing to that? I can imagine some cases, and again, this is the reverse of the public hearings. The default position would be publishing, but there can be reasons why not. And I was just thinking, just the top of my head,
You've dropped down.
corruption, and there are 5 people going to be corrupt, and they've sent out they've actually sent that to the DPP, and there are a number of others who were not sure about whether they're corrupt or not, and they're waiting further evidence. So that would be just one example where they would come to the end of an investigation, and there would be good reasons two good reasons not to actually publish that. And I'm sure there are others, which is why I think that this gives the discretion to the Commission, as it does in a number of other areas, and I think that's entirely appropriate, provided you've got a decent appointment process, which is suggested.
Thank you. Mr Wallahan.
Thank you, Chair. Thank you all, and thank you, Professor Brown. You've had the advantage of sitting through quite a few of these today, so I'd like to direct most of my questions to you, if that's all right, but anyone can jump in. We've heard from 4 groups now, so the Australia's Institute's National Integrity Committee, the Centre for Public Integrity, the Accountability Roundtable and Transparency International Australia. I want to thank you all for your detailed submissions and advocacy. It's clear all groups are passionate, but if I could offer one bit of constructive criticism. All 4 have engaged in hyperbole in your submissions, written and orally, and I'd like to take you to the examples here today in your submission and also in your evidence and in the Transparency International Australia. And then I just want to have a discussion that can maybe tie all this together about where we're at. I think that would be helpful. So if I go through some examples, and if you think I'm wrong, correct me at the end. So the first one, Mr Moore, if we could use this graph. Mr Moore, in his evidence, referred to the Albanese's model as the most restrictive in the nation, whereas on your own graph, if we assume that that's correct, there are others that are more restrictive. When you were referring to the subsets of the Albanese model, and particularly the parts in red, so from 14 through to 21, I think they're the 74 provisions, you said they were very, very wide and used the term very twice. In your submission, which is tab 46, if I could take you to page 6, under the heading of Public Hearing Powers Recommended New Best Practice, the point is made that 73(2)A poses dangers for the effective operation of the Commission, whether through tactical litigation or inaccurate political expectations, or both. Now, I'm not going to repeat the point that I went through for the Victorian example, but I would put it to you that that's just not allowed in Victorian courts, and it doesn't show out in the evidence. So I would say that that is hyperbole again, and I don't know what you mean by tactical litigation that otherwise would be allowed. And then if we continue through the report, actually your report might be, that's the end for you for hyperbole. And then if we go to the Accountability Roundtable.
Oh, I've got off quite lightly there. Oh, thank you. Thank you very much.
And then the Accountability Roundtable, if we go to page, doesn't have pages, but it's the one with footnotes 5 and 6 at the bottom. And again, on the same point, it says a third of the way down, It says, again, on public hearings, this internal inconsistency will no doubt encourage litigation to test the meaning of that phrase. Again, when we have examples in Victoria of 10 examples, and there's one key test, which Ms McLeod referred to, and then above that paragraph, and I know this is not your submission, it says, it talks about why would only politicians and the staff be entitled to such secrecy? Now, we know today this isn't a politicians' corruption commission. We heard from the federal police that said that 7,400 of their members are going to be subject to this. The entire public service are going to be subject to this. The entire military are going to be subject to this. And again, it's for effect to say it's about politicians, but it's not. It's about ordinary people who have ordinary jobs in the Commonwealth.
I'm going to object now. I cannot conceive of how any witness could fairly answer that. That's a statement. It's a lengthy statement. It's nothing like a question. And it is totally unfair to put 17 disconnected propositions to a witness and say, you're wrong, aren't you? I'd ask you to direct members to have questions, not statements.
Did we get to the question? We get your analysis, but this is a time for questions and it is 6:05. So can you cut to the chase?
Just about there.
Thank you. No, we'll get there right now.
I don't want to hear this, Professor Brown, but it's the truth. So
I'm all for questions.
On 6.
Why do I feel that this is not really for my benefit, Mr. Wallahan? I don't know why. But.
Well, we have an important task to do, Professor Brown, and we have 800 pages to consider. This is a monumental reform to our democracy. This is a very serious point.
But is it a question?
It is a question.
Okay.
I think we should be patient. And if we need more time, we're happy to have an extension for this whole inquiry. It doesn't have to be rushed. So not only is the point is repeated in the second submission about it being ambiguous and then how it could be used for tactical litigation. So my question is this. If we look at your graph, and I commend you on using graphics to explain concepts, I think there should be more of it. On the left side, in red or orange, just a danger, you've got totally restricted, no public hearings. And in a nice teal on the right, you've got unrestricted public hearings. And then right in the middle, in the lovely blue, is recommended new best practice.
I should point out, it's Transparency International blue.
Transparency International blue.
Just to be quite clear on
very,
some of the design
clear.
concepts behind our graphic.
Clear.
It should be green.
Very clear.
Just to be clear, should be green.
Now, if someone on the committee disagrees with what I'm about to say, they can jump in. But I think we can all agree there are very good arguments to have private hearings. There are very good arguments to have public hearings. And reasonable people can have a view on those. And it's really about policy, and we're talking about the law around that. But one thing that disturbs me in all of these submissions, there's a clear bent in the last 4.
Chair, I'm going to object again.
I'm about to get to the
a minute
question.
and a half ago, we were told there was about to be a question, and that was after about 3 minutes of introduction. We're about 5 minutes into this question, and I use inverted commas around it. This is not a question.
I'm at the
This is
point.
a statement.
I'm there, Chair.
Right, the question.
The question is this. Do you find it remarkable that none of the groups that have appeared today, when advocating for a broader definition of corruption or more public hearings, I haven't once heard arguments put about the cost of that being about the rights of witnesses in those public hearings. So this isn't a court, so I haven't once heard about the compulsion to appear, the no rules of evidence, must answer questions, no right to silence, and no presumption of innocence. Furthermore, the shame that comes on a person and the depression and potential suicide. Do you find it remarkable that all of those considerations haven't been put by any of the groups here today?
Can I reply to, I think, 2 questions that I have identified in your remarks there, Mr. Wallahan. In relation to your second one, I think you're incorrect. I think when early on in my response to particularly Senator Scarr's question, but certainly reflected in our submission, is the absolute imperative importance of getting the balance right between the protection of individuals' rights and liberties. And that's why we've made some positive suggestions for better ways to try and balance that, and why we've made a point of pointing out the extent to which this bill already does that in new ways that we think are really important policy developments. And so I think we all look forward to the committee's report in terms of the striking of that balance, but we fully agree, and it's fully reflected in our submission, that balance is imperative. We had the discussion before about not just legal professional privilege, but protection against self-incrimination, etc., etc. So, I think that's inherent in our submission. That's the search that we're all on. So I won't speak in relation to other groups. I think they're on their own version of that search, but certainly with respect to my own work and to the submission of Transparency International, what you've just alleged is not present in our submissions is in fact present in our submissions.
But on a lot of the other rights I mentioned, you mentioned legal professional privilege, I agree, but all those other rights, the court-like rights that are in a court hearing, we've heard about court-like transparency, but not the court-like rights.
Well, I don't think I've got anything to add to my answer, because I think we have touched on quite a number of those rights, and that's the issue that we're talking about, especially in terms of issues that are located in the red dots and in our submissions, red dots in Figure 1 and in our submissions. So I think we're actually on the same page there. We're just finding a way to vigorously disagree about whether we've talked about it or not. In terms of your first question about exceptional circumstances and whether or not it's everyone's been indulging in hyperbole when talking about that particular formulation creating risks of litigation that could affect the effectiveness of the Commission, or as referenced, and thank you very much, Mr Wallahan, for pointing it out, as referenced in our submission, the issue of political expectations, which hasn't otherwise been discussed. I think for the reasons that Ms McLeod pointed out, the fact that there has not been yet a case under the Victorian legislation which has created the kind of delay and frustration to corruption investigation in 10 years, which is only 10 years, and you already noted that the first 2 years it was, etc., only just getting operational, and it took quite a while before it actually had effective jurisdiction to hold public examinations at all, given the definitions, the defective formulation of the original Victorian legislation and the fact it wasn't actually amended until 2015 to make it feasible to hold effective public examinations. So that's not a long period of time. When you look at the experience of other commissions, especially in New South Wales, the litigation that's been undertaken in order to try and derail investigations or delay them or avoid the consequences has been very substantial, very significant. And
sorry, just on that point, but you're not comparing like with like. It isn't the most relevant example Victoria.
Well, we're talking about the risk of strategic litigation using whatever available means are there.
Well, with respect, all of the arguments on that. Are you
going to let me answer the question?
I'm just clarifying the question. Yeah. You'll have all the time to answer. But the point is about public hearings, Section 73. That's the test that matters, and that was the point at which the submissions were put in. There wasn't strategic litigation put for any other provision. That was the only provision it was narrowed to.
Well, I guess I think it's a question of why unnecessarily create another opportunity for that kind of litigation when it effectively that provision doesn't add any value, any substantive value. But if I could finish my answer, and I'm just very mindful of the very long day that the committee has had, that the other key consideration in our submission, that I'm not sure whether you were accusing it of being hyperbolic,
or some say hyperbole,
hyperbolic or not. Was the fact that this provision, this exceptional circumstances clause, is not just about that particular legal risk. It is very clearly serving a political purpose, and justifiably so. It is very clearly defining what the Parliament understands, and therefore what the public and the nation understand to be the circumstances in which public hearings will be held. And this is really the problem. The problem is that there is nothing wrong with what the Attorney-General has said in his explanation of this provision, that and similarly it's been welcomed by colleagues of yours from the Coalition when this was originally revealed that this would be the test, who used the language of saying it is good to know that public hearings will be the exception rather than the rule. There is absolutely nothing wrong with that. But the fact is that's not what the term exceptional circumstances does in the provision. It imposes a requirement, however problematic or not legally, that it will only be in extraordinary circumstances that a public hearing will be held. What we're suggesting is that if it is playing that political purpose or that policy purpose or that conveying that understanding in the public domain, that what we're talking about here is being very clear that public hearings are the exception rather than the rule, then let's at least define it to mean that in order to take away that legal risk. That would be the backstop. And so those political expectations are absolutely fundamentally important to the sustainability of the Commission. If half or a third or 2/3 of this Parliament turns around in 3 years and goes, that's not what we understood by exceptional circumstances, we're now going to gut this piece of legislation so this can never happen again, then we as a nation have a very, very big problem. This is the moment to actually identify what the consensus is that you all agree on as being what this provision should mean. I think that there is actually a consensus there, but the way in which it's put forward in the bill does not adequately reflect that consensus. This is the opportunity to make sure that that uncertainty is taken away in the future so that the multi-party support for this historic reform is actually locked in and not set up for a public or a political debate in a few years' time that will cause any of this to be undermined or wound back. So I would just add that whole dimension to why this issue is so important, in addition to the legal reasons which you clearly, Mr Wallahan, have reached a different view about. And in closing, I'd just like to commend you for the detailed analysis that you've given to the way in which public hearings and examinations, are or aren't being used, which I think is very useful. And I think it's very reassuring to know that we have members of Parliament who are devoting this amount of attention to these provisions because it is such a historic and important reform for this nation.
Could I finish on this question? Could you imagine, either in the NAC or a hypothetical corruption commission, a liberal public hearing test, so maybe even the default, but in that public hearing test, you get all of the rights that you would get in a court. The rules of evidence apply, the presumption of innocence applies, legal professional privilege applies, everything. What would that look like, and would that work?
That would look much more like a court. Mm-hmm. It would not look like a standing royal commission.
Of course, but for public hearings, so private hearings wouldn't have that, but for public hearings,
then it would look much more like a court.
But wouldn't it be more fair? Wouldn't it be fair to the person who's there appearing?
It would be a different standard of fairness for a different purpose. If the consensus of the Parliament and the nation is that what we want to have is a good standing Royal Commission model, then we're talking about Royal Commission type public hearing powers, which are different to the way that you just described it. That's the difference between a court and a standing Royal Commission. But I fully agree with you that ensuring the balance, that's why the privilege against self-incrimination, for example, or in this case, the inability to use the evidence in a court, at least in criminal proceedings, is built into the bill, as it is with Royal Commissions. So that's why that's there. I think we're agreed on what the question is, but if the Parliament and the country are going to stick to this model that we've now effectively pioneered internationally, and there hasn't been any questions about international experience, which I was really hoping for, but if we're going to now lock down at our national level what we've already created, which is a pioneering approach internationally by institutionalising a standing Royal Commission model for our anti-corruption specialist investigative agencies, then all those questions are right. And I mean, I actually do believe we're on the right path now to find that new best practice model for how to codify those powers and protect those rights in this context. But we're not quite there yet, which is why we're all looking forward to the committee doing the rest of the hard work.
Thank you, Professor Brown, and thank you, Chair.
Any other questions? Can I take it then your final point was this is a historic moment, we're on the right pathway, and we should consider all the things that you said, but if we didn't, it's still a historic moment, a big opportunity for Australia.
It's by definition a historic moment.
Thank you. That'll do.
Thank you. Thank you very much, Madam Chair and the committee.
Thank you all for your attendance here today. We appreciate this, and particularly as we did start a bit late. I think you were asked on occasion to provide some additional information, which could you please forward to the Secretary within 5 days from today. You will be sent a copy of the transcript of your evidence, and will have the opportunity to request corrections to transcription errors, which I'd ask that you do promptly as well. I will now suspend the proceedings until 9 a.m. tomorrow morning, whatever day that is. Thanks very much. Thank you.